few housekeeping things. Please keep yourself muted if you're on the platform unless we are calling on you. Know that the entirety of the hearing is being recorded and transcribed, and that there is interpretation for the entirety of the hearing by Ms. O'Grady and her team of interpreters. Ms. O'Grady, if you would, please.
Yes, good morning. This morning our interpreters are Dinora Gutierrez, federally court certified interpreter, and Amelia Cardena as New Mexico court certified interpreter. And Ms. Cardena, if you can please turn on your camera to be sworn in.
Good morning, Ms. Cardena. Do you swear to faithfully interpret between English and Spanish and English in this hearing? Thank you very much. If you are interested, by the way, in anyone offering public comment, please indicate that to Pamela Jones. If you're on the platform through chat, if you're in the room, there's a sign-in sheet at the back of the room. I'll invite public comment at approximately 1 p.m. And if we are still in hearing at 5 p.m., at approximately 5 p.m. But if you want to be sure to get in your comment, please plan to join us at 1 p.m. Let's see, we do have board members on the platform and also here on the dais. I'm sorry?
Yeah, so we, like I said last week, we subsidized, this year we're subsidized.
Wait, oh, okay. Again, please keep yourself muted if you are on the platform and unless we call on you. So, is there anything else? Lots of parties in the action, all of whom entered their appearance yesterday. We won't go through that again. Is there anything we should talk about housekeeping wise before we return to the very end of the department panel questioning? No? All right. Mr. B. Hill, then you are representing the panel, and at the very end of yesterday, Mr. Seidner was trying to respond to a question posed by a board member. And we had technical difficulties, and I'm hoping, Mr. Seidner, that this morning we'll be able to hear your audio and that you are willing to repeat what you said yesterday.
That I am.
Please go ahead.
All right. If I recall correctly, at the very end, I was simply explaining that I had encouraged the department, or rather cautioned them, I believe was the approach I took, that there was a certain level of coordination with industry representatives that would most likely be beneficial, but then beyond a certain point, which no one really knows what that is, we ran the risk of just delaying the process. You know, that we would ask for information, they would give us information via email, in our group calls, many of which I was a part of. There'd be, you know, natural, good faith conversations about information transfer and questions and answers. And then there would often be a follow-up, as with any meeting, where we would request additional information. Well, the simple point is that I feel very strongly that the department went to great lengths to accommodate industry and their feedback, and gave them numerous opportunities to present information, even potentially at the department's demise because of the limitations on their time. And of course, that was simply my opinion, and that is based on a lot of experience over my 25 years. And that concludes my statement.
All right, thank you, Mr. Seidner. I have now forgotten exactly who had finished questioning on the board and who had not. Mr. Hunker, Member Hunker, had you been able to ask a question yet?
I have my opportunity now, but I have no questions. So.
All right, thank you. And Member Bitzer, I think I had called on you yesterday, so Member Garcia.
Thank you, Madam Hearing Officer. I have a couple of questions, sort of piggybacking off of what Member Ely brought up yesterday, which is related to the required approval by EPA of the revision to the SIP. How long did it take EPA to approve the first SIP?
Good morning, Member Garcia. You're referring to New Mexico's first period SIP?
Yes.
I honestly have no idea. Does anybody know? What I can tell you, maybe this might be more relevant, I don't know, is EPA has been very slow in approving second period SIPs. So I don't think anybody has a clue, what happened 10, 15 years ago when the last New Mexico SIP, went through that process. But EPA has been very slow and is far behind in approving states' second period SIPs. And it's, a year would be light speed. Probably 2 years, and in some cases more is probably more the norm. We obviously have no idea if you all were to adopt the SIP and we submit it to EPA, we obviously can't speak as to how long it would take EPA to approve it, but that's kind of the way it's been going. Is there's a backlog, and it's taking EPA a long time to approve or deny SIPs for the second round, depending on what they're doing.
Okay, thank you. Also, if EPA were to have suggested changes or revisions, suppose we approved the SIP and the accompanying rule, and then you submit it to EPA, and they have suggested revisions or changes, would you not have to come back to us for approval of those changes?
It's a good question. I think we talked a little bit yesterday about the process. Like once it leaves New Mexico and goes to EPA, they go through a process where they would review it. And they don't simply pick up the phone and call you and say, hey, there's some problems with this, we'd like you to change it. Once we make it as a formal submittal, it goes through their formal review process. And so if they had concerns about it and they were not going to approve it based on, whatever those concerns were, they would publish a proposed either denial of the SIP, or we've been seeing quite a few partial denials where they approve parts of it, but they disapprove other parts of it. And then that comes with notice, there's a notice and comment opportunity that goes with that. So I think the state's next opportunity to sort of engage would be in comments on, say, a proposed either approval or disapproval. So if they were proposing to disapprove or partially disapprove because they thought it didn't meet requirements in some way, then we would have an opportunity to argue that, basically argue our side of that and explain why we thought that they were incorrect and that they ought to go ahead and improve it. It's possible they would accept whatever arguments we made and then reverse course and say, okay, our final decision is to approve this, right? But if on the other hand, they followed through and they denied it, either in whole or in part, then yeah, I'd have to think about this a little bit, but yeah, most likely it would sort of come back to us, and I don't think it would simply be a matter of us making some changes and then giving it right back to EPA. It would probably have to come back through the board for approval, because it would look different at that point. And, how so? I don't know, because we're just kind of talking about hypothetical. But I think most likely it would have to come back through the board for approval with whatever changes were made before it got sent back up to EPA again for the next go around.
I might just add a little bit to that. So there are some states where, of course, states are in different EPA regions, and we work with our regional office. So we're in Region 6. Some of the other RAP states are in Region 8 and Region 9. But in being a part of the RAP work groups, we have heard other states mention that their regional offices have had certain, I don't know, in some cases, kind of logistical issues with specific parts of their SIP that, and the agreed on solution or resolution to that was for the state to develop like a supplement to the SIP, and then that would be approved through the state process. It also would have to go through, in most cases, the FLM review period again because of the formal FLM review requirements in the rule. But that's one way that I've seen in the past where, you know, there's been changes to a SIP and it's done through, I don't know what exactly it's called, but I believe it's like a supplement to the SIP.
Okay, thank you. So given that, why wouldn't you get EPA approval first before you came to us? Is there a requirement in the CFR to do it this way?
I'm sure there's a requirement somewhere. All I can say is, particularly since there's a state rule involved here, we cannot submit a rule to EPA to incorporate into New Mexico's SIP unless it has been adopted first by the Environmental Improvement Board. So I apologize. I can't give you a citation to some part of the CFR where it lays all this out. But basically, I mean, every state has a similar, if not identical, sort of structure and sort of process as New Mexico. There's obviously differences from state to state, but just about every state has some kind of board or commission that makes the decision at the initial step for the state to say, okay, this is the official state of whatever, you know, submittal plan, rule, whatever. And then once it's gone through the state process and the state's board or commission has approved it, then and only then do they submit it to EPA for approval. So obviously, you know, there has been a lot of communication with EPA on this prior to these proceedings. I think it came up in testimony yesterday that, you know, we've been meeting really throughout the process regularly with EPA Region 6 staff, the folks who you know, are responsible for regional haze at Region 6, having monthly meetings for going back several years, I believe, right? And that provided opportunities to ask them questions, get input on various aspects, you know, of the plan as it was being developed. But once it was sort of done, and there's no more work to be done on it, and we had what we felt was the final proposal, then it was time to bring it to you all. And at that point, you all have to approve it before, or I think adopt is the proper term, adopt it before we submit it to EPA for approval.
Okay, so let's say if we were to adopt and a lot of the requirements, I guess the main requirements under section, is it 102, and the deadlines and timeframes, et cetera, are dependent on the clock starts after EPA approval. So considering the current state of affairs of the federal government, it's possible that EPA doesn't do anything, that you get crickets out of EPA. So then the majority of the rule, even though it's technically enforceable once it goes into the New Mexico register, right? The majority of the rule is not effective until that time period. Is that a correct reading?
It's possible. I apologize. I'd have to think about this a little bit. I mean, it's possible that the state might, if you all were to adopt the SIP and rule, and then we ship it off to EPA, and they sit on it and basically never act on it, or, you know, whatever, or take forever to act on it. It's possible that in the interim, the state could enforce on that. Like I said, I'd have to probably do a little research to give you a more definitive answer on that. You've kind of caught on to, you know, one of the sort of problems that we faced when we were thinking about the compliance deadlines, right? was, like I was describing, it's taking EPA a long time, and we knew that that was the case. And we knew it was quite likely, you never know, but we probably very likely that even without what's been going on of late, that it would have taken EPA a good long while to get around to acting on the SIP, right? And so we had concerns, and there's just sort of some logistical challenges in trying to establish deadlines that don't account for that, for that fact. The facilities are going to say, and they're probably correct in this, that until EPA approves it, it's not the plan, right? Maybe this answers the question that I was kind of fumbling about, what would happen in the interim as far as, state enforcement goes. They're not subject to the requirements in the SIP until EPA has approved it, right? And so, going back to that question, it's like, well, we don't know how long this is going to take. We don't really know what's happening. So if you establish compliance deadlines that are not conditioned in some way or contingent in some way on that EPA approval step, then you run the risk of it sitting at EPA and it's taking longer and longer. And suddenly the deadline for compliance is coming up. And they could be put in the position of having to really start moving on, investing in and installing controls, still not knowing yet at the end of the day whether EPA is going to approve it. And those are going to be the actual requirements that they're subject to. So that's why the deadlines are contingent on EPA approval. As worrying, I guess, as that might be, just kind of given, what's been going on and what's likely to be going on for a while.
Okay, one more related question. Are there other parts of the rule? I mean, just looking at it, I couldn't see that, but are there other parts of the rule that would take effect upon being in the New Mexico Register? Other parts of the rule that are not contingent on EPA approval that would take effect, that are enforceable?
Right. The most significant parts of the rule in terms of, the impact on facilities, sections 102, well, pretty much just section 102, really, because it covers both units that would receive limits that are based on them installing a new control, but then also limits that are based on, in a few cases, controls that are already in place and operating, right? So there's limits for units that would have to install new controls to meet them, but then also limits for some units that are already operating controls, right? And those have a compliance deadline too. I think I talked about that a little bit yesterday in my direct testimony. It's, basically as soon as EPA approves it, new limit applies, right? Because the controls are already there. They don't need the extra time to actually install controls once that, that approval happens. Everything else, the rest of it is, I think, in the other measures section, and that just pertains to the retired units. So, that restriction on reauthorizing retired units wouldn't come into effect. So I suppose you could argue there'd be a window of opportunity there. But, how likely of a scenario that is hard to say. A number of those retired units literally no longer exist, right? San Juan Generating Station, for example, there's a couple of units at San Juan Generating Station that have been retired in the last few years. And so they're included in that, that section 103 requirement that they cannot be authorized. But if you've been following the news, San Juan Generating Station is in the process of being dismantled. They're not going to be coming back and saying, "Hey, we'd like to reauthorize, those units." So that's pretty much it. The only other thing is this. I've talked about this as well in my direct yesterday. A couple of units or these amine treatment systems that have acid gas injection wells. Amine, A-M-I-N-E. I apologize. A few facilities that have what we consider to be the best available control for their amine treatment systems. So as a means of ensuring that they continue to operate those controls and can't change without further analysis, basically, we would be incorporating certain permit conditions that pertain to the operation of those controls into the SIP. So that's not in the rule. It's really kind of separate and in the SIP. But EPA would be incorporating those permit conditions into the state SIP. But that incorporation would not happen again until EPA approves the SIP. So really nothing really happens or is ultimately required until that decision is made at the federal level.
Right. Okay. Thank you.
Okay, thank you. Vice Chair Trujillo.
Yes, thank you. Just to follow up on some of Member Garcia's questions. I believe one of the things Mr. B. Hill mentioned during his opening statement was that a failure to pass the SIP could result in EPA instituting their own SIP. Is that correct?
I don't want to dominate the conversation, so anybody else feel free to jump in. Yes, EPA can at any time, given the amount of time that has passed since our SIP was due, adopt a federal plan. So it wouldn't be a SIP, it would be a FIP, federal implementation plan. And if the EPA has a certain amount of time after SIPs are submitted to them to either approve to act on them, approve or disapprove, whatever they want to do. They often miss that deadline, as you all are probably aware. What typically happens is they get sued for failing to fulfill a non-discretionary duty, because the duty to act on state SIP submissions is, it's written right into federal regulations. They have a certain window of time. And if they fail to meet that, which again, they often do, they can be sued for failing to perform or fulfill a non-discretionary duty. And so that actually happened in the case of Regional Haze. A lot of states submitted their SIPs late. The amount of time that EPA had to act passed, or some states, I think there's about a 2-year window, if I remember correctly, where states, could have come in and submitted their plans. But EPA issued a formal finding of failure to submit. So in the case of New Mexico, and I think there were 15 states, if I remember right, that were part of that. EPA said, okay, we are officially determining that you all have failed to meet this duty of the act, which is to submit a SIP by July 31st, 2021, right? Once they did that, that started a 2-year clock where any time within that 2-year period, EPA could issue a FIP or approve a SIP submitted by the state, right? So that clock started in August or September of 2022. And we're obviously now beyond 2 years. And New Mexico has still not submitted its SIP. I hope we're getting close, but we still haven't submitted our SIP. And EPA obviously hasn't implemented or proposed a FIP yet either, right? So they're kind of back in the situation where at any time, they could get sued again for failing to perform a different non-discretionary duty, which is to either approve a state SIP or implement a FIP, right? So that's kind of where, it's a long rambling answer, but that's kind of where we are.
Okay, so if they decided to implement their own SIP, how long would that process take for us to receive something back from the EPA?
Right.
It sounds like it's taking a while.
Yeah, we talked about this a little bit yesterday. It's really impossible to predict. If EPA decides tomorrow, you know what, it's time to move on, and it's time, New Mexico is not going to get it done. It's time for us to step in and do something ourselves. We need to develop a FIP. I will say this, EPA doesn't want to implement a FIP for New Mexico or any other state. It's a lot of work to come up with these plans, obviously, and they have their own resource constraints and things like that. So they much prefer states, even if they're late, to do it themselves and submit something that they can hopefully then approve. But if they, depending on how things go here, or because of what's happening in Washington, or for any other reason, they decide at some point, okay, it's time to move on, and we need to come up with a FIP for New Mexico. The timeline for that, like I talked about yesterday, is anybody's guess. It really boils down to how long is it going to take them to prepare a plan. I think realistically, in a normal world, a year to 2 years at the minimum to actually develop from. I don't know if they'd be starting from scratch. There's some question as to they obviously have seen what we have, so they could potentially take what we've got and use that as a starting point. Say, okay, let's make some changes to this, and then kind of make that our own. But if they kind of go back to the drawing board and start from square one, it's a long process. It doesn't happen overnight.
Okay.
And then once they develop it, then they have to go through the proposal, comment, finalization process. That takes time as well. So none of it happens quickly, but unfortunately, I can't tell you how long that might be if it does come to that. Obviously, we hope that it doesn't.
Okay, and I'm going to pivot a little bit of my questions. I just wanted to follow up on Member Garcia's some things that popped into my head there. So I remember from yesterday, you all had some comparisons with other states. And I was curious if you had used Texas as a comparison when you were putting together the SIP. I didn't remember hearing Texas mentioned.
Are you referring to in any specific way, or
yes?
or did we just
I'm
look
sorry.
at Texas?
I'll be very specific. There was some discussion about the particulars in, especially around SLIP. And so I was curious when you were looking at other states, if you had used Texas as one of those to compare with the New Mexico plan.
Yeah. There's, obviously there's a lot of states out there. And so when we were looking at other states for comparison purposes, we focused first on our neighbors, so Texas, Colorado, Arizona, the states that are right next to us, because in some ways their situation is going to be closer to ours than, a state in the upper Midwest, let's say, or the East Coast, right? So we always looked at neighboring states, including Texas, but then also beyond that, more so just towards Western states. Because again, East Coast, the Northeast, it's such a different, world out there, if you will, that, they're not necessarily the most useful ones to look at. But yes, we did. The short answer to your question is yes. At multiple times when we were wanting to see, what did another state do on this or that or the other, Texas was pretty much always within the mix of states that we looked at.
Okay, so to quote one of my favorite NMED employees, we're going to pull on that string a little bit. So the reason I'm asking about Texas is that with the other parties in this particular case, is that, we're looking at the Permian essentially. So as you were looking at comparing neighboring states, operations in the Permian, Texas versus operations in the Permian, New Mexico, was that looked at specifically when putting together the SIP?
So I'm trying to process the question. Did we look at it specifically through the lens of what's happening in the Permian? Would that be a fair way of putting it?
Well, some of the issues that were brought up yesterday were operational issues and technical issues about the facilities that are, within the Permian Basin. And I mean, essentially the operations are the same, just separated by the state line. So as you look at Texas, and I should back up. I'm assuming Texas has an approved SIP.
No, not for the second period. EPA has not made any final decision on Texas's. In fact, EPA, believe it or not, EPA just in the fairly recent past did, I think, their final action on Texas's first period SIP.
Okay. So, but it's kind of still the same principle as, Carlsbad Caverns is on the state line. So was the area at least evaluated as a whole from an operational standpoint?
So I'm going to give you one answer to that question. I'm going to ask maybe Mr. Jones to provide a little more context on the second part. If memory serves, and I'm going by memory here, we found Texas's SIP to not be a particularly useful or helpful example. Not quite sure what the right word for it is, because their approach was quite different from most states. Again, if I remember correctly, they basically evaluated broader source categories in a generic way. So they didn't drill down to the facility level and say, okay, contact facilities and tell us what it's going to cost to do, determine what's going to be feasible on units that you've got at this facility, that facility, and then to determine what might be cost effective, et cetera, et cetera. They basically did their own analysis where they said, okay, we're going to look at, I don't know that this was one of them necessarily, but I'm using an example because it's something that's obviously a big part of our stuff, right? So compressor stations, let's say, they kind of did a generic evaluation of compressor stations in general, right? Without going in and looking at any specific one, and made, kind of like generic determinations about what kind of controls might be feasible, came up with their own estimates, again, I don't want to say with no facility input, because it's been a while since I've looked at it, but certainly limited, if not no facility input. They just kind of said, well, we've got some numbers from somewhere, and so we're just going to use those for all of these facilities, right? So that makes them, it's a very different beast, I think, than ours, right? Where we identified facilities and then went to each facility and said, we want, for your specific facility, an analysis of what's feasible, what it would cost to install anything that might be feasible, et cetera. And obviously, we didn't always agree with what they submitted. And so in some cases, we substituted information from other sources. But it's just, that was a key difference between how Texas approached their SIP and how we approached ours, that kind of made theirs not a particularly great point for comparison, right? Most other states, certainly all the other states that we looked at, close-in states, took the approach much more like New Mexico's, where it was all the analyses were very source specific and not more sort of, I hesitate to call them generic, but generic kind of like category analyses. So that's that. And then Mark, do you want to address the?
Yeah, maybe just at a little bit of a higher level. So we work with the Regional Planning Organization, RAP, which prepared a baseline and future year emission inventories based on information from the national database, so the National Emissions Inventory, but also RAP states contributed to helping to make sure that those inventories were the best, according to their state information. Of course, Texas isn't part of the RAP, but the Western Regional Air Partnership developed or did use information from EPA on emissions from like oil and gas and other sources on the Permian on the Texas side. So those emission inventory inputs went into the modeling platforms that were used by RAP, which we used in our plan. So there's not a total disconnect, even though Texas is outside of the RAP. And a good example is in the Salt Creek Wilderness Area Analysis. In section 10.3 of the SIP, it goes into that robust demonstration, and it shows an area of influence that covers the Permian Basin. And that area of influence shows the areas, or geographically, the most likely where the most impacts are coming from on the most impaired days. And so that helps to give some perspective on the impacts from Texas as well as New Mexico in the greater Permian Basin. And then there's also source apportionment modeling that was done, which has a breakdown of contributions by source type from the RAP states. Now, since Texas isn't part of the RAP, the modeling didn't delineate Texas as a state. It just had a category for non-RAP states. So the apportionment was to non-RAP states, but that shows some of the significant impacts that, we believe are coming from Texas as well as New Mexico and the Permian. And in this case, specifically impacting Salt Creek Wilderness Area.
Okay, I think I have some more questions, but I'm gonna hold for now. Thank you.
Any other board questions, Member Honker?
Yes, I'd like to go back to the compliance deadline issue, which I think I basically understand. But for instance, I'm looking at table 1 of the proposed revised rule. And some of these facilities have a 0 year, which I assume goes from the date EPA approves the SIP. And so my question is, if we were to approve the SIP and the revised rule in some form or fashion, you send it off to EPA. EPA pops out an approval. I mean, I used to work for them. Surprising things happen sometimes. So now, does 0 years mean on the date of EPA approval, the facility has to be in compliance? Or how will that work?
Member Hawker, thank you. You are correct. I will note that the only facilities that have, or the only units, I should say, in that table that have a compliance deadline of 0 years are units that already have controls in place, right? So these are, and they already are, or certainly should be complying with those limits, right? But it's just, that's not the limit that they're sort of legally beholden to at this point. They have some other limit in their permit, right? So yes, if, assuming in your example that EPA magically acts on it and approves the SIP, then they would publish a final rule in the Federal Register. There would be an effective date of that final rule, and that would be the date on which all of the that the limits and all the other requirements in that rule would apply, right? And so on that day, if it's a facility that already has controls in place and has a compliance deadline of 0 years, that's when that new limit would kick in. For all the other units in that table, which is the vast majority of them, where they're going to need to install new controls to meet those new limits, they have 2 years, 3 years, depending on the unit and the likely controls to come into compliance and meet those limits. So that date of approval, the effective date of the final Federal Register rule, that would start the clock ticking for 2 years or 3 years. And after those 2 to 3 years is when the limits for those units would become effective.
Thank you. That's helpful. That's all I have.
Okay. Other board member questions? Member Garcia.
One more quick question. I understand this covers the Title V programs or the Title V facilities. Of the facilities that would come under this rule, and I know you did a lot of outreach for a long time with all the facilities about how this rule works. Could you give me an idea of the percentage of facilities that have come into agreement with some of these requirements? Is there a ballpark percentage? I know there's some here today that definitely are not in agreement. But could you give me an idea of the percentage of the Title V programs that would come under this rule that might be in agreement?
Thank you, Member Garcia. Could you clarify for me what you mean by come into agreement or agree with?
I guess I should put it another way, are not opposed to the rule because they are already in compliance or close to compliance, or they plan to be in compliance with it.
Well, one thing I want to be very careful about is assuming that there's a decent number of companies that own a fair number of facilities that will be impacted by this rule if you all adopt it and EPA approves it, who are not part of these proceedings, right? They're not opposing it, but I don't know if that means that they support it, or it obviously means they weren't they weren't so opposed to what they saw that they wanted to become a party and provide testimony and all the rest, right? But I still want to be careful about making any assumptions about what their posture is in relation to the rule, simply for the fact that they're not part of these proceedings. So some numbers, I'll give you two different maybe sets of numbers, and I'm not 100% sure which is the right set of numbers that you might be looking for, but I think one of them will be. There are, within the board's jurisdiction, there are 23 facilities that we looked at, and not all of those facilities have new requirements. There are facilities that, for any number of reasons, given the way the analysis shook out, we determined, okay, there's no new control requirements that we would impose on this facility. Usually because there's nothing that was cost effective, right? So there are 3 companies, Targa, EP&G, and Enterprise, that are part of this proceeding that do actively oppose the rule, and they've said that very clearly in their filings. And those 3 facilities, or excuse me, those 3 companies, they own 9 of the 23 facilities that we evaluated. So not quite half, but it's close to half. And it's probably, so it's a little bit less than 50%. In terms of the number of facilities that actually have requirements, I think it's 16. Does that sound right? I think the number of facilities that actually have requirements is somewhere around 16. I might be off on that a little bit, but if that's the case, these companies own 9 of them, so that's a little bit more than half of the facilities that are actually impacted by the rule. I think your question may be a little bit broader, though. What percentage of Title V facilities do these 23 that we looked at represent, right? And Mark, correct me if I'm wrong, you're our source screening expert. At the time that analysis was performed, I believe there were 134. That's correct. Okay, 134 Title V facilities. So 23 of that 134 met the sort of the screening criteria that we had developed, where the Q over D that Mark talked about yesterday, Mr. Jones, excuse me, talked about yesterday, and got sort of pulled into the regional Haze program, and then had to go forward with analyses on certain equipment. So 23 out of 134 is a little bit less than 20%.
Okay, that's helpful. Thank you.
Other board member questions? Member Ely?
Yeah, thank you, Madam Hearing Officer. I think it was Mr. Peters yesterday that said that EPA allows for just pretty much any control strategy as long as it's not expressly prohibited. I'm just wondering if there's anything in EPA or RAP guidance or EPA rule regarding replacement as a control strategy.
I'm not sure if there's anything in RAP guidance about replacement. I was speaking in general that if something is not prohibited, then it's allowed. Or in respect to anything, not just regional Haze.
Mr. Jones, do you know if there's anything regarding replacement in the RAP guidance?
So the RAP guidance doesn't specifically address that, but it doesn't exclude that. And, that's the same with EPA guidance. We did reach out to our regional office several times on this question, and the feedback that we received back from our regional office was that they concurred that replacement of engines was a control strategy that was okay or allowable for the second implementation period.
Thank you.
Member
And
Ely?
yes,
I
please.
apologize.
No, go
Sorry,
ahead.
just to add a little bit more to this. The exact language in the rule, the regional haze rule, is that the state must evaluate and determine the emission reduction measures that are necessary for regional progress. So, there's some contention. I'm sure there will be more contention before the hearing is over about controls and the installation of controls, and states being limited to what are traditionally thought of as controls that are retrofit onto existing equipment. But the language in the rule is arguably much broader. Emission reduction measures, that can potentially encompass a lot of things: changes in operations, replacement of equipment, installing controls certainly, would kind of fall within that bucket, right? But that, I think, was one of the points that the EPA regional folks made. They pointed to the language in the rule and said, that's pretty broad language. And then just kind of going back to the overarching concept that came up several times yesterday about the rule giving states a huge amount of discretion in all kinds of different ways in regional haze. That, in some ways, that's a good thing. In some ways, it's kind of a curse. There are times when it would be nice if the rule was a little more clear and specific about what it wanted states to do. But we have the rule that we have. It is what it is, right? So the way the rule is written would certainly suggest that things beyond simply bolt-on controls, would kind of fall within, the purview of states to require. And there is the 2019 EPA guidance, I believe, does have a section where 2019 EPA guidance does have a section that provides examples of control measures that states can consider. I don't think anybody would read that as an all-inclusive list. It's examples, right? And not all of those. I'd have to pull it up to refresh my memory of everything that's on it. But not everything on that list is a traditional retrofit add-on control. There are other types of measures, on that list as well.
Yeah, it makes sense to me. It seems like many of these engines are 50, 70 years old, and it may be more cost efficient to replace them rather than to try to weld on controls. But do any of the other states that have been approved for their second SIPs, do they use replacement as a mechanism to establish emission caps for those particular types of engines?
Thanks again for the question, Member Ely. Once again, I apologize. I'm going to go off memory here. So, and keep in mind that there's not a huge number of state SIPs that have been approved. I am not familiar with, or I don't recall any SIPs that have been approved that require replacement of any units that were evaluated. I do believe, again, based on my memory, that some other states, certainly not all of them, but there were other states that evaluated replacement, but they ruled it out for one reason or another, not cost effective, or I don't remember all the details, but I can say fairly confidently we're not the only state that looked at replacement, that evaluated replacement. But again, I don't think any state SIP has been approved at this point that actually required replacement. And one final point, just to, this came up several times, I think yesterday, and it is an important point to always remember. Technically, nobody's being required to replace anything. The rule sets an emission limit based on what would be achieved if a new engine, were brought in. But there are other ways, there are other controls. We believe that in many cases, maybe not all cases, but in many cases where replacement is required, would allow the facility to meet that same emission limit. And so there are potentially other ways that facilities could comply with limits beyond or besides replacing, the equipment. Member Ely?
Yeah.
So my recollection is also that there are states that did include that in their 4-factor analysis. of feasible control measures that were, then underwent that evaluation. Since Bob Seidner is on the line, I know, Bob, that you had done some, ERG had done some pilot studies before launching into the full four-factor analysis for all of our facilities. Do you recall, or do you have anything to add to this question from Member Ely?
Just two items. One, I wish I could pull from memory exactly which states and to what extent. Unfortunately, that is not something I can do readily. If the board would like more information in this regard, I'm pretty sure we could do a little bit of research. And the second point is the fact that it is my recollection that when we submitted documentation to EPA for their review, there were no comments from EPA pushing back on our evaluation and the incorporation of replacement in our four-factor analysis. But my colleagues here could speak to whether or not that is true.
That's my recollection as well, Bob.
Thank you. No further questions for me.
All right, other board member questions for the department panel? No? All right, any reason not to excuse the department panel?
Madam Hearing Officer,
Yes.
in response to this is Allison Wood at the back of the room. In response to Member Garcia's question about the length of time that it takes that EPA has once it receives a SIP before it has to either approve or disapprove it. I know the answer to that along with the citation. And if it would be helpful to the board and if NMED does not object, I'm happy to provide that.
All right, I think while we're on the topic, it would be helpful. So please go ahead.
All right, so the answer, Member Garcia, is that it's 18 months that EPA has from when it receives the SIP. It has first 6 months to determine whether the SIP submission is complete or not. If it doesn't act within those 6 months, it's automatically deemed complete. And then from once a SIP is deemed complete, EPA has 1 year, 12 months to either approve or disapprove it. So if EPA received the SIP and did nothing, after 18 months, it would have missed its deadline. And as Mr. Miller noted, the agency often does miss those deadlines. It can then be sued for missing a deadline at that time. And the citation for that is Clean Air Act Section 110K, which can be found at 42 USC 7410K.
Thank you very much, Ms. Wood. Anything else from the board? No? Mr. Behill, did you have something? Oh, redirect. Okay, please go ahead.
Thank you, Madam Hearing Officer, Madam Chair, members of the board, Madam Vice Chair, members of the board. I just have just a couple clarification questions for the benefit of the board. And we had some information come in similar to what we just heard. And I'd like to ask Mr. Peters, could you tell us a little bit of the history of the approval of the first period SIP?
Yes, I've been presented with some research that indicates that the first round, round one, Regional Haze first planning period, EPA issued the plan August 22, 2011. EPA approved NMED settlement agreement February 2013, and it was approved by the board in 2013.
Thank you very much. These next two more questions, and I'm going to ask the witnesses, whoever answers the question. The spirit of the question is kind of to give the board some inside baseball insight into the decision-making processes internally. And just while my mind's on it, the first one is, now, when it came to determining whether or not replacement was appropriate, how was that approached in terms of the information that you needed? Did you seek advice on whether or not internally, and how did that happen? I don't know if I'm making sense to you, but I'm talking about just the internal team behind the scenes. What went into this decision making to decide that a replacement was appropriate?
So I believe the short answer to that is, you know, and Bob Seidner may speak to this as well, but the short answer is that we did a thorough look, the beginning of the 4-factor analysis, after we selected the facilities and the sources, 133 sources. We did a in-depth review of control technologies that were feasible that could reduce the emissions of NOx or SO2, in this case, NOx. And then those control measures were then moved on to the next steps of the 4-factor analysis.
Okay, great. I guess I probably should have asked this more directly. Can you tell the board how you determined that it was legal?
I'm not a lawyer and can't provide
No, I'm not asking.
a legal answer.
Yes.
Yeah.
And because you're not a lawyer, how did you determine that this was legal?
Well, two ways, primarily by asking our lawyers the question.
Yes, yes.
You know, there's been pushback on this. Is this allowable under the Regional Haze Program? Obviously, as we've talked about, also talking to EPA about it, but that's different. We were talking to technical people. So, you know, they have the same issue or limitation that we do. They're not lawyers, and so they can't really provide legal advice. So it's really grounded in what our attorneys told us.
Yeah, that's what I mean by inside baseball. Now, getting away from the legal, but still inside baseball. Just as, you know, this give a glimpse of the decision making process of the team. And I know that some of it was captured in the testimony, but I don't think that maybe it was as full. And it doesn't have to be a very long answer, but could you talk a little bit about why the rule was adopted? You know, the rule was adopted for a very specific reason. And could you explain what that was and what the difficulties were, particularly with regard to the question of federal enforceability?
Just to make sure I understand, you're referring to the proposed rule 20.2.60, not the regional haze rule and why it was adopted.
Yes, that's right. I apologize. Yes.
Okay. And I'm sorry, could you just restate the question real quick?
So the proposed rule, can you speak to why that route was chosen, particularly with the question of federal enforceability? And this is, I think you understand what I'm saying in terms of inside baseball. What was the decision-making process that the team went through in order to determine why that was necessary?
Right. Thank you. So this was something we had a lot of discussions with EPA about. Because again, at the end of the day, you want to submit a SIP to EPA that they will be able to approve. There's no point in doing all of this work and going through the process of a hearing and wasting everybody's time if you know that once you hand it off to EPA, they're going to say, no, that doesn't meet our requirements, right? And this was a very important issue to them. It's an issue that they brought up, I think, repeatedly. And so we had a lot of discussion about the different ways or mechanisms by which states can make provisions in their SIPs or their long-term strategies federally enforceable so that EPA can in fact approve their SIPs. And think this was covered maybe to some limited degree in my direct testimony, and I'm sure it's discussed in the SIP as well, to some extent. But there's basically three options, and they all have their pros and cons, their pluses and their minuses. So we looked at the three different options, and I'm happy to talk about specifically what they are if that's what you need or you'd like. But there were issues or pitfalls, maybe for lack of a better word, with two of the three options that were not promulgating a state rule. Promulgating a state rule was in some respects the sort of cleanest. I don't want to say it's the easiest way, but it's kind of the cleanest and maybe in some respects the easier way, particularly when you're dealing with so many facilities and so many units. The alternatives, the complications really get compounded given the number of companies, facilities, units that have requirements under regional haze. And so, again, given that sort of background, doing it via a rule was really, I don't know if it was the only way to do it, but it was far and away the best way to do it in the department's view, based on what I've just described in a lot of conversations with EPA. And
you may get some extra cross on this, so I just want to clarify. Could you briefly describe the two other options to achieve federal enforceability that you didn't choose in favor of the proposed rule?
Yeah, certainly. So the other two options, one is to incorporate the requirements, in this case it would be new emission limits, new compliance deadlines, into facilities permits, right? The issue there is our permitting language talks about the fact that the department can impose conditions to meet requirements of SIPs that have been federally approved. So you kind of have this, I think I described it maybe in my direct as a chicken and egg problem. It's like, we can't put conditions relating to this into facilities permits until EPA has approved the SIP. But EPA told us, we want to approve your SIP unless you've already modified the permits and all that stuff is already in place. So that's kind of an irreconcilable problem. So that kind of eliminated that possibility. The second possibility, and other states did do this, but again, it was more viable, I think, for some other states, given the number of facilities maybe they were dealing with, or the nature of the controls. But the other option is to enter into actual agreements ahead of time with the facilities, where contingent on approval of the SIP, they basically volunteer that they will agree to meet their new limits by whatever their deadline might be. But here again, I don't remember the exact numbers, but if you look at the facilities that are subject to requirements, it's somewhere in the neighborhood of 10. I apologize, I don't have the numbers right off the top of my head, but multiple companies, a lot of different facilities. And so if you can imagine having to hammer out and negotiate agreements like that related to this large number of facilities owned by quite a few different companies, and ask them to do it on a voluntary basis before they've had a chance to come before you all and argue why plans shouldn't be adopted or ways it should be changed first, etc. It was going to be an enormous resource. It would take an enormous amount of resources, and there's no guarantee that it would work, because if we decide, well, that's the approach we're going to take, and you've got a holdout or a couple of holdouts, then where does that leave you? Having agreement with 3/4 of the companies would be great, but you still got a quarter of the companies that you don't, and so then you're kind of stuck. So the rule approach, it avoids those problems with both of those alternatives, where we put all the requirements into a rule, and if the board adopts that rule, then we're good. The new emission limits and things will ultimately end up in facilities permits, But if it's in the rule now, that creates the federal enforceability kind of at an earlier stage before all that happens. And that goes back to what I was saying, where we have to wait until the plan is approved before we can start doing those permit modifications.
I have no further questions. Thank you.
All right, thank you, Mr. Behill. Did that set of exchanges raise any additional questions in the board members' minds? No? No? All right, any reason not to excuse the department panel at this time? No? Thank you very much, Mr. Sanchez, Mr. Miller, Mr. Jones, Mr. Peters. Let's take a 15-minute break and come back at, this would be 10:22. Thank you, Pam. So when we broke, we had completed the testimony of the department's panel. We move now to El Paso Natural Gas. Ana Gutierrez is counsel. You have several witnesses. Oh, and Mr. Miller, if you would please, counsel, let us. You're certainly open to making an opening statement. Please try to keep that to 20 minutes if you choose to do that. And if you would let us know the order in which your witnesses will be presenting.
Of course, thank you, hearing officer. Ana Gutierrez with Womble Bond Dickinson. So I do plan, and just want to talk logistics for a minute, to do a brief opening statement, and then we'll proceed. We have 4 witnesses that will proceed, and they will go in the order of Ms. Wewin Daly, Mr. Francisco Tarin, Mr. Tom Mitchell, and Mr. James Trent. I also was hoping the way we're going to aim to do this is have one witness up at a time, and we'll do their full direct and full rebuttal, and then make them available for cross and board questions before we move on to the next, just to be as efficient as possible, if that works.
Whichever you prefer.
Right. And then if the board is amenable as well, we have a brief closing statement as well.
We're going to talk about closing statements after we finish the entire evidentiary record. So please hold off on that.
Okay. And clarification question, do you think we will have them? Because if we will not have them, I might have some thoughts in opening.
So if I can't tell, I can't anticipate whether the board is going to want to deliberate immediately following the close of the evidentiary record or not. If they choose to do that, we can certainly invite oral closing statements.
Okay.
If they choose not to do that, we're going to ask counsel to put their closing statements in writing.
Perfect. And I'm sorry, one more clarification question. Would it be one or the other, or perhaps, okay.
Yeah, it would be one or the other.
Okay, understood. And I also am going to mix things up on us and present some slides. Technology is not my forte, so let's see if I can do this. Okay, are we just seeing the slide deck?
Maybe that.
May I request that the big screen on the TVBR deck by chance?
Yes, I'm sure they'll pin it for you. There it is.
Very appreciative. Good morning, board members, hearing officer Orth. It's good to see everybody again. Hope we're all well rested this morning. As I mentioned, we can't click. My name is Ana Gutierrez with Womble Bond Dickinson, and I represent El Paso Natural Gas Company in this proceeding. EPNG is a subsidiary of Kinder Morgan. This rule is about regional haze. Haze results from certain air pollutants, and for purposes of this rule, we're talking about SO2 and in lesser degrees, NOx. Those molecules interact with sunlight and other constituents and cause what we refer to as visibility impairment. Regional haze is then measured by, and our obligation to act is determined by evaluating those levels of visibility impairment for our Class 1 areas. So think your national parks or your wilderness areas. What's really exciting is that even before this rulemaking, so without considering any of the reductions that might be achieved by the proposed rule, nearly every single Class 1 area in the state of New Mexico, it's on track to achieve natural visibility conditions. This is what we call a uniform rate of progress, and we are starting from a place of success. And for EPNG, the Blanco A and Pecos River facilities, which we'll talk more about in detail today, they are not closest to the Salt Creek Wilderness, which is the Class 1 area of concern. This is all just really important context to this rulemaking because it informs us that we can and we should be more surgical about application of the final rule. And Kinder Morgan is a committed partner in developing that rule. As many of you will remember, Kinder Morgan actively participated in the Part 50 ozone rulemaking, and we worked cooperatively with the department's council, other stakeholders, and we helped assist in development of what we now know as the alternative compliance plan options and the alternative emission standards options under the Part 50 ozone rule. We even brought a joint proposal with the environmental groups to address how we do leak detection and repair at transmission compressor stations. Under the Part 50 ozone rule, Kinder Morgan is in the process of reducing approximately 1,200 tons of NOx per year in New Mexico. That's impressive. Unfortunately, in this regional haze rulemaking, the department did not consider those forward-looking emission reductions, such as those from Part 50, whether from Kinder Morgan facilities and most others. What that means is that regional haze success story I just told you about, where we are on a path towards visibility improvements already, that may well be underestimated. So turning to the proposed rule before you, and I know we have a SIP and a rule, but for ease of words, I'm just going to call it the proposed rule. At the end of these proceedings, these three things must be true. Any final rule must be lawful. A final rule must be cost effective, and a final rule must be feasible. This is the board's duty. Unfortunately, several of the department's proposals as they relate to EPNG are either unlawful, they're not cost effective, they're infeasible, or all of the above. Our witnesses will present EPNG's most pressing concerns, and I'll highlight a few of those here in our opening statement. But the bottom line is, if the board adopts the department's proposals for EPNG's Pecos River and Blancos A facilities as is, as proposed, the rule would be arbitrary and capricious, and it will face significant exposure in subsequent litigation. You're going to see a version of this slide again in the hearing. This is just a quick cheat sheet, and it summarizes EPNG's positions on the department's proposals. I'll let you digest this on your own, and of course I'll submit this to the record so that you may have it before you. But what the department needs to know, what the board needs to know is that the department proposes to regulate 3 EPNG facilities under this regional haze program. The first is Washington Ranch. EPNG does not oppose the department's proposals with respect to Washington Ranch. Our witnesses will discuss, though, that we do think it's best practice to correct the calculation errors on the record in support of that proposal. For Pecos River, the department proposes 2 units at Pecos River achieve a 3.38 pound per hour and 7.28 pound per hour. And thank you to Mr. Miller for correcting my NOx emission limit. This is now corrected on the record. And the only way to get there, I want this to be very clear because we do lack flexibility here. The only way to get there is application of a bolt-on or aftermarket technology called selective catalytic reduction, or SCR. And in applying SCR, the department demands an 80% NOx removal efficiency. There are 2 core problems with this proposal and one important practical consideration. The first fatal flaw is that the proposal is not cost effective, and it's not even close. What's really interesting, and this is important for the board to understand, is Pecos River qualified for an alternative emissions limit under your Part 50 rule, ozone rule, just in 2023, so less than 2 years ago. And that decision was made because the department deemed SCR too costly for precisely units A2 and A3 that are the subject of this rulemaking. Oddly, the department has made an about face in this rulemaking, and it is unsupported. By contrast, EPNG has submitted site-specific vendor quotes and costs in this rulemaking. EPA recommends we use vendor quotes. The department has declined to accept or review or consider our vendor quotes to date. And those are the same type and style, scope, same level of redaction, which is to secure confidentiality of who we're speaking with at the vendor. We submitted those exact same quotes in the Part 50 rule, as well as the AES, both of which were acceptable to the department as well as the board. Second, while SCR at 80% removal rate might be achievable, consistently hitting 80% is unproven in the natural gas transmission sector, and you'll hear more from our witnesses on that topic. Last, you'll hear testimony that regardless of these first two fatal flaws, the department has failed to demonstrate that the requested reductions for Pecos River would in fact achieve any beneficial visibility impacts. Last is Blanco A, and you're going to hear a lot about Blanco A today. There's a threshold legal question that this board and this board's council must grapple with. The proposed rule would impose emission rates limits on 2 units at the Blanco A. This is a half gram for 0.5 grams per horsepower hour. And those emission rates can only be achieved by removing 2 existing units, making them go away, and putting brand new state-of-the-art units in their place, 1 or more. There's been some testimony that there are other technically feasible options. LEC was considered for Blanco A and deemed by the department to be not cost effective. So that is not on the table. That means replacement is the only option. EPNG filed non-technical testimony that discusses this legal issue at length, and I'm going to refer you to that filing. But the takeaway is that the Federal Regional Haze Program only authorizes installation of controls on an existing unit, so not outright replacement of a unit. In all of the guidance from EPA, pages and pages of guidance, they provide lists and descriptions of quote unquote control measures. And this links back to what we heard earlier, is that EPA directs states to identify those measures to reduce emissions for purposes of regional haze. EPA has put extensive guidance out there and deemed these to be control measures. All of those lists, in none of them, not once, reference replacement of a unit. The only reference to replacement would be replacement to an existing control device. So replacing that control with a new control. I think this is really important that when you look at these lists, taking the big, massive leap to these types of controls and going to replacement is unlawful and it is unsupported. For this reason alone, the board cannot legally adopt the proposed emission rate limits for Blanco A. But there's a host of other reasons for Blanco A that its proposal is unsupported, including that it's preempted by FERC regulation. It is not even technically feasible to do the requested replacement. And even if it were feasible, it's not cost effective. The issues truly compound and we are not on stable ground. Now, on the point of FERC regulation, the department's counsel suggests that FERC preemption case law doesn't apply here. That analysis is incomplete and the conclusions are misleading. We'll respond in our post-hearing briefing, should we have some, but this is a question of law. I want to be very clear. This is a question of law that is not a close call. And FERC's position on this issue is very clear. So I encourage this board and this board's counsel to carefully consider the legal issues before it relating to Blanco A. Last, I offer a quick summary of the process to date. Again, I won't read this slide in great detail, but the key points are, we talk a lot about these sort of imminent compliance dates, but I don't want us to lose sight of the fact that this SIP was due to EPA in 2021. Right, so those imminent urgent deadlines are not as a result of industry's participation in the process. The department did not publish a draft of the proposed rule until August 2024, and they have been very clear that they couldn't put a draft of the proposed rule out there until they conferenced with EPA, until they conferenced with the FLMs, the federal land managers. So we didn't know what was final and what to officially react to until August in 2024. Since August 2024, that proposed rule has been updated and republished twice. And in each republication, the rule revised how it would apply to EPNG's facilities, changing from 90% to 80%, changing revised cost calculations. Those changes are hugely consequential. So every time we saw a new rule, whether it was August, December, we had to re-engage vendors to obtain updated vendor quotes, develop new engineering analyses, and overall reconduct very time and resource intensive evaluations. Throughout the process, EPNG's has been fully engaged and very responsive. To ensure a reasonable and justified rulemaking process, we ask that this board carefully consider EPNG's written filings and verbal testimony independent of the proposal before it. And lastly, there's been a good amount of talk even this morning as to, what is the last step in this process as it proceeds. And this rule and the SIP adopted by this board would have to obtain approval from EPA. As you may have seen, the Trump administration has announced that it is reviewing and restructuring the federal regional haze program, and that is likely the purview under which this SIP will be reviewed. And in its reconsideration, the administration has cited to high cost to industry, which they have indicated will have a negative effect on affordable energy throughout the United States. I will hit just two more points briefly, which is to say that the decisions today are the board's decisions, and these are just two legal citations that drive home that point. Accordingly, the board is tasked with evaluating the evidence presented in this rulemaking independent of the proposal before it. And the one other piece I want to hit for us is, and flip here, is there's been discussion about, how many facilities are regulated and what are the consequences of those facilities. And we heard that there are 23 facilities in this regional haze out of 134 Type 5 facilities. And the entities here today, the three that are represented in this rulemaking, are 9 of the 9, I might get this wrong, 9 units of the 23 units. It's 9 units. So there was that, I know that fact is true. Which is a little bit misleading with respect to the impacts to your rule if, for example, Blanco A and Pecos River were appropriately removed on the legal bases we have presented. In total, for the incremental projects at Pecos River and Blancos A, the projects are less than 300 tons per year for those two facilities out of all of the regional haze program. And I want to remind you that those are NOx reductions. So NOx reductions have the potential to reduce the formation of ammonium nitrate. However, it's SO2 emissions that form ammonium sulfate, which has the far larger impact on visibility impairment. And like you can see here on the graphs before.
Mr. Behill?
Objection, mild objection. I also saw a slide that said, well, objection. Ms. Gutierrez is not a witness. She's giving testimony. I've tried to be very tolerant of this. I think sort of crossing over the line. There were a couple things that said that were questionable. There's really no way to cross-examine her, which I'd like to do. I'm not going to try to do that. But also there was a slide that said questions. So I don't think it's appropriate that the board question an attorney, you know, as if they're a witness. So with that, I'll leave it at that.
All right, thank you. Ms. Gutierrez, I would not be inviting anyone to ask you questions. And perhaps as you finish this, and you do have just a few minutes, if you can say, you know, you'll hear this testimony from this witness, that would be good.
Understood. And you will hear testimony from Ms. Wee-Wen Daly and Mr. James Trent with regard to the actual impacts from Blanco A and Pecos River, which again, I want to be clear, were slightly misleading in just the count of facilities when you're looking at the emission reductions that would be achieved. And as you'll hear from Ms. Daly in her testimony today, it's very clear that the primary driver, as we've heard, is from ammonium sulfate, which is this large yellow bar, whereas ammonium nitrate is the orange bar, which is again, when we're looking at the Pecos River and Blanco 8 facilities, where they would fall. This is all very relevant when we're talking about the cost prohibitive projects that are being requested. And with that, I think I will end my closing and we will transition to Ms. Wee-Wen Daly.
Thank you. Ms. Daly, if you would spell your first and last name for the transcript. Thank you. Do you swear or affirm to tell the truth? Thank you. That is going to have to be closer to you. Yeah.
And this is Michael Miller for the record. If I could request sharing of my screen when I clicked it.
Okay.
Ms. Daly, can you please introduce yourself for the record?
Yes, my name is Wee-Wen Daly. I'm a senior environmental health and safety engineer at the EPNG's parent company, Kinder Morgan Inc. In my role, I prepare and submit air permits applications, prepare and submit compliance and emission reports to relevant regulatory bodies in compliance with air permit requirements. I previously worked for an environmental consulting company and the Arizona Department of Environmental Quality, Air Quality Division, including air permits section, compliance and inspection section, and enforcement sections. Since joining Kinder Morgan, I have worked through the regional haze process in other jurisdictions, including Arizona and the Navajo Nation. In all, I have 20 years of professional experience in air quality matters.
Did you previously file pre-filed written direct testimony in this proceeding?
Yes.
And are there any corrections you would like to make to your pre-filed testimony?
No, I adopt my pre-filed technical testimonies in full here.
Would you please summarize what topics your direct testimony will cover today?
Certainly, I addressed several issues in my testimony. First, I will provide an overview of the elements of the department's proposed original Hayes SIP revision that apply to EPNG. Next, I will provide a brief background on EPNG itself. And after that, I'll provide a detailed analysis on several of the department's methodologies and show why the board should not impose emission reduction on units at Blanco A and the Pecos River.
Would you please discuss how the department's proposed SIP revision would apply to EPNG?
Yes, the department proposed NOx emission rate limits for certain units operate at 3 EPNG sites. The first is Washington Ranch. Here, the department proposed requirements shown on the slide for 2 units at Washington Ranch. EPNG does not oppose these. These are based on the existing controls at the site. The second facility is Pecos River, where the department proposes NOx emission rate limits for 2 units, A02 and A03. And those limits would be based on installation of SCR, assuming an 80% control efficiency. For the reasons we will discuss, EPNG opposes these limits. Finally, the department proposed EPNG entirely replace 2 units at Blanco A to achieve a certain NOx emission limit. EPNG opposes this as well, which we will discuss.
Ms. Daly, before you get into the detailed reasons why the board should not adopt the proposals for Blanco A and Pecos River, can you first please provide a high-level overview of EPNG and its operations in New Mexico?
Yes, as shown on this slide, EPNG supplies natural gas to a number of electric and natural gas utilities in New Mexico. EPNG pays millions in state and local taxes to support local communities. EPNG also employs over 180 individuals in New Mexico. On this slide, I show where EPNG operates in the natural gas supply chain. What we're talking about are the compressor stations that move pipeline quality natural gas from the natural gas processing plants to the end users, such as communities, schools, hospitals, homes, and other industrial uses. EPNG also provides storage, which is critical to smoothing out seasonal demands when, for example, we all turn on air conditioners during high heat and the heaters when the weather turns cold. Contrary to the assertions made by the other parties, EPNG is not looking to evade any new requirements. That is not our mission, nor is it the company's demonstrated behavior. EPNG does its part to work with the department and the other state and the federal agencies to develop responsible emission reduction strategies. Indeed, Kinder Morgan worked closely with the department in development of Part 50 ozone precursor. EPNG maintains that any requirements must be cost effective and based on rigorous and accurate analysis. More fundamentally, the board must stay within its legal authority in promulgating any rules.
Thank you, Ms. Daly. We are ready to discuss your recommendations on the proposed SIP. Would you please start by discussing the issues in the proposed SIP that apply to all of EPNG's facilities?
Yes, I first wanted to start with the method that the department used to estimate how much NOx emissions are expected to be emitted in the future. This is a critical issue because the cost effectiveness analysis is determinative. That calculation is the cost of controls over the tons of emission reduced. Bottom line is that EPA's guidance directs states to use actual emissions, not the potential to emit, when calculating cost effectiveness. For both Blanco A and the Pecos River, the department assumed that in any hours, those units would be operating at a 100% engine load. That is simply not a realistic or accurate assumption. This is a bit of an exaggeration. It is somewhat like assuming whenever I drive my car, I'm pedal to metal at all times when calculating gas mileage. Just like that assumption is not reflective of my actual driving behavior. The same is true for engines and turbines, which do not typically run at 100% load when operating. Even EPA's AP42, which is the compilation of air emission factors from stationary sources, clearly states engines on gas transmission pipelines run at the variable loads. And in making that assumption, the department used a single NOx emission test result to derive the NOx emission factors for each unit at the Blanco A and the Pecos River. One data point extrapolated as a linear function of engine load is not representative of actual operations. EPA's AP42 states that actual emissions can vary significantly due to variations in the engine operating conditions. And it is not unusual to test emissions from two identical engines in the same plant, operated by the same personnel, using the same fuel and running at the same load, and have the results show completely different emissions. Interstate natural gas pipelines are designed to be available to serve absolute peak load when demand is the highest, and everything in between. Peak loads occur infrequently, only a few times per year. For this reason, when units are running, they only run at 100% infrequently. Furthermore, for Pecos River, the department used an ISO horsepower rating based on sea level and the ambient temperature of 59 degrees Fahrenheit to scale up the emission factors. This is not an accurate assumption and overstates the turbine's actual emissions.
Ms. Daly, what is the consequence of the department's use of incorrect data?
Recall, we are talking about the cost of implementing controls divided by the tons reduced. In the department's approach, the baseline emission data are dramatically overstated, which inflates the denominator and the results in artificially lower cost per ton. In fact, the department's estimated emission reductions are so inflated that they are higher than the actual emissions at the Blanco A and the Pecos River.
And Ms. Daly, based on your experience, analysis, and corrected calculations, what is your recommendation to the board on this issue?
I recommended that board evaluate the cost per ton emission reduced using actual expected emissions from each individual unit. As I show on the table here, adjusting just the actual emissions, not using the potential emit, and no other assumptions would cause the cost per ton of each unit to be above the department's proposed $10,000 per ton threshold.
And as a follow-up, what is your position on the department's proposed $10,000 per ton threshold? Is it appropriate?
The $10,000 per ton threshold is the highest threshold in the nation today. When approved by EPA, the Biden administration EPA made it clear that it would not likely apply such a steep threshold. This is an important consideration for the board, given that the SIP, the regional haze SIP, would need approval from the Trump administration EPA to move forward.
Okay, let's shift gears to another topic, the consideration of visibility impacts. Would you say that the department properly considered visibility impacts?
No, visibility impacts were not adequately considered at the source selection stage and at the control selection stage. Beginning with the department's decision that Mesa Verde may be affected by emissions from New Mexico. The department did not do any detailed modeling of this issue. Instead, the department relies on residence time plots. For a given point, this showed the probability that an air parcel came from a surrounding area. The department's mapping, in fact, shows that Blanco A's air is only getting to Mesa Verde less than 1% of the time. And that the department does not analyze whether once that air gets to Mesa Verde, there are in fact any visibility impacts. This 1% is an awfully small number from which to conclude that Mesa Verde may be affected by emissions from Blanco A, when in fact, Blanco A is likely to have a de minimis impact, if any, on the visibility in Mesa Verde.
And were there any steps in the department's analysis that would have merited air quality modeling or more careful analysis?
Yes, the department is clear that ammonium sulfate dominates visibility impairment on the most impaired days at the relevant class 1 areas. So it matters whether the emissions are SO2 or NOx. However, the department improperly ignored this fact and weighed NOx reduction 1-to-1 ratio with SO2 reduction. This is not scientifically accurate. Let's take Pecos River and the Blanco A. Their respective SO2 emissions were 1.68 tons and 0.12 tons. It is clear that the SO2 emissions from Pecos River and the Blanco A are de minimis. And what's more, the department has said that every single class 1 area except one is already below the glide path to natural visibility condition.
You also noted that the department should have evaluated actual visibility impacts at the control selection stage. Can you elaborate?
Yes, the whole point of this rulemaking is to address visibility conditions at the class 1 areas. Yet the department did not consider impacts on visibility conditions at the class 1 areas that would result from the proposed emission reductions. The 2019 EPA Regional Haze Guidance provides that the states have reasonable discretion to consider the anticipated visibility benefits of an emission control measure. Had the department considered this factor, it is likely would have concluded that no emission reduction are required from Pecos River or Blanco A because of existing visibility and the de minimis emissions from Blanco A and the Pecos River, including near zero SO2 emissions. This analysis was never conducted by the department.
What is your overall conclusion related to visibility impacts?
The board should reject the proposed SIP revision because the failure to consider visibility impacts at the source selection stage. Short of that, the board should reject the new emission limits for Blanco A and the Pecos River because such reduction would have inconsequential impacts on visibility at the locations that are already below the glide path to natural visibility conditions.
Thank you, Ms. Daly. I'd now like to shift gears and turn to the facility-specific issues that you said you would discuss. What is EPNG's position on Washington Ranch?
EPNG does not oppose the proposed emission rate limit for Washington Ranch. EPNG does not agree with the underlying cost effectiveness analysis that was performed by the Department for Washington Ranch for the reason already discussed. For example, the department did not use actual emissions, and we recommend the board to correct these errors for the record.
And what is EPNG's position on Pecos River?
EPNG strongly opposes that proposal.
Why does EPNG oppose that proposal?
There are multiple reasons. Two of them relate to my previous points. First, the department did not use actual emissions, just assumed the full load emissions, which is both flawed and it results in an inaccurate cost per ton. And the second, the department should have considered overall visibility impacts of Pecos River, which are minimal. Turning to issues that are specific to Pecos River, there's one point that is really important. In 2023, the same department approved an alternative emission standards, or AES, under the board's recently adopted Part 50 ozone precursor rule. The reason for that AES, the department determined that SCR at the Pecos River should not be required because it is economically infeasible. Now in 2025, when costs of controls have only increased, not decreased, all of a sudden, the department changed its determination and found that the cost is feasible. Finally, vendor costs at the Pecos River show that SCR is far more expensive than the generic cost estimates used by the department.
Thank you. Could you please briefly discuss the AES, or Alternative Emissions Standard, at Pecos River?
Certainly. Each unit at the Pecos River is subject to the board's ozone precursor rule at Part 50, which specifies NOx emissions requirements for each of these units. As the board is aware, the ozone precursor rule also has alternative compliance pathways when a company is faced with cost or technical infeasibility. EPNG submitted a demonstration to the department in 2023 that the department approved, finding that all units, including AO2 and the AO3, could not meet the Part 50 NOx emission standards based on the high cost of installing SCR. Now, in this rulemaking, the department is deviating from its early finding and proposing to find that SCR is cost effective at the units AO2 and AO3. That is arbitrary.
Thank you, Ms. Daly. The next issue you noted for Pecos River is the use of vendor cost estimates. Could you please describe your position on this issue?
Our position here is that EPNG has presented a detailed unit-specific vendors quotes. The department should have considered these vendors quotes, but it did not. The board must adopt a defensible rule. In doing so, it makes good sense to consider actual vendors quotes as opposed to generic cost estimates presented by the department for SCR at Pecos River, based on costs from completely different kinds of units. The department's estimates are really an apples to oranges comparison. To be clear, the EPA's 2019 guidance provides that unit-specific estimates based on vendors' quotes are preferable for assessing cost-effectiveness evaluation. Indeed, for the alternative emission standards I discussed above, EPNG presented the unit-specific cost estimates based on vendors' input. There's no reason for the department or the board to ignore the vendors' quotes.
Your discussion just now was in reference to capital costs for SCR. Did EPNG also calculate different operations and maintenance costs, or O&M, for SCR?
Yes, EPNG's operations and maintenance costs for SCR were also based on vendors' estimates and were far higher than those calculated by the department. EPNG used the vendor cost estimates to assess the cost of catalyst replacement, which must be conducted approximately every 3 years. Additionally, ammonia must be used constantly by the SCR system as part of the chemical reaction in the SCR process, based on vendors' estimates of ammonia consumption rate and the ammonia cost. EPNG calculated far higher annual ammonia consumption cost than the department did.
Thank you. Could you please summarize your conclusion on SCR costs for Pecos River?
I conclude with high confidence that adding SCR at the Pecos River is not cost effective. As you can see in the table below, correcting all the flawed assumptions by the department results in cost more than double the proposed $10,000 per ton threshold. And this is in the yellow column. And to be conservative, if we look at this different ways, for example, if you were to hold all of department's assumptions the same, but just correct the capital cost by using our vendor's quotes for SCR, and that should not even be debatable. The costs are well above $10,000 per ton. That is the blue column. Finally, if we leave all department's assumption, but only correct baseline actual emissions, then SCR is still not cost effective at the Pecos River. That's the green column. I therefore strongly urge the board not to adopt an emission requirement based on SCR at the Pecos River. Doing so would not be defensible in a subsequent court challenge.
Ms. Daly, I would like to shift gears to discussing Blanco A, the other EPNG facility that the department has proposed regulating under the proposed SIP. Could you describe the proposed requirements for Blanco A?
I'd be happy to. Here are pictures of the two units at Blanco A that are included in the proposed regional haze SIP, units 811 and 813. These visuals show just how massive these units are, which gives context for the unprecedented demand by the department to replace them. This is not like replacing an engine motor. These units each measure 19 feet long by 14 feet wide by 9 feet tall. They are larger than a typical primary bedroom in the United States. As you can see on the table on this slide, the department is proposing that the Blanco A units achieve a 0.5 gram per horsepower hour emission limit for NOx. In this proposed SIP revision for regional haze, the department determined that the low emission combustion control, or LEC, is not cost effective for the units at Blanco A. So the only way to achieve that NOx limit here is to replace the existing units. So the department is proposing replacement. As you can see on this slide, there are 6 reasons that the board should not adopt the department's proposal with respect to Blanco A. As you heard from our counsel, the department does not have authority to require replacement. Should the board venture down that path, my testimony further describes why adopting the department's proposal would be arbitrary based on the record in front of you. The first 3 reasons are based on reasons we have discussed and that apply to multiple facilities. In the next part of my testimony, I will discuss the use of an over-inclusive screening analysis. That's number 4. And the cost per ton evaluation. That's number 6.
Thank you, Ms. Daly. Would you please start with the screening analysis and explain to us what Q over D is?
Certainly. The department used a Q over D analysis to determine which sources to include in its cost effectiveness analysis. Q over D looks at the quantity of a source's emissions, then divides it by the distance to the nearest class 1 area. In this case, the department used the tons of NOx and SO2 as the Q, the quantity, and the distance in kilometers in the class 1 area as the D. The department stated that its approach was to select a Q over D threshold that would pull in 80% of statewide emissions from Title V facilities. As you can see on this slide, we don't contest the use of Q over D, just the department's application. This is because the department deviated from the RAP regional haze protocol that the department states it followed. The RAP protocol suggests use of a Q over D of greater than 10 to screen sites in, and only recommends a lower threshold if no sources are captured by a Q over D of 10. Here, a Q over D of 10 would have pulled in 13 facilities, covering about 70% of the total NOx and SO2 emissions from all Title V sources in New Mexico. That is a perfectly reasonable stopping point. The department offers no reason for deviating from the protocol's recommendation. As to the last point, even if 80% of statewide emissions was the right target, Blanco A still should not have been included. Blanco A was the very last source that the department screened in. Without Blanco A, the department would have still screened in 79.98% of emissions. Under the conventional rule of rounding, 79.98% would have rounded to 80%. The department's failure to apply the standard rounding rule that applies to every other air quality context is arbitrary. Additionally, on page 93 of the proposed SIP revision, the department stated that a Q over D of 5.6 would achieve the goal of identifying Title V sources responsible for 80% of total NOx and SO2 emissions in New Mexico. In this table, the department identified the Q for Blanco A as 356.65 tons and the Q as 63.35 kilometers, resulting in a Q over D of 5.63. On page 111 of the proposed regional haze SIP revision, the department stated that the shortest distance from Blanco A to Mesa Verde is 39.8 miles. Use any available conversion tool. 39.8 miles equates to 64.05 kilometers, not 63.35 kilometers. So the correct Q over D for Blanco A is 5.57, below the Q over D threshold selected by the department. By shortening the distance from Blanco A to Mesa Verde, the department erroneously screened in Blanco A for cost effectiveness analysis. Indeed, Blanco A should never have been screened in if not for the department's math error. My bottom line recommendation on Blanco A and the screening is that the department should have screened out Blanco A for multiple reasons.
Ms. Daly, I'd like to ask you one clarifying question for the record. A moment ago, you referred to a Q of 63.35 kilometers. Would that have been D instead of Q?
Yes, that's the Q, 365.65 tons. That's the quantity.
Whereas the D would be the kilometers amount, correct?
Yeah, D is 63.35 kilometer.
Thank you.
Yeah.
Ms. Daly, you mentioned that the next issue you would address for Blanco A is the cost effectiveness analysis. Would you like to turn to that now?
Yes, I would like to address several flaws in the department's analysis for the cost of replacement in Blanco A. Before doing so, I just want to highlight that my colleagues, Mr. Trent and Mr. Mitchell, will address why replacement at Blanco A is not feasible. Frankly, we should not even get to the cost effectiveness discussion because EPNG cannot do the activity the department is requesting. but for the record, we felt it necessary to share the data with the board. First, the department assumed $0 for annual operation and maintenance costs for replacement. But that conclusion entirely fails to consider the cost of oxidation catalyst for the replacement unit. The new units will have to meet the new source performance standards, FAR-J standards, that have very strict CO limits. In order to meet the strict CO limit, EPNG has to install oxidation catalyst. The catalyst will require replacement every 3 years and a chemical wash every 7,000 hours of operation. The department did not include this additional O&M cost in its cost effectiveness analysis. Second, as I already testified, the department used grossly inflated estimates of baseline actual emissions at Blanco 8. This table shows that if we could even do this, the costs at Blanco 8 would be prohibitive. The blue column corrects the O&M cost, and the baseline emissions shows the cost per ton is well above $10,000 per ton threshold. The green column corrects just the baseline emission, and it is still over. I therefore recommend that replacement at Blanco 8 be rejected for these additional reasons.
Thank you, Ms. Daly. If this concludes your direct testimony, could you please summarize all of your overarching recommendations for the board before concluding?
Yes, as shown here, there are multiple reasons that the board should not adopt emission requirements for Pecos River and the Blanco 8. Thank you. That concludes my testimony.
Thank you. Okay, we'll now be moving to your rebuttal, Ms. Daly. Ms. Daly, did you previously pre-filed written rebuttal testimony in this proceeding?
Yes.
Are there any corrections you'd like to make to your pre-filed rebuttal testimony?
No, I adopt my pre-rebuttal testimony in full here.
Would you please summarize what topics your rebuttal testimony will cover?
Certainly. I will respond to certain testimony from the department's witnesses that relates to my testimony. First, I respond to testimony addressing the department's source screening methodology and the overall consideration of feasibility impacts. Then I respond to certain assumptions that the department made in their cost effectiveness analysis. Before going forward, I first want to quickly reorient on the 6 units at the 3 EPNG facilities that the department has proposed regulating and how the agency suggests EPNG achieve compliance. As shown on this chart, EPNG opposes the proposed regional haze regulations for Blanco A and the Pecos River.
Thank you. Turning to the source selection and visibility issues, what specific issues do you present for the board's consideration?
I will explain the 5 topics shown here on this slide, starting with the first issue, that it is too late for parties to challenge the department's source selection process. First, contrary to assertions made by certain department's witnesses, it is not too late to challenge the department's source selection process. Department witnesses argue that water is under the bridge and that the department has already made its source selection decision, so there is no going back. That answer is not very well thought out, nor does it respect this rulemaking process. The board is responsible for adopting air quality regulations, not the department. The board must still exercise the role designated to it by the New Mexico legislature to properly consider all aspects of the proposal before it. This is not a rubber stamping process. The second item related to the source selection that I would like to discuss is the role of the RAP protocol. My discussion of the RAP protocol focused on the fact that the department said it was following the RAP protocol, but the department failed to do so without explanation. It would have made sense to us if the department did in fact follow the recommendations in the protocol to select a Q over D of 10 if multiple sources are pulled into for further analysis on that basis. It is not reasonable for the agency to say it is following one procedure or practice, but then deviate from it without saying so, or without any explanation. Additionally, for source selection, the department's witness defend its source selection process based on the fact that National Park Service supported the department's methodology. My point here is that an agency must act reasonably. And so simply citing support from one group does not necessarily show reasonable action, nor does it represent compliance with the law. Reasonableness will be judged by this board's independent and comprehensive analysis.
Thank you, Ms. Daly. Shifting gears, can you explain to us again the rounding error issue at the screening stage for Blanco A?
Yes, the department stated its goal was to screen facilities that comprised 80% of statewide Title V emissions for NOx and SO2. The top 23 facilities comprise 79.98% of statewide Title V facilities, NOx and SO2 emissions. The department should have stopped there because in all other relevant air quality rules, you round up. But the department didn't. And the Blanco A is only pulled in because of this error, causing the proposal to capture more than 80% of the total emissions for NOx and SO2. It is not a reasonable response that the department's Q over D process was well documented. That defense does not address the core issue. A flawed process is still a flawed process, even if it's well documented. I also want to note that EPNG is not looking for a procedural loophole. We are just asking the department and the board to follow conventional rules of math and to keep consistency in their application.
Thank you. Taking a step back, are the Class 1 areas that are subject to this proposal already below the uniform rate of progress glide path to the visibility targets?
All but one Class 1 area being addressed in this proceeding is projected to have visibility conditions below the uniform rate of progress glide path to achieve natural visibility conditions by 2064. And that projection does not consider this rule proposal. In response, the department points to the one Class 1 area that is projected to be above the glide path, Salt Creek. But Salt Creek is not the closest Class 1 area to Pecos River or Blanco A, which makes that irrelevant to EPNG. It is not persuasive to say that Salt Creek is relevant to Pecos River because of an area of influence analysis, as I discuss next. As I show on this slide, the department's own supporting documentation shows that the area where Pecos River is only has its air parcels end up in the Salt Creek wilderness area 0.2% to 0.5% of the time. So even the department's fallback argument about Salt Creek's area of influence is unpersuasive.
Thank you, Ms. Daly. Moving to cost effectiveness analyses, do you have any responses to the department's direct testimony?
Yes, I have two responses. As I emphasized at length in my direct testimony, actual emissions are reflective of actual visibility impact, and they must be used in the regional haze program. Nothing in the department's testimony has convinced me otherwise. EPA's guidance on using actual emission is quite clear on this point, as I discussed in my written testimony. Second, as EPNG has shown, replacement at Blanco A is infeasible, and the department is not able to respond to that argument. Regardless, the revised proposed SIP is based on a cost estimate that does not include the catalyst cost for achieving new source performance standards, or CO.
Can you please respond to Department Witness Robert Seidner's arguments about inappropriately using a 100% load assumption?
Ms. Seidner argues that the department's process for scaling up emission to 100% load was reasonably accurate. But my broader point is that the department should not have scaled the load up at all. The 100% load assumption is simply not realistic. As I stated in my direct testimony, it is analogies to assuming that I drive my car pedal to the metal whenever I'm driving. Of course, that is not accurate.
In 2017, EPNG submitted potential rather than actual emissions with its emissions inventory. Why did EPNG submit potential emissions at that time?
The department requires all Title V sources to pay emission fees based on potential emission, not actual emissions. For this reason, it made more sense at the time for EPNG to only calculate potential emission rather than actual emissions. At that time, EPNG did not have any requirement to calculate actual emissions. And in the 2016 emission inventory submitted to the department, EPNG provided the basis for emission factor used in the calculation, which is the permit limit, not the actual test result. In early 2020, during the early stage of the regional haze four-factor analysis, EPNG noted this issue to the department so that it could correct emission inventories based on actuals. For that reason, EPNG submitted to the department in 2020 updated emission inventories using actual emissions for calendar years 2016, 2017, and 2018. That leads me to the chart shown on this slide. As you can see, the emission reduction that the department calculated are so inflated that they are actually far larger than the actual emissions from the same averaging period that the department used. In summary, the baseline emission that the department calculated for the purpose of developing a cost per ton were grossly inflated and not representative of the actual operations. This means that department's cost estimate in dollar per ton are far lower than the actual cost per ton.
Thank you, Ms. David. Would you be able to summarize your rebuttal testimony's recommendation?
Yes, in conclusion, the department's written testimony does not persuasively address my critique of their source selection methodology and the cost calculations. Thank you. That concludes my testimony, and I'm happy to answer questions.
And hearing officer, we're happy to submit Ms. David for cross-examination at this point. We don't know whether a break would be amenable for folks, but either way.
All right, so our last break took us to 10:20. It's just 11:30 at this point. Let's proceed with cross-examination. Mr. Vigil, you do not have questions. All right. Ms. O'Grady, do you have questions? You do. You would sit up next to Member Garcia there.
Good morning, Madam Hearing Examiner, Madam Chair, and members of the board. Morgan O'Grady, Counsel for Western Environmental Law Center and the conservation groups. Ms. Daly, I'd like to talk a little bit about a few issues raised today. First, you testified during your direct this morning about whether NMED's analysis would be defensible in court. Is that correct?
Yes.
And you testified as well about how strictly NMED must follow RAP guidance.
Yes.
And this morning, NMED's witness, Mr. Kenneth Miller, testified that replacement is a legal issue.
Could you please rephrase that?
Yes, Mr. Kenneth Miller this morning, a witness for NMED, testified to the replacement of units being a legal issue, which he was not able to speak to. And it's okay if you don't recall, that's totally fine. Yeah. Okay. And are you an attorney?
I'm not.
Okay, thank you. I want to turn to the timing of NMED's engagement with EPNG. So NMED first sent EPNG a letter indicating that one of its facilities had been selected for further analysis on July 18th, 2019. Is that correct?
I don't know the exact date, but it is in 2019 because I was not involved at it.
Okay, thanks. And NMED again contacted affected companies in 2023 about the 4-factor analysis process. If you're able to speak to that, is that correct?
I think it's probably mid 2023-ish. Yeah.
Okay. And then NMED met with EPNG during the year of 2023 as well. Had a meeting with EPNG.
Yes, correct.
And NMED first shared drafts of the cost analyses in early 2023, or sorry, late 2023.
Like towards the end of December 2023.
Yes.
Yes.
Okay. And then NMED accepted comments on those first drafts of the cost analyses. Is that correct?
We provided comments to the department, and we never get any response from.
Okay, thank
from
you.
the department.
And then my last set of questions relates to the ozone precursor rule. Was the ozone precursor rule a separate, different rulemaking?
I would say so.
And was the ozone precursor rule governed by the regional haze rule 4-factor analysis?
It wasn't, but the calculation is similar to calculate the cost per ton.
Okay,
to
thanks.
determine whether or not.
Thank you so much. That's all I have for you. Thank you so much.
Thank you, Ms. O'Grady. Mr. Harris, do you have questions of Ms. Daly? Thank you. Mr. Harris indicated that he does not. Mr. Wexler or Ms. Wood, do you have questions of Ms. Daly? Nope. The answer was no. And Ms. Catalano? No. Ms. Catalano said no. I'm not sure if Mr. Maxwell is on the platform today. He is not. All right, thank you. Let's turn then from the parties. I'm sorry, Ms. Gutierrez, would you like, or Mr. Miller, do a little redirect before I turn to the board?
That would be appreciated.
Okay, go ahead.
Ms. Daly, with regard to the RAP protocol, it is not your position that you're asking the department to quote unquote strictly adhere, correct?
That's correct.
Rather, you're saying because the department is saying it's following a guidance, and guidance is there for a reason, that you would expect it to either follow that guidance or explain why it diverged, correct?
That's correct.
Thank you. And then when EPNG was selected for analysis in 2019, right, when that engagement originally began, did the department share with you any specific grounds, bases, calculations, any kind of numbers or explanation for the reason why they were pulling you into the four-factor test?
No, they did not.
Thank you. And the ozone precursor rule, is NOx a precursor to ozone?
Yes.
Pretty sure. And the primary focus of that rule was NOx reductions, correct? Right. And here, the primary focus of the NMED's proposals with respect to EPNG facilities is NOx reductions, correct? So in your evaluations, you would have applied the same exact EPA-derived cost analyses in evaluating cost effectiveness as between those two rules, correct?
That's correct.
Thank you.
I have one question also. So in Council, Ms. O'Grady mentioned a 2023, late 2023 request for information from industry. Was the turnaround time to provide answers to that sufficient to receive vendor quotes?
It was not. We actually were asked to provide comments during the holiday season, and we requested additional day, which we were given only 7 extra days to provide comments.
Thank you. That concludes my redirect.
Okay, thank you. Vice Chair Trujillo, do you have questions?
I just have a couple. As you were talking about the Blanco facility and the replacement of those units, if those units were to be replaced, does that action trigger other regulatory requirements? Let me just double check my notes here. Does it trigger greater compliance under other state or federal rules?
I would, I think that's a better question for my colleague.
Okay. All right. Well, then I don't have any more right now.
Okay. All right, thank you. Member Bitzer, do you have questions?
Following on that a little bit, I heard earlier that new equipment or that equipment could be running same fuel, same temperature, same altitude and so forth, and still have different outputs. Would that likely also be true if there were replacement equipment? Would seemingly duplicate pieces of replacement equipment also potentially have that variable built in?
I think that's another question for our witness later.
Don't want to interrupt, but probably both of those, save those both for Mr. James Trent. I think he'll be your best.
Thank you, Ms. Gutierrez. Member Hunker.
Yes, just one question. Ms. Daly, during your testimony, you talked about an error in calculating the distance between the Blanco A facility to Mesa Verde. Could you repeat that? I didn't quite follow it.
Yes, so basically the Q over D process, Q is the quantity of the emissions of NOx and SO2. Then the D is the distance from the facility, the Blanco A, to the nearest class 1 area. So the department stated in the SIP revision that the distance between Blanco A to Mesa Verde is 39.8 miles. So the D is in kilometers. So we have to convert the miles to kilometer to the calculation. So 39.8 miles equates to 64.05 kilometer, which is the denominator. So the department converted 39.8 miles to 63.35 kilometer, shorter distance, causing the Q over D larger. So that's how you pull in. So it becomes higher than the threshold of 5.6. So you're pulling in Blanco A for screen the Blanco A for cost effective analysis. But indeed, our Q over D is less than 5.6. So we should not even be pulling in. Basically, that's
okay. Thank you.
Member Garcia.
No questions. Thank you.
Right on the platform, Member Ely.
Yeah, I think I just have one question, and that is, Ms. Daly, what is your understanding as to why NMED did not use the vendor estimate for SCR at Pecos River?
I don't know the answer, why they don't use.
They did not get back to you on that.
They didn't. We didn't get any response from the department. Like when we submitted a response in January 2024, we didn't hear anything until close to either July or August. Says there will be a draft. I mean, but we're not getting any response from the department.
Okay, thank you.
Chair Sweeney?
No questions. Thank you.
Thank you. Member Bitzer?
Yeah, I have one more question. You used the term glide path as it head towards achievement of attainment of standards. Is that a industry term of art? Is it a regulatory term of art? Is it legal? Is there room for consideration or grounds for consideration of that?
I think it's a regulatory, right? It's the EPA uses that.
Okay, Ms. Gutierrez, would you like to answer that question?
I would be happy to. It's sort of a short term for uniform rate of progress, right? So the formal term is uniform rate of progress, which is if you're on that linear trajectory towards your visibility goals at the set date. I think folks just say glide path, thinking like you're on the glide path to the right place. So it is shorthand.
Okay, any other board questions? Oh, yes, Vice Chair.
I just had some questions about the vendor estimates. Can you explain a little bit more to us about how those estimates are put together? Like what is included in that estimate?
Again, I think it would be better answered by our next witness.
Okay. Thank you. Well, thank you for your time.
Yeah.
Okay, other board questions? Is there any reason not to excuse Ms. Daly? No? Thank you very much, Ms. Daly. Okay, we are right at 11:45. I see, let's see, you had identified Mr. Tyreen.
That's correct, hearing officer. His testimony is pretty quick.
That's what I saw in your NOI. It's about 10 minutes.
Yeah.
Can we
Let's
knock
try.
that off? All right, thank you. And is he on the platform? All right, Mr. Tyreen, if you can turn on your camera and unmute yourself.
Can everybody see me and hear me?
Yes, there you are.
Oh, thank
if you
you.
would please spell your name for the transcript.
Yeah, yes, ma'am. My first name is Francisco. That's Francisco, and my last name is Tarin. T as in Tom, Arin.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you very much. Go ahead, Mr. Miller.
We're just working a little bit on this PowerPoint. Excuse the thing. Mr. Attorney, can you please introduce yourself for the record?
Yes, my name is Francisco Tarin. I am the Director of Regulatory Affairs for the West Pipe region of Kinder Morgan Incorporated. That would be EP&G's parent company. In that capacity, I oversee regulatory matters related to compliance with the Federal Energy Regulatory Commission, referred as FERC, and also oversee Natural Gas Act compliance matters. Accordingly, I believe I'm well versed in FERC procedures, regulatory requirements, and regulatory timelines.
Did you previously file a pre-filed written testimony in this proceeding?
Yes.
Are there any corrections you would like to make to your pre-filed testimony?
No, I adopt my testimony in full here.
Would you please summarize the testimony that you will present today?
Certainly. I address two main topics. The first one, I explained that the Natural Gas Act is meant to provide a uniform playing field across every state to ensure that interstate natural gas infrastructure can be developed and operated without any state blocking a pipeline. Accordingly, the state of New Mexico may not independently require the abandonment of interstate natural gas pipeline engines or facilities. Second, any final state implementation plan must at least consider the timeline required for the abandonment process that will be undertaken with the Federal Energy Regulatory Commission.
Thank you. Could you please discuss the first issue, the Natural Gas Act and preemption?
Objection.
Certainly.
Mr. Tareen is not an attorney. The legal analysis that was provided by EPNG is not related to black letter law or description of the Natural Gas Act. What it is a highly speculative, attenuated interpretation of federal case law. And so what Mr. Tareen is going to do is engage in interpretation of case law and provide the board with legal conclusions. That's the job of the attorneys. It's all the more reason why we should address this and find the effective conclusions of law. Closing arguments. Thank you.
Mr. Miller? Yes, please.
So yesterday we agreed that we'd be admitting testimony in all. We'd stipulated to that. That's a first point response. Second is that Mr. Tareen will not be addressing any cases. I think it's possible that counsel for the department is misconstruing Mr. Tareen's testimony, his direct testimony filed in this proceeding, with the non-technical statement that addressed legal issues. And additionally, we can focus on the policy basis for these rather than a quote legal basis, as Mr. Tareen has over 20 years of experience in FERC regulatory matters.
Yeah, this sometimes happens with technical staff at the department as well. As regulators, they actually know a fair amount about how the law is ministered, implemented, construed, enforced. I allow that testimony in, of course, and I am looking at his testimony. He oversees regulatory matters for the company. So with just one caution to the board, this witness is not a lawyer, but he does oversee regulatory matters. So please weigh his testimony with that caution. Thank you.
Okay, let me re-ask the question for you, Mr. Tareen. Could you please discuss the Natural Gas Act and the kind of policy basis underlying it?
Certainly. For reference, the map on this slide shows a network of both interstate and intrastate pipelines in the continental United States. The blue lines represent the interstate pipeline network. These pipelines generally function to take natural gas being produced in various basins across the United States to areas where you have your consumers, your end users, your industrial complexes. Notably, in New Mexico, you see the pipelines that transport natural gas from the Permian Basin that's in southeastern New Mexico and transport that gas westward to market centers in California and in Arizona. While not, I mean, the clarity or definition in this map doesn't clearly show that, these pipelines also serve the state of New Mexico, as EPNG witness Mr. James Trent will further discuss. Because of the 48 state footprint we see, Congress had the foresight in 1938 to pass the Natural Gas Act to ensure that one state would not disrupt the reliable and stable flow of natural gas across the states. We discussed this issue in more detail in our non-technical statement filed with the board. Just a point of notice, when we say natural gas pipeline, state statute, regulations, and case law tell us that that means the pipeline, as well as the facilities that are part of the pipeline.
Objection.
Engines,
He's making a legal
Hold on.
Sorry.
Hold on, Mr. Terry. Mr. Behill.
He's stating a legal conclusion. He's openly interpreting the law. He just admitted or just stated that he's weaving together case law, state law, and regulatory law. I also would like to object that this is not relevant. This does not apply to this proceeding. This is a red herring. This is just a distraction This, well, I'll
gonna
cover
object
this.
to that.
Okay. Ms. Gutierrez or Mr. Miller?
So there were several points raised. We'll start with the last one about this being a red herring. I think we can address that in post-hearing briefing about the relevance of this particular testimony. I would also point out that NMPRC, or sorry, getting mixed up with regulators, NMAC 20.1.1.401B says the hearing officer shall admit any relevant evidence. This is relevant evidence about what FERC regulatory requirements are. We can ask Mr. Tarin to not specify if it's provided under case law or the legal authority, and can just testify to his experience as someone who has dealt with FERC regulation.
Right. So that is the spirit in which I was hoping we could accept his testimony. And Mr. B. Hill, I'll ask you to save your questions for cross-examination. Go ahead, Mr. Miller.
Okay, Mr. Tarin, turning to this slide on FERC's role, I'd like you to testify to FERC's role in regulating natural gas pipelines, and please keep your testimony limited to your experience and what you've done with company.
Certainly. Well, this slide provides more background related to FERC's role, right? In order for a company to build, own, and operate an interstate natural gas pipeline, it must file an application with FERC, seeking authorization to do so. FERC then has to approve such a request, and the approval typically comes in the form of a certificate that gives such companies the right to build, own, and operate such facilities. In this process, FERC bases its decision to approve such requests on a determination of public convenience and necessity. That includes the need to meet that customer demand. Once approved and accompanied by other agreements, the pipeline is committed to providing natural gas transportation service that FERC has determined is necessary. These commitments cannot be compromised.
Thank you, Mr. Tarin. So, as a hypothetical, if a final rule were to require that Blanco A achieve an infeasible emissions rate, would EPNG have to abandon the Blanco A engines that would have that rate apply to them?
Yes.
And is it your understanding, or would you please discuss what the abandonment process looked like at FERC from your experience? Point you to slide 8.
Going through to slide 8. Sure. Give me 1 second, just organizing my notes. As I mentioned earlier, right, the FERC regulated facility has a certificate that is issued by FERC for that facility. The Blanco compressor station has multiple certificates associated with the construction and operation of that facility. And the 2 Blanco A units that are the subject of discussion operate pursuant to such certificates. As a certificated facility, FERC requires the facilities to continue operating on that basis, on the basis that FERC determined that the pipeline or turbines, engines associated with that facility are necessary to continue to meet that public interest. In order to abandon such facility, FERC also has to make a public interest finding or determination that the abandonment of such facilities is in the public interest. The regulatory process associated with it will involve submittal of an application to FERC, and the review process that goes along with it can take anywhere between 10 to 18 months. If there is a protest associated with that application, that proceeding, or 4 to 7 months if there is no protest.
Thank you. And
yeah, but I'd like to make one more point that, once an application is submitted for the abandonment, while that timeline is pending, EPNG cannot commence any abandonment activities.
Thank you, Mr. Tarin. Based on your testimony and your experience with FERC requirements for abandonment, is it possible that there could be a conflicting mandate wherein the board's rule or the SIP would require an infeasible emissions rate, and yet the FERC would not allow abandonment?
Yes. I think what this kind of presents a preemption kind of argument, right? There is a possibility that if the state of New Mexico would move forward with that mandate, you'd have the conflict would be when from the state of New Mexico to no longer operate those Blanco A units, kind of weighed against FERC saying that those units are still necessary for the public interest.
Thank you, Mr. Petty. Another question would be, are there any concerns that you have about regulatory timelines that would arise from the FERC requirements?
Can you repeat the question, Mike?
Certainly. So as another hypothetical, if the final rule here did not consider the amount of time that it takes to potentially receive the FERC abandonment approval, would that potentially require you to have to achieve a certain emissions rate before you actually have the approval from FERC, or without enough lead time to get the project done?
Right. You're going to be challenged as a company to try to meet, that requirement within the timeline. I think the way it stands today, the proposed rule does not take into account the necessary timing associated with El Paso Natural Gas securing the necessary FERC abandonment authorizations for it. So at a minimum, you'd have to take that. Yeah.
And we now submit Mr. Petty for comments.
All right, thank you very much, Mr. Miller and Mr. Tarim. We're actually going to break for lunch at this point. We will return at 1. And Mr. Tarim, just for your information, I have approximately 4 folks who want to make public comment at 1 p.m. We'll have 3 minutes each. And when we've finished with public comment, we'll return to you for your questioning. Thank you.
I'll agree. Thank you.
Okay, it is 1 p.m. and my name is Felicia Orth, hearing officer appointed by the Environmental Improvement Board to conduct a hearing in EIB 24-49. The matter relates to regional haze requirements. We have reached one of the times we set aside for non-technical public comment. Just a few things. We do have a court reporter making a transcript. We have a team of interpreters interpreting between Spanish and English. I'll ask you to go just once, to limit your comments to 3 minutes. In the event you have more to say than that, please submit your comment in writing to Pamela Jones before we adjourn. I'm not sure when we'll adjourn. I'm not sure there will be another comment period. If we somehow finish before 5 p.m., we will not. If we're still going at 5 p.m., there will be another public comment period. So the names I have, and I'll call on you in this order: Clara Sims, Maud Dinan, Sister Joan Brown, and Carlos Matutes. Ms. O'Grady, would you please offer a few comments to those who might desire interpretation? Right, just to let someone on the platform know that that there is a channel in which interpretation is being provided.
Thank you. Buenas tardes. Para cualquier persona que está compareciendo por internet, tiene a su disponibilidad canales de interpretación. Entonces, si quiere escuchar la interpretación en español, por favor, Mire en su esquina inferior a la izquierda y aparece ahí un mundo. Haga clic en el mundo y de ahí puede seleccionar español.
Thank you very much, Ms. O'Grady. So, is Clara Sims on the platform or in the room?
I am.
Great. Thank you very much. Ms. Sims, would you please spell your first and last name?
Yes, CLARASIMS.
Do you swear or affirm to tell the truth?
I do.
Thank you very much. Go ahead.
Thank you to the Environmental Improvement Board for hearing public comment today. My name is Claire Sims. I was born and raised in Los Lunas. I work on the staff of New Mexico Interfaith Power and Light, and I also serve as a minister in the United Church of Christ. I'm speaking today in strong support of NMED's proposed Regional Haze State Implementation Plan. Alongside other faith leaders, I have traveled to areas in southeastern New Mexico to witness specifically how these communities are impacted by industry pollution, such as sulfur dioxide, nitrogen oxides, and the particulate matter pollution herein understood as haze. I was shocked that the hazy, polluted skies I witnessed while traveling around Carlsbad were considered normal and even better than normal. We all have a fundamental right to breathe clean, unpolluted air. Not just humans, but all communities of creation have this fundamental right. The core values of my faith tradition and many others uplift not only the imperative to care for neighbor as self, but to care for the most vulnerable with unceasing dedication. From the city of Carlsbad to the caverns to Mesa Verde and the Guadalupe Mountains, all these communities of life are being made vulnerable by industrial pollution sources, and from oil and gas operations especially. NMED's proposed Regional Haze State Implementation Plan is a strong and necessary step toward protecting these communities with common sense measures such as replacing outdated equipment and requiring additional analysis and implementation of haze reduction measures. In a time when our federal administration is jeopardizing environmental protections for communities at so many levels, bold state leadership is more important than ever, and I hope the Environmental Improvement Board will lead with moral integrity and support the strongest Regional Haze State Implementation Plan as is possible. Thank you for your time.
Thank you, Ms. Sims. Maud Dinan?
Good afternoon.
Hello. Would you please spell your first and last name for the transcript?
Sure. M-A-U-D-E. Last name is D-I-N-A-N.
Thank you. Do you swear or affirm to tell the truth?
Yes.
Thank you very much. I'll start your 3 minutes.
Thank you for the opportunity to comment today on New Mexico's second planning period for the Regional Haze State Implementation Plan. My name is Maud Dinan, and I am the New Mexico Program Manager for the National Parks Conservation Association based in Las Cruces. NPCA is the oldest and largest nonpartisan, nonprofit advocacy organization for our national parks, with over 1.6 million members and supporters across the country, and 13,000 here in New Mexico. Along with my comments today, I have submitted a community letter with 13 organizations expressing strong support for the plan. As written, it is one of the strongest in the nation and will make important progress toward our national visibility goal by reducing more than 17,000 tons of nitrogen oxides and 5,000 tons of sulfur dioxide annually from facilities across New Mexico. Thank you for your commitment to the state and leadership for others. Here in New Mexico, the vastness is as big as the sky, with views of rolling grasslands, sage steppes, mountains, and canyons. Echoes of this land's layered history booms across the stillness. There is truly no place on earth like New Mexico. Visibility preserves these inspiring experiences, while in places like the Greater Chaco region, being able to see geological formations in totality is of crucial importance to individuals with cultural ties to the landscape. In addition to the value of our mind, spirit, and heritage, the plan has great potential to protect our physical health too. The pollution that causes haze also contributes to ozone and can harm our lungs. New Mexico has multiple cities and counties that rank among the worst in the nation for ozone pollution, according to the American Lung Association. New Mexico has for too long been treated as a sacrifice zone for activities such as nuclear testing and outsized extractive industry, resulting in degraded health among residents with disproportionate impact to rural and indigenous communities. This plan can act as one of many avenues to correct this history and elevate the importance of residents' well-being to that of industry. Now, a robust plan does not mean negative impacts to our economy, but the opposite. Carlsbad Caverns National Park, one of New Mexico's 9 Class 1 areas, alone brought in over $29 million in visitor spending and supported 359 jobs. Yet Carlsbad Caverns ranks 4th in most polluted parks for regional haze out of 399 across the country, according to NPCA's 2024 Polluted Parks Report. When air quality at national parks is polluted, visitation can drop by up to 8%, harming local economies and businesses. Right now, we have a once-in-a-decade opportunity to preserve scenic vistas, keep New Mexico's tourism thriving, and protect the health of all who live here and enjoy New Mexico's treasured public lands. Thank you so much for your time today.
Thank you, Ms. Dinan. Sister Joan Brown?
Yes, I'm here.
Hello. Would you please spell your first and last name?
Yes, Joan, Joan, Brown, Brown.
Do you swear or affirm to tell the truth?
Yes.
Thank you. I'll start your 3 minutes.
Thank you. Thank you, board and a hearing officer today. My name is Joan Brown. I'm a Franciscan sister, and I am the former director of New Mexico and El Paso Interfaith Power and Light. And I continue to work on oil and gas and other concerns of our communities and this lovely state that we live in. This hearing is really important because it affirms the need for strong leadership in caring for our sacred and precious lands that millions of people visit as a source of healing, awe, nourishment, and hope. And many of our parks are concerned, and I'm especially concerned about Carlsbad Caverns because it's hugely affected by the haze pollution emitted from New Mexico's industrial facilities, and the area has been in ozone non-attainment for quite some time. These days, as we remember the passing of Pope Francis, I have been reflecting a lot on his call to care for creation, and remembering last year he spoke very disheartened, with a disheartened spirit, lamenting that we hadn't done what we need to do, and things just keep getting more and more urgent. And he said there is a need to act with urgency, compassion, and determination, since the stakes could not be higher. This hearing and this state plan is part of something we can do in these high stakes we're living in. I'm speaking strongly about Carlsbad Caverns because I go there very often, and at least twice a year I lead a people of faith groups with New Mexico and El Paso Interfaith Power and Light on an immersion retreat experience. And we always begin at what we call the Cathedral of the Earth, Carlsbad Caverns. However, Carlsbad Caverns currently ranks number 4 for hazy skies and 5th for unhealthy air out of the 399 parks nationwide. And I don't believe this is how we should treat these sacred places, which we have a sacred trust to the future for. And those who visit the caverns in that region are very aware of the haze, and they're very concerned for the communities living there. Natural gas processing plants and oil and gas operations emit the most haze-causing pollution in New Mexico. And as I say that, NMED has released a strong draft plan for the state implementation, and it highlighted 23 facilities for haze emission reduction analysis and action, including natural gas processing plants and oil and gas compressor stations, of which we see a lot of when we go down to that region. But the action is only proposed for 13 facilities for installation of pollution controls, in my understanding. I'm wondering why not all 23? We're very grateful for the constant work of NMED and tirelessly working with limited resources and staff facing humongous industry challenges because we're the second largest oil and gas producing state in the country. We do support a very strong plan and the continued work of NMED, including enforceable retirement of any sources currently excluded from an analysis of emissions reduction measures. And several examples of this that have been brought to my attention are the Cunningham State Power Plant and the South Carlsbad Compressor Station, stationary combustion engines. So when we go on these immersion retreats, we see tons and tons of facilities. We also experience a lot of pollution that contributes to the haze problem we have at Carlsbad and Guadalupe Mountains and areas around there. We'd also like to really draw attention to a concern for health and well-beings of the communities there and invite a thorough assessment of impacts of haze pollution for these communities. So we're very grateful for steps that NMED is taking and encourage continued ethical and moral leadership to care for our common home. Thank you.
Thank you, Sister. Carlos Matutas.
Thank you very much.
Hello. Would you spell your first and last name, please?
Yes, first name is Carlos. Last name is Matutes.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your 3 minutes.
Thank you very much. Thank you, board members, for your service here. We really do appreciate the work that the EIB is doing and that NMED has done throughout our history. My name is Carlos Matutes. I am the New Mexico State Program Director for Green Latinos. We are a national environmental justice organization focused on the well-being of Latina communities and other communities of color. I will not repeat what the previous speakers have so eloquently stated. I will talk a little bit about what this anti-haze work is going to do for our communities. First of all, I'd like to acknowledge that both nitrogen oxide and sulfur oxides are hazardous to the well-being of folks, especially communities living in close proximity to the pollution sources. As a previous speaker has stated, these also lead to ozone pollution, which New Mexico has at much higher rates than other states. Those pollutants impact Latina and indigenous communities at a much higher rate, in part because of proximity. We are doing this not just for the aesthetics of that are impacted by haze, but we're talking about the health of New Mexicans. However, not just the physical health of New Mexicans, but the mental and emotional health of being able to look around and to be able to see the beautiful landscape, which is a big reason why many of us live here. We have a staff member in Roswell who's lived there for over 60 years, and she has noticed the massive degradation in sight lines because of haze pollution. This is something that she can step outside and take a little bit of a respite from a very, very stressful world that we're all living in right now. But when she can't even see the mountains from her backyard, we have a problem. Another thing that I'd like to bring up is that these pollutants also increase degradation of those landscapes, of cultural spaces, of relics like the petroglyphs that we find around our state. We do encourage retirement of these facilities. We do encourage that we take every step possible towards reducing the pollutants that cause this haze and cause the degradation of our health, our welfare, and our landscapes. Thank you very much.
Thank you, Mr. Matutas. Is Caitlin Miller on the platform at this point?
Yes, I am. Hi, I think you read my mind. I was going to ask if I might be able to give comment now, since it
Yes.
sounds like we might not go until 5 today. Great, thank you.
Yes. Spell your first and last name for the transcript.
Yes, I'm Caitlin Miller. It's CAITLINMILLER.
Thank you. And do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your 3 minutes.
Good afternoon, everyone. I'm Caitlin Miller, the Associate General Counsel for Clean Air and Climate with the National Parks Conservation Association. Throughout the hearing, you've heard a lot about the scope of NMED's authority and what the agency can and cannot consider in the state's regional haze SIP. I want to address 2 topics on NMED's authority under the Clean Air Act's Regional Haze Program. First, party claims that NMED should have considered visibility as a 5th factor, and its 4-factor reasonable progress analyses are incorrect. In the Clean Air Act, Congress set forth 4 and only 4 statutory reasonable progress factors that NMED must consider in its analyses for this planning period. 1, the cost of compliance, the time necessary for compliance, the non-air environmental impacts of compliance, and the remaining useful life of the source. None of these factors includes the visibility impacts of controls. This is in stark contrast to Congress's explicit direction that states consider visibility in their 5-factor best available retrofit technology, or BART, analyses that were conducted in the first planning period. It's a long-standing rule of statutory interpretation that where Congress includes a requirement in one provision of the Act but excludes it in another, that exclusion is intentional. Here, Congress intentionally did not include visibility as one of the 4 reasonable progress factors. If NMED considered visibility in the ways that parties have requested, that consideration would violate the Clean Air Act, and any references to EPA guidance to the contrary cannot override the statute's plain language. Second, nothing in the Clean Air Act or Regional Haze Rule limits the types of controls that NMED may consider under the haze program, including replacement of old dirty emission units with new units. The Clean Air Act and the Regional Haze Rule both broadly provide that SIPs must include emission limits, schedules of compliance, and, quote, other measures as necessary to make reasonable progress toward the natural visibility goal. This other measures language directs states to consider the full range of potentially available controls for purposes of regional haze. Party arguments pointing to statutory, regulatory, and guidance language here are misplaced, as that text either does not apply to NMED's 4-factor reasonable progress analyses for the second planning period, or does not evince any intent on the part of Congress or EPA to limit the types of controls NMED may consider. Additionally, the Natural Gas Act explicitly does not preempt state authority under the Clean Air Act, and courts have held that that statute does not prevent states from requiring facilities to comply with state SIPs under the Clean Air Act. NPCA strongly supports NMED's regional haze SIP, and we request that the board adopt the SIP as proposed without modification. Thank you.
Thank you very much, Ms. Miller. Is there anyone else on the platform who would like to offer public comment at this time? This may be the last opportunity, I'm not sure. No? Is there anyone else in the room who would like to offer public comment? No? All right. Pam, if anyone reaches out to just let me know. We'll try to work something out after we return to the technical case here. So let's return to the technical case. When we broke, Mr. Tureen, who is on the platform, had finished his testimony, and we were about to turn to questioning. So, Mr. B. Hill, do you have questions, Mr. Tureen?
Good afternoon, Mr. Tureen. Do you agree that NMED has jurisdiction with regard to enforcing the Clean Air Act over EPNG's facilities in New Mexico?
Objection, that's a legal question.
All right. So, Mr. B. Hill, you objected a couple of times to the elicitation of legal testimony. We tried to navigate that issue. At this point, I guess, and I'm wondering, we're not seeing Mr. Tureen on the screen, Pam. We see Member Ely and members, Madam Chair. I don't see Mr. Tureen.
Can you hear me?
Yes.
Okay, let me just restarted my video. Does that work?
Not yet. Oh, let's see. There you are. Okay. Pam is going to pin you. There you go. Mr. Treen, would you be able to follow the same guidance that you followed on your direct, which is to the extent you have an answer as someone in charge of regulatory affairs, you can answer to the extent this is something you would go to your lawyer for, that you say it's not something that you can answer today.
Yes.
Does that make sense? Okay, thank you. Go ahead, Mr. Behill. Repeat the question and we'll get his answer.
As you in your position, do you deal with New Mexico's authority as the primary enforcer of the Clean Air Act?
No, firstly, I'll defer to my attorney to answer that question.
Okay. If every single compressor at Blanco Way were to malfunction in such a way that they could not be repaired, would the facility have to stop operations permanently and submit permission to abandon and wait until FERC gave authorization for abandonment?
If all of the compressor engines were to cease to operate, El Paso, would evaluate or assess the need for replacement. How El Paso opts to replace the unit, whether restoring the same amount of horsepower, less or more, are other considerations that must be taken into consideration. Ultimately, those factors, those variables will dictate, I believe, the regulatory process path, if you will, on whether or how to replace the compressor units. There will be other factors to consider as well, for future need for the facility, for example. But those are all collectively assessments that would be made by El Paso itself, not necessarily, by me, and part of my responsibilities as well.
And so is there another process that, as you're assessing this for El Paso Natural Gas, is there another process by which you could replace an engine under the Natural Gas Act?
Certainly, if the company will decide to replace a compressor unit, there's a regulatory process that would allow you to do so. There are various regulations that would facilitate a replacement of a compressor unit, so long as it meets the requirements associated with each of those regulations.
So, if I'm correct, what I'm hearing, excuse me, what I'm hearing you say is that there are two separate processes, at the very least, one for replacement and one for abandonment. Is that correct?
That is correct.
Okay, I have no further questions. Thank you.
Ms. O'Grady? All right, she said no questions. Mr. Harris? No questions for Mr. Harris. Ms. Wood? No questions for Ms. Wood. Ms. Catalano? All right, no questions from Ms. Catalano. We'll turn then to the board. Let's start. Member Garcia, do you want to kick us off?
No questions, thank you.
All right, Member Hunker.
No questions.
Member Bitzer.
Just one, if we got to the point where a abandonment became the path, what are the criteria for being able to object? Does anybody have standing, or is it do you have to have dog in the fight or whatever? And what are the odds of such an objection happening?
Mhm.
Ballpark guess.
Yeah, let me, I'll rephrase your question so that I understand what you're asking. So you're asking if EP&G were to move forward with the abandonment, what party what kind of party would have any kind of standing or raise issues, right, to protest the proposed abandonment? Is that, okay, yeah. So the proposed timeline that was described in my testimony for abandonment is one which is a prior notice application, right? And as the name suggests, El Paso would be required to make a prior notice filing with the commission. This process in itself, gives any interested party the ability to come in and offer comments, intervene without no further comment, or to protest, the proposal. And so because it means any party, that's exactly what it means. There have been instances in other type of prior notice proceedings that I've been involved with where parties, would submit comments and that would be adverse to a proposal that would be considered as protest. So it's hard to really define which or what kind of party, but the regulations really are somewhat open-ended at the FERC level that really allows any party that has an interest, if you will, in that proceeding to come in and protest or oppose your proposal.
So part two of that is given the fact that pretty much anybody can protest, you imagine that the odds are pretty good that would happen then?
Generally speaking, if as a pipeline, we address the issues that may surround the abandonment, and particularly in this instance, maybe the service issues. Shippers, customers of El Paso Natural Gas, would have an interest in the proceeding, and to be prudent and to mitigate the risk of opposition. We reach out to potential customers that will be affected by our proposed abandonment. And so, that while we would try to do that and reach out to customers and try to address their concerns, to avoid any potential protests in the proceeding. So from the commercial standpoint, if you will. So.
All right, Vice Chair Trujillo.
Yes, thank you. I'm going to kind of follow along with Member Bitzer here. So in the, as you evaluated the possible abandonment of this facility, have you looked at how it would affect compression in the region and upstream operations?
From a FERC regulatory standpoint, what we are tasked with is assessing whether there will be any adverse impacts on El Paso Natural Gas customers. So that assessment, we'll look at capacity impacts, with taking away those two compressor stations. So the assessment, the evaluation would be limited to that, and we would have to demonstrate that there would be no adverse impacts to our shippers. I think what you're asking is, do we go and look at compression impacts further upstream or downstream? In assessing impacts to customers, you assess some of that, but it's hard to gauge or measure how far upstream you would look at potential impacts from that. And so, does that answer your question?
Yes, generally it does. So in kind of pivoting there on away from the idea of abandonment, if you did have to replace the engine, the units, I realize there are multiple pieces. If you had to replace the units, would you then have to enter a new permitting process? I'm just kind of looking for some understanding of the
Yeah,
next steps there.
yeah, certainly for a replacement of compression. There are numerous factors that the company will take into consideration to determine, what regulatory path you're going to take. It could be as straightforward for a replacement, right? And I'm not saying that this would necessarily apply to this proposal for the 2 units at Blanco, but for replacements that would involve, let's say, smaller compression, you could move forward with a replacement with submitting a report after the fact of the replacement. Because compressors generally tend to be more expensive these days and are getting more expensive, a straight up replacement where the replacement takes place within the same compressor station facilities and property lines. And if it meets that requirement, you would be able to submit an advance notice of your proposed replacement with the FERC. And that would be just a notification, right? If you get into situations where you need additional workspaces, meet certain parameters associated with workspaces, then you would kind of end up in having to submit a prior notice application for the project, similar to what it would be for an abandonment. And so you would kind of face the same issue. So there's no straightforward one answer that I can offer, given that there would be several additional questions that would have to be addressed to be able to determine, which regulatory path with FERC that could be taken.
Okay, and I'm sorry, I'm just gonna kind of back up and ask you a different question here about your background. I understand you've mostly talked about FERC. Do you also work within the regulatory processes of the state of New Mexico as well with NMED and with OCD and the rest of the alphabet soup there?
No, I don't. My responsibilities are focused on managing FERC regulatory compliance issues and Natural Gas Act compliance issues. On a very periphery, I interact with people with the expertise at the state level, but my responsibilities are not in those areas.
Okay, thank you very much. I appreciate your time.
Thank you.
Member Ely.
I have a few questions. Good afternoon, Mr. Terrain.
Good afternoon.
I just need a little clarification based on the line of questioning from Vice Chair Trujillo. I think you said a replacement of an engine would just require a notification to FERC, and abandonment would be a different process.
Yes.
The department is suggesting I believe, replacement of these engines. So why would that have to go through an abandonment process?
Well, it wouldn't, let me answer, it wouldn't necessarily go through an abandonment process. So for a replacement, there's a regulatory path that will allow an interstate natural gas pipeline to replace a compressor station. Let's say at an existing station, you have your existing station, right? And if you're replacing your horsepower with the same amount of horsepower, right, that allows the pipeline to maintain that same capacity, the pipeline, and let me add also the function within the interstate pipeline system. That's another factor to consider. You'd be able to undertake the replacement itself. Either, right now, I'll say either, with a self-implementing clearance, where if the cost of the project is below a certain threshold, the pipeline is allowed to replace it and then report that replacement in the subsequent year. Okay, that's one option. Similarly, if the cost of the project, right, that you're replacing that compressor station, but the cost, of replacement is I'd say just throw around a number, $40 million. Then the pipeline is required to submit an advance notification for the replacement. And I'll emphasize that it would be a notification to FERC, right? That this is the replacement I'm going to take. Those two examples are based on the pipeline company not requiring any additional workspaces or what have you, right? It's going to be within your existing property line. The workspace issue is important with FERC because that kicks in NEPA-related analysis that need to be taken into consideration. But to the point I made earlier, if the replacement, for example, requires the pipeline company to go out and expand its footprint of the compressor station to install the replacement compressor stations, then if that's going to be the case, that workspace requirement kind of eliminates the two previous options. And so because of the cost itself, right, it would likely be elevated to a prior notice type filing. Prior notice type filings are applicable, for this type of replacement that we're discussing, but the prior notice is a process that would also be applicable for abandonment of a facility, right? So that it would follow the same track, right, as it would for an abandonment, for the criteria that I just described to you. So it would follow that prior notice process that requires the applicant to submit a prior notice application that would be noticed at FERC for a certain period of time and allows the public to come in and submit comments in support or in opposition of that proposal.
Okay, so it has something to do with cost of replacement and additional workspace requirements as far as what bucket it goes into as far as notification or abandonment.
Right, without getting into all of those details. Yes, ma'am.
Yeah, I don't need to go into that. Fair enough. So I'm looking at the Appendix C, and it looks like there are 14 engines out there that are all about 70 years old, similar engines with 943 horsepower. It also looks like a number of them haven't operated for many years or during many years. For example, 8 didn't operate at all in 2020, 2021, or 2022. They're still in place, but they're not operating. So that's clearly wouldn't be an issue of abandonment. But is it possible? I guess this would be an engineering question. Of those engines that haven't operated, couldn't those operate and make up for the compression for the time period, say when 11 and 13 were being replaced?
If I may, that may be a question better suited for one of our engineers at our facility.
Okay. But if that were possible, that wouldn't be an abandonment issue because there's no consideration of space for costs.
I think from a straight up FERC interpretation, each engine is certificated at a certain horsepower, right? So as you pointed out, we have 14 engines, and I don't know the exact horsepower rating for those engines, but I'll just assume for simplicity purposes, I'll just say each one has 1,000 horsepower associated with it, right? The fact that they're not running is not relevant to the fact that they're certificated, right? The operation and the certification are apples and oranges. From a FERC standpoint, if you eliminate, those 2 of those 14 engines, you are taking away 2,000 horsepower capability, right? So while to your point, operationally, you may be able to run, but from a certificate standpoint, you're taking away, the available horsepower that it has been previously certificated. So.
Okay.
Okay.
I think I get that.
Yeah.
So the rule gives you 3 years to come into compliance if the board adopts it. And that is from the time that EPA approves the SIP, if they approve of the SIP. So is that not enough time to go through a certificate process with FERC? 3, maybe, just say generously 4 years, maybe.
Yeah, well, generally speaking, right, El Paso Natural Gas would not move forward from a filing standpoint, with the proposed abandonment of those engines until, the requirement, the law, the statute becomes effective, right? So to the extent that's going to be the case, then, this rulemaking process and its finalization may take, as you're pointing out, 3 years. EP&G would not move forward with the abandonment until the rubber hits the road, if you will. And so from that point forward, if it becomes law, we move forward with submitting an application, right? In my estimate and timelines, that 10 to 18 month period, if the application would be protested, we required that amount of time, right, to be able to prepare an application, submit an application, and if there are protests, kind of move through those processes. I mean, stranger things have happened in the FERC world, and it could take longer, right? We cannot control that timeline, but that should be generally factored into whatever decision that the interstate pipelines rather, need, that additional time, to be able to secure the necessary FERC approvals for the abandonment.
Okay, so you wouldn't, until EPA approved, you wouldn't start that FERC process, and 3 years may or may not be enough to get into compliance. Did you tell NMED that what a reasonable compliance timeline would be for El Paso?
Other than what my testimony suggested on the worst case scenario, protest is proceeding that 18 months. No, I have not.
Okay, that's it. Thank you so much for your time.
Thank you.
All right, thank you. Chair Sweeney, and just a reminder to all questioners and all witnesses, please don't step on the end of the other person's sentence.
Thank you, Madam Hearing Officer. I don't have any questions at this time.
Oh, all right, thank you, Madam Chair. Let's see here. Any other board questions at all? Any reason not to excuse Mr. Tareen?
Could we have redirect, please?
Oh, all right. Go ahead, Mr. Miller.
I'll defer to my colleague.
Thank you. Mr. Tari, just a couple of follow-up questions. There's been discussion about the FERC replacement process. Sorry, I just hate this, like not seeing who I'm speaking to. The FERC process for replacement and then the FERC process for abandonment. Here, isn't it true that the request from any NMED is replacement, and because replacement is infeasible, it is in effect a request for abandonment? Is that true?
That is true.
Thank you. So all the testimony you just provided in response to questions about what is the process that would apply would be the FERC abandonment process that carries those longer timelines. Correct?
Correct. That is correct.
Thank you. And then one follow-up question is, if something like the abandonment process were required of EP&G and Kinder Morgan, is it true that you would bring to the table the FERC expertise, engagement with your commercial customers, but you would work very closely with the Kinder Morgan and EP&G environment team, very closely with those folks who are grounded here in New Mexico from the engineering side, the folks in New Mexico who are working with regulators. So it's a team effort that would respond to that issue.
Yes, it would be, as you're pointing out, a collaborative effort with all the different expertises within Kinder Morgan.
Thank you. And I think that's all we have for Mr. Tati.
All right, thank you. Any reason not to excuse him now? No? All right, thank you very much for your testimony, Mr. Attorney.
Thank you.
Ms. Gutierrez, before you move to your next witness, I'd like to take a single public commenter who joined since the session ended. Is Roger Harmon on the platform? Mr. Harmon? May have left. All right, Pam, if he rejoins, let me know. Okay, Ms. Gutierrez, your next witness, please.
Yes, I would like to call Mr. Tom Mitchell, please.
I'm here.
Thank you. Let me go ahead and get slides up and running. Oops, can I make content sharing available, please?
Mr. Mitchell, would you spell your first and last name for the transcript, please?
Yes, it's Thomas, Thomas, or Tom, Tom, Mitchell, Mitchell.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Ms. Gutierrez.
Just 1 minute for technical difficulties, if you may. It's catching all of my slide decks, so I'm going to close them out and try and just have the one open. Apologies for the delay. Okay, great. Mr. Mitchell, can you please introduce yourself for the record?
My name is Thomas Mitchell. I am the Air Permitting and Compliance Manager at EPNG's parent company, Kinder Morgan Inc. In that role, I have developed considerable expertise.
Sorry, your audio.
Yeah, hold on, Mr. Mitchell. Your audio is muddy. Maybe move forward toward the microphone.
Is this any better?
Okay, yes, it is. Thank you. Please repeat what you said a moment ago.
Sure. My name is Thomas Mitchell. I am the Air Permitting and Compliance Manager at EPNG's parent company, Kinder Morgan Inc. In that role, I have developed considerable expertise in understanding air quality regulatory regimes and control technologies. I have a total of 38 years of experience in an engineering capacity.
Thank you, Mr. Mitchell. Did you previously file pre-filed written direct testimony in this proceeding?
Yes.
Are there any corrections to your pre-filed testimony?
No, I adopt my pre-filed technical testimony in full here.
Thank you. Would you please summarize the direct testimony you plan to give today?
Sure, I will explain why replacement is not appropriate. Second, any proposed requirements have to be technically feasible, and replacement at Blanco A is not feasible. Last, I explained that the department did not consider negative impacts from ammonia slip.
Thank you, Mr. Mitchell. Could you now discuss replacement at Blanco A being inappropriate?
Yes. Throughout numerous sources and in the department's own testimony, the Regional Haze Program refers to controls. Controls refers to technology that are added onto existing source to improve its emissions performance. But controls do not refer to replacing an existing emission unit outright. And never, not once, does any precedent, guidance, or other direction suggest that it would be appropriate for New Mexico to require replacement. On top of that, replacement at Blanco A is not feasible. This is a simple concept. It's beyond dispute.
Hold on, Mr. Mitchell. Ms. O'Grady. Yeah.
I might have gotten to the mic too late, but just objection on replacement as a legal matter that should be drawn by attorneys and not by technical witnesses.
All right. Ms. Gutierrez,
Yes.
what would be the basis for him discussing that?
And in two responses to that, one is that this is Mr. Mitchell's experience as he is working through the regional haze and four factor analysis. And the second being, I think we heard quite a bit of testimony from the department's witnesses about how the Clean Air Act regional haze program works. They are not lawyers, but they opined and gave summaries of how we operate under the program. I think this is equitably presented in this hearing.
Okay, I'm noticing that Mr. Mitchell is the air permitting and compliance manager for EPNG. And I think as a permitting and compliance manager, his work and his personal experience would touch quite a bit of law. So same instruction, Mr. Mitchell. If you heard the discussions with Mr. Tyree, please answer from your personal experience and your understanding from your work. And the board knows that you're not an attorney. Thank you.
Understood.
Mr. Mitchell, we are on slide 6 if you'd like to run from there.
Okay. Starting from the top, then at slide 6. On
Yes,
top of that, replacement at Blanco A is not feasible. This is a simple concept, it is beyond dispute, and the department agrees that the Regional Haze Program does not require companies to undertake infeasible projects. And EPA's guidance says the same. The ask has to be technically feasible. For Blanco A, it is not. For Blanco A, the compressor building itself cannot accommodate any new units because of vibration, safety, and space constraints. Then looking beyond the compressor building itself at the whole Blanco A site, you see that there's nowhere to add additional engines and compressors where the piping would not interfere with existing piping. And even if it were possible, it would be much more expensive. Mr. Trent will go into greater detail on this topic.
thank you, Mr. Mitchell. Based on your testimony, what do you recommend the board, how do you recommend the board proceed concerning Blanco A?
I recommend and urge the board not to adopt any emissions requirements for Blanco A for multiple reasons. Replacement is not a permissible strategy under regional haze, in my opinion, and it is infeasible to replace engines at Blanco A.
Thank you, Mr. Mitchell. I believe the next item you wanted to address was ammonia slip. Could you address that now, please?
I'd be happy to. Just so everybody knows, on screen is an ammonia molecule. And to orient us, we're talking about ammonia because ammonia is required for use in SCR. And the department is proposing to require SCR for Pecos River. As part of the SCR chemical reaction, ammonia is used as a reagent. The SCR system needs to monitor conditions to ensure the right amount of ammonia is injected at all times. But even with the best system, some ammonia makes it through the SCR system unchanged and is released. This release is called ammonia slip. Unfortunately, ammonia itself causes a number of negative effects on the air. It's a precursor of particulate matter like PM2.5, and PM2.5 has visibility impacts and negative effects on human health. There are additional specific federal safety regulations required for the safe handling of ammonia. Thus, the department should have done some assessment of the trade-off between NOx reductions and ammonia slip emissions to make sure that it was at least not making matters worse. The department did no such analysis, nor did it consider the cost of compliance with the required ammonia safety regulations. In addition to the air impacts, ammonia itself is quite hazardous and would need to be shipped on public roads in large tanker trucks like you see on screen. We calculate that approximately 27 truckloads per year would be required. Trucking is subject to its own limitations and regulatory requirements. This is another downside of ammonia that the department did not consider, but we encourage the board to consider. I recommend that the board conclude that any requirement to install SCR is unsupported at this time. The department simply has not evaluated the downsides associated with ammonia.
Thank you, Mr. Mitchell. Would you please summarize your direct testimony recommendations for the board?
Yes, bottom line is that both Blanco A and Pecos River should be excluded from any final SIP. In my opinion, the department does not have the authority under the Clean Air Act to require replacement of the engines at Blanco A, and regardless, replacement is not feasible. Additionally, SCR is inadequately supported by the department's evaluation for the reasons I have discussed and for other reasons discussed by EPNG witnesses.
Thank you, Mr. Mitchell. And if we just give me 1 second, we will transition to rebuttal testimony. Apologies for the delay. PowerPoint is rebooting. Okay. All right. Mr. Mitchell, did you previously file pre-filed rebuttal testimony in this proceeding?
Yes.
Are there any corrections you'd like to make to your pre-filed rebuttal testimony?
No, I adopt my rebuttal testimony in full here.
Would you please summarize your testimony in this rebuttal?
I address 2 points, and my testimony will be brief for the benefit of the board. The first is ammonia slip, and the second is whether SCR in the natural gas pipeline sector is in fact prevalent.
Earlier, you stated that NEBD admits that ammonia slip occurs. Could you please explain that here?
Yes, the department Mr. Rob Seidner, directly acknowledges this, as shown by his direct quote on the slide.
Is this relevant to the proceeding?
Yes, it is very relevant. The entire purpose of this regional haze rulemaking is to address visibility impacts in Class 1 areas within the state. As the department's proposal makes clear, particulate matter causes a large share of the visibility impacts in those areas. Ammonia emissions are a precursor to particulate matter. The department has not performed any modeling or other analysis to understand whether the increased particulate matter caused by ammonia emissions would overwhelm the benefits of its NOx emission reductions.
In your opinion, what should the department have done?
I think to pass a rule that reasonably considers the important aspects of the issues, the department should understand the amount of visibility trade-off that ammonia causes compared with NOx reductions. That's the bare minimum to be reasonable. If the department did do such an assessment, it would also have been helpful to then incorporate these results in the dollars per ton estimates that the department ran. For an example, an SCR found to be cost effective at $9,000 a ton might actually have visibility benefits that cost $18,000 per ton once the drawbacks of ammonia emissions are accounted for. The record is devoid of any type of this analysis on the topic.
And a couple follow-ups on that point. Is it true that there's a 10 ppm limit for ammonia, I think deriving from the Part 50 ozone precursor rule?
Yes, there's an ammonia slip requirement, maximum of 10 ppm.
Did the department use the 10 ppm rate to calculate the estimated ammonia emissions that would occur from your application of SCR?
No, not to my knowledge.
So does that mean that the department also did not include those estimated emissions in their cost per ton analysis?
That is correct.
Which means there may be some emissions missing, which could artificially lower the cost per ton value that they estimated. Is that correct?
That is correct.
Thank you. And you stated that the second issue you intended to discuss is the prevalence of SCR in the natural gas pipeline sector. Can you elaborate on that point, Mr. Mitchell?
Yes, I want to respond to the department on this point and to bring to bear EPNG's deep experience in this area. Kinder Morgan operates approximately 430 natural gas turbines. Of those 430 turbines, none have SCR installed. So it is not accurate to say countless facilities have installed SCR when talking about interstate natural gas pipelines.
Might Mr. Seidner have been referring to other sectors of industry?
I imagine he was referring to SCR installed in the electric generation sector. In that context, while I am not an expert in the electric generation sector, my understanding is that SCR is more common in the industry. But those are very different types of systems and units. The fact of the matter is that SCR is very uncommon for mechanical drive turbines.
Fair enough, Sir. Sorry.
Yes, ma'am.
We submit Mr. Tom Mitchell for a question.
Thank you very much, Mr. Mitchell and Ms. Gutierrez. And Mr. Behill, do you have questions?
Good afternoon, Mr. Mitchell. I asked to see the slide, the summary of positions slide, please, if council doesn't have any objection.
Of course. Give me 1 minute.
That's for the rebuttal.
Oh, what's that?
The rebuttal to direct.
It's for direct, I think, yes.
I closed that one, so just give me 1 minute. That should get us mostly what we need.
Oh, that's it. Thank you so much. Mr. Mitchell, in item 1 on the summary of positions, excuse me, you offered the legal conclusion that the replacement of Blanco A is unlawful. Is that correct?
No, I offered my opinion that it was unlawful.
Thank you. And you say that the CAA of the Clean Air Act only authorizes controls. Is that correct?
Yes.
Okay.
In my opinion.
The CAA does not have any such provision that exclusively authorizes controls. Is that correct?
It is my understanding the Clean Air Act and all its subsequent regulations does not allow replacement.
Let me ask you, that was not my question. My question is this: the Clean Air Act does not have a provision that exclusively authorizes controls and explicitly disauthorizes replacement. Is that correct?
I will defer that question to my lawyer.
Okay, thank you so much. But because the Clean Air Act does not exclusively authorize controls to the exclusion of replacement, your testimony on this point is essentially a legal interpretation of various provisions, correct? And that would reflect your testimony as well.
My testimony reflects my opinion.
I see. Can you point me to the provision that that prohibits replacement?
Again, I defer that to my lawyers. I think that is a legal question.
Okay. Were you the one that developed this testimony?
In consultation with my lawyer.
I see. Thank you very much. No further questions.
Okay, thank you. Ms. O'Grady? No questions from Ms. O'Grady. Mr. Harris? No questions from Mr. Harris. Ms. Wood? No questions from Ms. Wood and Ms. Catalano. No questions from Ms. Catalano. We'll turn then to the board. Madam Chair, shall we start with you on the platform?
Sure. I don't have any questions at this time.
All right, thank you. Member Ely?
No questions. Thank you.
Vice Chair Trujillo?
No questions.
Member Bitzer?
No questions.
Member Honker?
No questions.
Member Garcia?
No, thank you.
All right, thank you very much. Thank you, Mr. Mitchell. You would like some redirect?
Just, I think 1 redirect, unless my colleague Mr. Miller has another one. Mr. Mitchell, in your experience in permitting and compliance, in the world of regional haze, has any EPNG or Kinder Morgan facility been requested to replace its facilities to comply as a quote unquote control measure?
No, it has not.
Thank you. No further questions.
All right. Any reason not to excuse Mr. Mitchell? No. All right. Thank you very much, Mr. Mitchell. We did have another request for a single public comment in between our technical witnesses. Is Ellen Casey on the platform?
Yes, I am.
Oh, great. Would you spell your first and last name for the record, please? Oh. You need to unmute yourself, Ms. Casey.
ELLENCASEY.
Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. I'll start your 3 minutes.
I just want to first of all, thank NMED for putting together an excellent SIP on this issue of the haze regulations. It's extremely important to New Mexico. As you know, what we have here is unique, probably in the country and in many parts of the world, in terms of being able to see the clear blue skies. What we would ask for in addition, what I would ask for in addition from NMED, and believe that this would further strengthen the SIP by incorporating the following recommendations, which are including enforceable requirements for any source, retirements for any source that the state excluded from an analysis of emission reduction measures or relies on, at least in part, for pollution reductions, such as the Cunningham Station power plant and the South Carlsbad compressor stations, stationary combustion engines. Because of company retirement announcements that are not binding. Also, because none of the facilities for which the state evaluated additional controls have federally enforceable retirement dates, we would ask NMED to use a longer remaining useful life for the controls in its cost analysis that are in line with what EPA and other states and the facility owner and operators themselves use to evaluate controls. Also, where the department relies on facility-provided interest rate that is different than the bank prime rate to evaluate control costs, NMED should, we hope or we believe, require that the facility adequately support and document its interest rate as required by the RHR. And finally, that the NMED conduct a thorough assessment of the impacts that haze pollution is also having on nearby communities. So that is basically what we think, what I think would strengthen the SIP. And again, we're very happy that you have had this hearing and that you are taking such a strong position on these very important regulations. Thank you.
Thank you, Ms. Casey. Anyone else on the platform who's not already offered public comment, just while I'm at it? No? All right. Ms. Gutierrez, your next witness.
Yes, I'd like to call Mr. James Trent to the stand.
Mr. Trent, if you would spell your first and last name for the transcript.
Yes, first name is James, James. Last name is Trent, Trent.
Do you swear or affirm to tell the truth?
I do.
Thank you.
Shift this way so I can. I think I have tagged. Okay, Mr. Trent, can you please introduce yourself for the record?
Yes, my name is James Trent. I'm a manager of engineering at EPNG's parent company, Kinder Morgan. I have more than 30 years of engineering and design experience. I manage Kinder Morgan's. Oh, sorry. I'll slow down. All right. I'm the manager of engineering at EPNG's parent company, Kinder Morgan, Inc. I have more than 30 years of engineering and design experience. I manage Kinder Morgan's emissions regulation implementation group. In that role, I'm responsible for evaluating new emissions regulations and the technology needed to meet those lower emission requirements. I have hands-on and direct experience in evaluating a wide array of emissions reduction technology and their costs.
Did you previously file pre-filed written direct testimony?
Yes.
Are there any corrections to your direct testimony?
No, I adopt my direct testimony, technical testimony in full here.
Thank you, Mr. Trent. Would you please summarize what topics you'll hit in direct testimony today?
Yes. I discussed the critical role that EPNG plays in New Mexico's energy sector. I then discussed why replacement of 2 engines at Blanco A is not feasible. After that, I discussed in detail the challenges with SCR and high NOx emissions removal rates from SCR systems. And then last, I present vendor quotes and cost estimates for SCR installation at Pecos River.
Thank you. And would you please start by discussing EPNG service to customers in the state of New Mexico?
Yes. So EPNG serves natural gas-fired electric generating stations and natural gas utilities in New Mexico. That means that if you have a gas stove or furnace in New Mexico, that gas may well have been transported by EPNG. Likewise, much of the electricity generated to serve New Mexico customers is generated using natural gas transported by EPNG. In fact, if you look at this slide here, EPNG serves power plants that comprise a total of nearly 3 gigawatts of electricity generation for power plants that serve New Mexico customers. We are committed to this state and its safety and energy security.
Thank you, Mr. Trent. Do you have any recommendations related to EPNG's critical role in the New Mexico energy supply chain?
Yes. I recommend that the board consider EPNG's integral role in New Mexico's natural gas supply chain and should not require EPNG to undertake infeasible or highly costly projects.
Mr. Trent, you had said you intend to address the feasibility of replacement at Blanco A. Could you please turn to that issue now?
Yes. The bottom line is that replacement of Blanco A is not feasible because of very significant site constraints. It is also important to state as a threshold matter that the board does not have authority to require replacement of these units under the Regional Haze program. However, we represent this testimony on infeasibility for purposes of development of the record should the board adopt the department's proposed rule as is. I'd first like to pause on this slide to show the 2 units at issue. We're not talking about the type of engines you might find in a car or truck. These are massive. As you can see from the ladder in these pictures, these are very large machines. Each of these units weigh about 138,000 pounds, which is approximately the weight of 10 full-size grown elephants. And that doesn't include, that's just the unit and does not include the block of concrete underneath it supporting it. And as you can see, then these units are housed in a large building. This slide shows the site layout at Blanco A station. As you can see, there is a compressor building located in the circled area that is located very close to other property on all sides. EPNG does not own the land directly adjacent to Blanco A parcel. I know that's kind of hard to see on the picture, but it's the circle towards the top is the Blanco A station. Typically, when we replace an engine, the old engine would be retired in place. This is for a lot of reasons, including that the cement floor and the entire building is constructed specifically to accommodate that precise unit. That endeavor is tremendously costly. So that was our first concept here: retire in place and expand the building. As you can readily see, that was not an option given the size of these units. Because of the limited availability to expand the compressor building, EPNG also analyzed whether a new engine could be placed in the existing compressor building. That is also not possible. There are 14 engines already in this compressor building, and the building is full. And as noted above, the compressor building cannot be expanded due to the site constraints.
Mr. Trent, I understand from your testimony there's no space to abandon in place and then install replacement horsepower at Blanco A's existing compressor building, and also no space to expand the existing building. But what if EPNG removed the existing engines and replaced them that way? Would that be feasible?
We looked at that as well, and no, that is not feasible. There are other constraints that make replacement within the existing building itself infeasible. First, if we replace the 2 units, we would replace with one single larger unit. This would be the most efficient for our system and from an air quality perspective. However, that new engine runs at higher speeds than all of the other 14 existing engines in Blanco A. Having engines of different speeds operating within the same compressor building result in incompatible vibration issues that are a safety and operational reliability concern. On top of that, a new engine would also require an entirely new emergency shutdown system to be developed. A new emergency shutdown system would require close coordination with adjacent operators to adapt everyone's systems, which would be an incredibly slow and costly process.
Okay, so Mr. Trent, it sounds like you struck out on the first three options. Did you look at locating a new building with new units somewhere else on the property?
Because of the infeasibility of replacing within the existing building, EP&G also evaluated constructing an additional compressor building somewhere else on the length of property owned by EP&G. However, as shown on this slide, and as noted earlier, there simply is no room left next to the compressor building for another building. So EP&G also looked at the potential to use the southern section of the Blanco A parcel, but this is also infeasible. The same emergency shutdown system issue applies there as well. Further, to access that portion of the parcel, there's a significant pinch point where the star is. There is already so much piping, there is not enough room to accommodate new piping within the EP&G parcel. I addressed all these same issues in depth in my written direct testimony and discussions with the department in October of last year. To date, the department has not responded to any of our concerns regarding technical infeasibility.
Now, Mr. Trent, I know you just mentioned that you raised these issues with the department in October of 2024, and then of course in your written direct and rebuttal testimony. Why did EP&G not raise these issues earlier with the department?
There are multiple reasons why EP&G was not able to do so. Performing a feasibility analysis like this is no small undertaking. It requires an interdisciplinary approach because there are multiple levels of systems that might have an issue. I also should underscore that EP&G does not reach an infeasibility determination lightly. If EP&G is going to determine that a project is infeasible, the company wants to have certainty of that fact before stating it publicly. EP&G therefore did not undertake a feasibility analysis until a concrete regulatory proposal was presented, one for which EP&G had time to respond. When the department released its August public review draft of the proposed SIP, the department only gave members of the public 25 days and fewer business days to review and comment. This was not enough time to fully evaluate feasibility concerns. As early as October 2024, however, we had identified feasibility as a material concern, and we raised this with the department in a one-on-one meeting.
And one follow-up question there, Mr. Trent, did EP&G request that meeting with the department?
Yes, we at the October meeting we had with the department, we reached out, asked for a meeting, and we had a one-on-one to discuss some of these issues.
Thank you. Overall, and considering the points you raised, what do you recommend to the board on this issue?
I strongly urge the board not to require replacement of units A11 and A13 at Blanco A.
Thank you, Mr. Trent. Now, sticking with the theme of feasibility, you mentioned that SCR may have feasibility issues of its own. Could you please expand on that?
Yes. First, let me provide a background on SCR. And for context, we are talking about SCR because the department proposes to require 2 units at Pecos River install SCR with an 80% removal efficiency. Select catalytic reduction, or SCR, is what is called a post-combustion control, meaning that it addresses the exhaust gases from an emission source. It is not meant to change the way the combustion process occurs. SCR operates by constantly facilitating a chemical reaction to convert NOx in the exhaust stream into harmless nitrogen and water. The chemical reaction only occurs within a relatively narrow band of conditions that must be optimized constantly. For example, as this figure shows, SCR removal efficiency is directly dependent on temperature. The SCR system needs to operate in the sweet spot temperature to maximize removal efficiency. This is important because the Pecos River turbines have relatively low exhaust temperatures because regenerators on these units extract heat energy from the exhaust to increase their efficiency. I've reached out directly with vendors to understand whether the 80% proposed efficiency is achievable, and the vendors appear split on this. As I mentioned above, EP&G and Kinder Morgan are very careful before claiming that a project is infeasible. For this reason, we're not saying that SCR at 80% efficiency is infeasible, but we are saying that it is largely untested in the natural gas transmission segment, and there are real questions about consistently achieving an 80% reduction. Indeed, EP&G's parent company has approximately 430 turbines and pipeline compression service, but not a single one has SCR installed.
Thank you, Mr. Trent. Can you tell me, why did you go out and seek a vendor quote in support of your submittals related to SCR?
Yes, as my colleague, Ms. Weeman Daly testified, EPA and guidance recommends the use of unit-specific vendor-supported cost estimates over generic cost estimates whenever these vendor quotes are available. As directed by EPA, EP&G relied on up-to-date vendor cost estimates, and the department has not considered those costs to date, with no real explanation as to why. Instead, the department continues to rely on generic, irrelevant cost estimates based on coal-fired boilers of much larger size.
Thank you, Mr. Trent. Can you walk me through the vendor quotes you received and how that impacts the cost per ton analyses?
Yeah. On this slide, I show the total capital cost and annualized O&M costs that EP&G calculated for the 2 turbines at Pecos River, based on vendor quotes. You can see that both the capital cost and O&M costs are far higher than those calculated by the department. Now let's dive into the particular line items in the vendor quote. The large majority of the capital cost from the vendor quote is from the SCR system itself, which is $8 million. That system consists of a number of operational components. As you can see here as well, there are certain economies of scale from addressing 2 SCR systems on the same site. For example, only 1 SCR control system, 1 reagent storage tank, and 1 pump station are required for SCR on 2 units. The other costs for commissioning and training for installation total nearly $250,000, but are necessary so the vendor's expert staff can be on location for the installation and to properly train EP&G personnel. I now want to discuss the items marked in the vendor quote as optional. I want to emphasize that even though these are marked as optional in the vendor quote, that just means that the vendor is not requiring that we purchase those items from that vendor specifically. We could purchase those from some other third party. The vendor knows this and marks them as optional. These systems are not, however, optional for EP&G. To properly operate an SCR system, all of these systems are required. Take, for example, the jib removal crane. We cannot install the SCR catalyst elements without the crane. We either get it from this vendor or we get it from somewhere else, but we will incur that cost. Same is true for the other items on this list. Any engineer familiar with SCR systems is aware of this.
Thank you. Now, Mr. Trent, earlier you stated that the total capital cost for SCR installation at Pecos River is approximately $21 million. How do we go from an $8 million vendor quote for SCR to a total capital cost of $21 million? And as you respond, I'll encourage you to slow down just a little bit.
The short answer is the quote from the vendor for the SCR system is just for the components of that system. The actual equipment itself, so it's just for those components. EP&G would also need to install the SCR system, which comes with significant cost as well. This slide shows 4 of the biggest additional cost components we would incur. First, primary construction covers all the construction work that is needed to install a new auxiliary building for a new air system and the SCR controls. This cost is necessary. Second, a 5% construction contingency reflects uncertainties in construction costs. The EPA control cost manual for SCR provides that a 15% contingency is reasonable. That makes our 5% very conservative. Third, $1.8 million is required to reflect natural gas throughput loss. This is the cost that EP&G incurs from not being able to move gas with the turbine while it is taken offline for SCR installation. Last, capitalized overhead captures EP&G's internal project management cost from a complicated construction project. This cost is reflected in all EP&G construction projects.
Thank you, Mr. Trent. You've been discussing one-time costs for SCR installation. I'd now like to shift gears to O&M, operations and maintenance, based on vendor quotes. Could you discuss those items now?
Yes. The vendor provided the catalyst elements for SCR system must be replaced every 3 years. They cost $543,000 per unit. So we took that cost of catalyst and divided them by 3 to arrive at the calculated annual cost shown in the table here. Now, if you might think $543,000 sounds expensive, keep in mind that these catalysts use expensive precious metals and the catalysts weigh approximately 15,000 pounds. This is per the vendor quote. This is not a small piece of equipment. Another significant O&M cost component for SCR systems is the use of ammonia. Ammonia is used in the SCR reaction, and in order to achieve the 80% reduction, a significant amount of ammonia is required. This ammonia must be shipped in by truckload in 5,000 gallon increments. The as-delivered trucking cost is $1.33 per gallon. Multiplied by 13 gallons of use per hour and the hours of runtime per year results in the total ammonia cost shown here.
Beyond the O&M costs from vendor quotes that you just described, are there any other issues related to vendor quotes and costs that you would like to address?
Yes, there's one last thing. I understand that Ms. Daly addressed the alternative emission standard that the Pecos River units qualified for under the Part 50 ozone rule based on economic infeasibility. I note that the information that EP&G presented to support the approved AES was based on vendor quotes. So in addition to the fact that the department approved the request for an AES, it did so based on vendor quotes that EP&G provided. The department therefore is not taking a consistent approach in how it treats unit-specific cost estimates supported by vendor estimates.
Thank you, Mr. Trent. Based on your experience, what is your recommendation to the board?
Overall, based on my discussion of unit-specific cost estimates based directly on vendor quotes, I recommend that the board conclude that SCR for Pecos River is far more expensive than the proposed $10,000 per ton threshold. I also recommend the board rely on the cost estimates derived from the vendor estimates here, consistent with EPA guidance.
Thank you, Mr. Trent. And if you could please summarize your direct testimony before concluding.
Yes. So this slide summarizes EP&G's positions. As been mentioned, for Washington Ranch, we do not oppose the 3 grams per horsepower hour limits, but we recommend the board correct the calculation errors so this board's records is defensible. For Pecos River, we oppose the proposed NOx limit, which would mandate Pecos River install SCR on 2 units with an 80% NOx removal rate. We oppose this proposal because, using the most up-to-date information, which are the EP&G vendor quotes, the proposal is nowhere near cost-effective at $21,500 and a little over $25,000 per ton reduced, much greater than the $10,000 threshold. Consistently achieving 80% removal rate is unproven in this sector, and the department has failed to demonstrate that there will in fact be visibility benefits from this requirements. Last, is Blanco A. The department would require EP&G replace 2 units with brand new units. We oppose this proposal because this is not a control requirement. The project is infeasible. It cannot be done. And the department has not rebutted our testimony on this issue because the request for replacement is essentially a requirement to abandon those 2 units that abandonment preempted by FERC, and the National Gas Act. The department only screened Blanco A in due because it failed to round up its 80%. It's a simple arithmetic error, but it's hugely important. And if you get all the way to a place where the board is considering cost effective and it would take some work to get there, the proposal would cost at least $26,000 and $38,000 per ton to reduce, and that is not cost effective. And finally, the department has not demonstrated that the costly reductions at Blanco A would actually have no visibility impacts.
Thank you, Mr. Trent, and we will transition to your rebuttal testimony. Mr. Trent, did you previously file pre-filed written rebuttal testimony in this proceeding?
Yes.
Do you have any corrections to that pre-filed testimony?
No, I adopt my rebuttal testimony in full here.
Thank you. Would you please summarize the topics you'll cover in rebuttal?
Yes, I will address the following 3 topics: vendor quotes supporting cost of SCR at Pecos River, SCR used for mechanical drive turbines, and why replacement at Blanco A is not feasible.
Thank you. Would you please start by responding to certain arguments concerning the accuracy of the vendor quotes that EP&G provided?
I'd be happy to.
And before we start, isn't it true that Kinder Morgan, EP&G's parent company, submitted these precise type of cost evaluations and vendor quotes in the Part 15 ozone rulemaking?
Yes.
And would these be the same type of quotes you would submit to address NOx reduction technologies regardless of the rule?
Yes.
And these were accepted by the department and the board?
Yes. All right. As a very important starting point, both EP&G and the department agree that vendor costs are preferable to generic cost estimates. However, the department claims that the ammonia price that EP&G used was too high. The underlying vendor quote included optional equipment, and that use of allowance for funds during construction is not appropriate. I would respond to each of these. I want to first correct a minor calculation error in our capital cost estimates. The $3.05 per gallon for ammonia was not the correct cost, and we appreciate the department identifying this. However, this line item totals $21,000, and once corrected amounts to a $12,000 error. A correction to that data point does not move the needle when we are discussing an approximately $21.5 million capital project cost. But that is not really an important point in the grand scheme of things. Elsewhere, in EP&G's testimony, we are clear that we used $1.33 per gallon for ammonia costs when we considered those costs on an annual basis. The department says the cost should be actually in the range of approximately 50 cents per gallon, but that is just a commodity cost and does not include trucking costs to actually deliver the ammonia on site. That is a huge miss by the department. Next, I now respond to the argument that EP&G's vendor quote included optional equipment. Although I do agree that the vendor quote did include the words optional, this requires clarification. These line items are only optional in the sense that the vendor does not require them to be purchased with all the other items the vendor sells. It does not mean that EP&G could not go without them. As a matter of fact, SCR elements are listed as optional on this list. But those are always required for SCR to function properly. The last argument the department has regarding the unit-specific cost is that EP&G should not have included AFUDC. My first response to that is that AFUDC is a real cost that EP&G faces, as reflected by the fact that FERC allows AFUDC to be used for the rate-setting purposes. Second, even if we get rid of AFUDC, it's just not a material cost difference, composing just 2.6% of the total project capital cost.
Thank you, Mr. Trent. The department states that EP&G should have submitted vendor quotes or costs earlier, suggesting the department's only reason for not considering those was based on non-existent deadlines. What is your response to that?
I strongly disagree with that position as a practical matter. If the department's position were true, then this rulemaking process and every other rulemaking process means nothing. The process is intended to solicit information, evidence, data, and discussion to result in reasoned decision-making by the board. This is not how this process is supposed to work. We're here now and are presenting vendor estimates, and we urge the board to credit them. Second, EP&G's submissions were timely, and they should have been considered by the department. We knew the department was considering SCR for Pecos River, and during the stakeholder process, we expressed significant concerns with a 90% efficiency rate. This was based on data and information from EPA. There was no reason to cost out 90% efficiency rate at that time. We anticipated that our feedback during the stakeholder process would be considered, and at the least, the department would further engage on the appropriate level of SCR efficiency rate. We did not see the department's proposal until August of 2024, and at that time, we were shocked to see a 90% removal efficiency requirement for SCR. We had less than 25 business days to respond to the department's proposal. There was no chance to get site-specific vendor quote, so we submitted what was the most comparable to meet the arbitrary deadline. We did work with vendors in the fall of 2024 to put together a quote, but then we were told the department was updating its proposal. So we asked the vendors to press pause as we didn't know what was coming. In December of 2024, the proposal was updated to require an 80% removal efficiency. Feedback was requested from parties and provided. And again, we expressed concern with an 80% efficiency reduction. But on the short comment deadline of January 7 due date, we could not produce a quote in that time. In early 2025, we had to go back to the vendors to ask for a new quote on the entirely different system at 80%. The department published the proposed rule for rulemaking in February 2025, and we timely provided extensive vendor quotes in March with our testimony. Nothing about our engagement was delayed, and quite the opposite. I'd also like the board to understand that these things take time. It is not an easy ask or a quick turn to ask a vendor to design or redesign a system to give us a quote.
Thank you, Mr. Trent. I would now like to have you address claims about SCR that you identified in your introduction. Could you explain that, please?
Yes, certainly. I really think it's crucial to push back on the framing that SCR is this super common control technology that has been widely deployed in this particular industry. The department states that there have been countless SCR installations. This is simply not true for natural gas pipelines, which use turbines for mechanical work, not for electricity generation. The different operational needs makes SCR more suitable for electric generation. Notably, EPNG's parent company, Kinder Morgan, has 430 turbines and pipeline compression service, and not a single one has SCR. If SCR really was a technology with countless installations, you would at least expect some among those 430 units, especially among the newer ones. For older turbines, like the ones at Pecos River that use regenerators, exhaust gas temperature is also an important consideration. The department attempts to evade this issue by arguing that unconventional catalysts are able to operate at lower temperature ranges. But the department does not evaluate whether these unconventional catalysts might be more expensive than traditional catalysts. We have unique units at Pecos River that the department did not consider in their evaluation.
And Mr. Trent, in your evaluation, when you considered these unconventional catalysts, were the costs much higher than anticipated?
Yes, they were.
Thank you. Let's turn your attention now to the feasibility at Blanco A. What is your rebuttal testimony on this issue?
I will keep this brief. I just want to emphasize that I addressed the infeasibility of replacing engines at Blanco A at length in my written direct testimony. The department's written rebuttal testimony did not address this issue at all, because there is no rebuttal. It is simply an infeasible ask. So the only thing on the written record is that replacement is infeasible. The board can eliminate Blanco A from regulation without affecting any other aspects of the SIP.
Thank you, Mr. Trent. Would you please summarize your rebuttal recommendations for the board?
Yes, I urge the board to rely on the unit-specific SCR costs that EPNG provided for Pecos River. I also urge the board to disregard comments about how widespread SCR is. Finally, I urge the board to find the replacement of Blanco A is not feasible and therefore cannot be required. This concludes my testimony, and I stand ready for questions.
Thank you. Before we turn to Mr. Trent's questioning, I'd like to take a break. It'll be 15 minutes. We'll return at 3. Pam, start the recording. Okay, thank you. We are back after a short break. We're going to turn to questioning of Mr. Trent. Let me start with Mr. B. Hill. Mr. B. Hill, no questions. Ms. O'Grady? All right.
Good afternoon, Mr. Trent. I just want to ask a couple of questions. First, about the capital costs of the SCR at Pecos River raised in your testimony. In your testimony, you reference EPA's control cost manual, correct?
Yes.
Control cost manual. You also reference EPA's SCR tool. Is that correct? So you're familiar with both the control cost manual and the SCR tool?
I've used it in conjunction with our other group members.
And EPNG included allowance for funds used during construction in its cost estimate for Pecos River, correct?
Yes.
EPA recommends following the CCM cost estimate methods for purposes of regional haze, correct?
I don't know the answer to that.
Okay. And are you aware that the CCM states that allowance for funds used during construction is contradictory to the cost method of the CCM?
I don't know the answer to that.
Okay. So EPNG included costs allowance for funds used during constructions that are disallowed under the control cost manual.
We put together a full estimate based off of vendor quotes and what it will take to do the project, which part of that is AFUDC. But even if we remove that, we're still way above the $10,000 per ton, because that just equates to 2.6% of the $21.5 million. And our tonnage, or our dollar per ton, would still far exceed $10,000 per ton, even if you took that out.
Okay, thank you. Turning to the timing of the replacement analysis, you did not provide that until fairly late in the process, is that correct?
We provided it in our direct testimony. The department had said it was cost ineffective. And so when they came out with the rule in August, that's when they said replacement was the option. And for us, replacement isn't an option because it's not feasible to put the unit in.
Thank you. But you were notified early in your conversations with NMED that I'm aware that they ruled out replacement at one point in time, but you were aware very early on that they were considering replacement as a control method.
We weren't aware of replacement as the control method until the list came out in August of 2024. Before, our discussion was about LEC and the cost effectiveness of LEC.
Okay, thank you. I'll conclude my questions. Thank you so much.
All right, thank you. Mr. Harris. All right, no questions for Mr. Harris. Ms. Wood? No questions for Ms. Wood. Ms. Catalano? Right. No questions for Ms. Catalano. So we'll turn to the board. Madam Chair, do you have questions of Mr. Trent?
Thank you, Madam Hearing Officer. I don't have any questions at this time.
All right, Member Ely?
Yeah, I think I just have a couple. The quote you got for the SCR, I couldn't tell if it was from one vendor or multiple vendors, and you kind of hybridize them? Could you explain that?
No, the quote we submitted was from one vendor. I reached out to multiple vendors to see if the 80% reduction efficiency was doable. And so I had split. One vendor said they didn't think they could do it. Another said we could possibly do it. So that the vendor that I supplied in our quote was the vendor that said they thought they could do the 80% reduction.
Oh, okay. Thanks for that clarification. And are they the same ones that provided the O&M costs then too?
Yes, everything came from that same vendor,
Okay.
which was the same vendor that we had supplied during the ozone rule.
Ah, that was my next question. Okay, that's helpful. And is it normal to get just one quote, or would normally you get multiple quotes and maybe there was a time constraint? Just curious.
So there was some time constraint was part of the issue. The other is that so on certain technologies where there's multiple companies out there doing a lot of them, there's at times we'll get multiples of those vendor quotes and compare them. For SCR in our industry, there aren't a lot of companies that are really working with us to understand how it would work on the mechanical drive turbines. I understand there's more on the electric generation side, but I went to one and this one, well, technically two, right? One company said they couldn't do it, and the other company gave me an estimate, and so that's what I went with.
Okay, those are all my questions. Thank you.
Thank you, Member Ely. Member Garcia.
Yes, I do have a question. Thank you, Madam Hearing Officer. In your testimony, Mr. Trent, you say that it is infeasible to do a replacement at Blanco A because the DOT requires emergency shut-off system, and right?
That's one of the complications. If we did a replacement, it would cause redoing all of the emergency shutdown system.
Right, and then you say that there are third parties nearby, and so the building compressor station components near another entity's equipment would therefore require all third parties to operate under the same emergency shutdown system. This is not feasible. Are you saying that because you don't have control over the third parties?
So what I said was that it was complicated because of the other stations that share a site with us. The control or the low down system or the emergency system is all tied together and has components that interact with other components from the other companies. And so it would be extremely hard and complicated, expensive to redo that whole system if we put a new unit in. And so not saying it's adding a new unit and updating controls wouldn't be infeasible from the control standpoint for emergency shutdown. It's just as complicated. Adding the new unit is infeasible because we just don't have the place to put it.
Okay, so it's infeasible because you don't have a place to put it.
Right. There's no room in that building, there's no room around that building, and we can't get to the southern piece of the property because of a pinch point with a bunch of pipes in it.
Okay, so that sounds like a different argument than what you said in your testimony. In your testimony, you're talking about DOT requiring a emergency shutdown system, and because third parties would have to operate under the same emergency shutdown system, it's not feasible. So that's the part that I'm still trying to understand. I'm trying to get some clarity on, because DOT would require that third parties have an emergency shutdown system as well.
Right, and they are required to have one.
Okay.
But us making a change would force another company to have to do something, and we have no control over what they can do or can't do.
And you're saying it would force the other company to do what?
To change their emergency controls also.
Okay. And that's why it's infeasible.
Right.
Okay. Thank you.
Member Hunk?
Yes, just one question, Mr. Trent. You mentioned a face-to-face meeting you had with NMED staff in October 2024. What issues did you raise at that meeting?
One, let me make a correction. It was EP&G had a meeting with them, and it was bringing up the issues of the Blanco A, the issues of not having room to build stuff, to put a new unit in, and the issues that would come along with that, and then the SCR requirements at Pecos River.
So you weren't at that meeting personally?
I wasn't at that one personally.
Okay.
Unfortunately.
What feedback did you get from EP&G on NMED's reactions? And
it turned out to be a listening meeting where they listened to us and we didn't get the feedback. So we gave them our input, but we didn't get anything back.
Okay. So no commitment to review anything, get back to you at some point in time, as far as you know?
It was my understanding is it was a thank you for giving us this information, but didn't give us any direct feedback, even after the meeting, of what we had presented.
Okay, thank you.
Member Bitzer.
There was that narrow window described about where you get max efficiency, temperature range wise. What's the temperature range there?
So SCR, for it to be in the higher efficiencies of what they're asking, is like 700 to 900 degrees, and our units at Pecos River, because we have a regenerator on them, we're at like 480 degrees, which is the bare minimum for SCR even operating. After talking to the SCR vendors, they have said that 480 is at the bare minimum of it even doing anything. That's all I have.
Vice Chair Trujillo.
Thank you. Can I ask some of these questions of other witnesses? It's your turn. One of the questions, see, I have to reorganize my notes here. When you were talking about abandonment, now I understand that Blanco A is located in northwest New Mexico in the Farmington area, correct?
Yes.
So has there been any sort of analysis or any sort of review on if that station is taken out of commission, what kind of effect it has on the compression in the region, and if that'll be an issue?
We haven't deep dived into it. We've had some discussion of what is our commercial contracts for the location and what is the capacity, and what our firm contracts are for those 14 units sitting at that station. But we have not completely looked at what the impact in the entire area would be.
Okay. Which kind of leads me to some questions about construction of a new facility or decommissioning of a facility. Did you do any costs associated with the decommissioning of the facility, and what would be required of that?
We didn't do a cost of decommissioning the whole facility. We did look at cost of decommissioning the 2 units. There's cost involved with if we abandon them and have to file with FERC to abandon, and if we get approved, there's costs associated with that piece of it for the abandonment. But no, we didn't look at like what the cost of abandoning the whole facility would be, and we didn't look at what the contract costs would be. We have contracted flow or capacity tied to those 2 units. What would be the impact?
Okay, so what I'm gathering, if I'm understanding all this correctly, is that essentially decommissioning this facility in any way, whether it's just turning those units off or actually deconstructing the site, would have a kind of a ripple effect of greater costs associated with it, with contracts
Right.
you might have, or work that may need to be required to meet other state requirements.
So yes, so just not running them is not an option, because with this rule, we wouldn't have we wouldn't be able to run them because we wouldn't meet the new permit level of a 0.5 gram per horsepower hour for NOx. So just not running them is not an option, because from a FERC standpoint, we're required to be able to run them. And we have contracted capacity tied to those particular units. So turning them off, it has to be, we are asking for abandonment from FERC, and then we're going to our customers and having them release the capacity, basically canceling the contract. There's a cost related to that. And then, of course, there's physical cost of making the unit where it can't run on the system anymore by cutting the valves off so that it can't pump gas on the system anymore, and cutting off fuel so it can't run. So there's no option of it running in the future.
Are there any cleanup costs associated with what you just described?
If we abandon in place, we leave it there and we don't have to, there's not, besides making sure there's all the fluids are drained out of it. So there's some costs associated with draining fluids and, oil, water, those kind of things out of it, and sealing it up. So there's costs associated with that. But then going forward, if we're not taking it out, there's no cost associated with actually taking it out. If we do take it out, there's a lot of the costs associated with that.
And thank you for going down that little bit of rabbit trail with me. Okay, and now if I understand that you're saying pretty much the bottom line is that you don't have room to put new units in at all.
That's correct.
And I remember correctly from the compressor stations I've seen, there's a lot of underground piping associated with that as well. Are you saying there's just no space for these either?
So this building is already, there's a lot of equipment just right outside of it. But yes, if you see a satellite of the building, some pipes above ground, so you can see that. But there's also most of the ground right around there also has underground pipes. So there's just not room. Here, there's just not physically room to put a whole engine and compressor building extra. But then there's all the complication of piping in the ground, because there are 14 units at this station with different pipeline services. So there's a lot of pipe feeding these units.
And these units, are they all skid mounted, or are they built in place?
No, they're all built in place with a large, so Ms. Daly talked about how big the actual unit is, like 19 by 14 feet. Well, they also have a big concrete block that goes 10 feet into the ground underneath it. That weigh about 350,000 pounds of concrete to help deal with vibration and supporting the unit. So all of that is built in place. It's not like a gathering site where it's built on a skid and they could pick it up with a truck and move it. These are built in place and they've been operating for a long time, and they're not easily removable or replaceable.
Thank you for that description of things. I'm going to kind of move over to the SRC questions. Oh, I'm sorry, SCR. Wrote it backwards in my notes.
Sure.
So one of the things you had mentioned about was the catalyst that's associated with the unit itself that needs to be replaced.
Right.
I'm just curious, does that catalyst material, does it get regenerated, or does it have to go straight to disposal?
So for this one, every 3 years, that catalyst element will be taken out, and the precious metal on it is either has the NOx bonded to it. So sometimes you can clean it some, but generally after 3 years, you're going to take that out and put a brand new one in. In cases of non-SCR, which I have much more experience with, is we have to wash them like every year, and that kind of cleans them up. But then every 3 years, you have to replace them, and so that goes away and gets disposed of. We have a company that handles the disposal of catalyst element.
I'm more curious about the facility in which it's disposed at. I understand that Blanco is in Farmington area and Pecos River is in the Permian. Do you dispose of in facilities located in those regions?
To be honest, we don't in the Pecos River right there. We don't have any elements, so I don't know where they would be disposed of. Other places we generally is somewhere close. There's especially in areas that there's a lot of units out there that might have element, that have catalyst on them. Then there's probably companies that come and get them. I don't know where ultimately they go though.
Okay. And I'm going to follow up on Member Bitzer's question about the temperature range. And I just, if you could just explain a little bit more about the fluctuations in the temperature and the efficiency you were describing. And what I'm curious about is how you monitor that temperature and efficiency. Is there like a SCADA type system, or is it just a matter like I'm just kind of, you could explain that a little bit more.
Yeah, so on our current unit at Pecos River, we have exhaust temperature measurement. Oh, sorry. At our current unit at Pecos River, we have temperature measurement for the exhaust. So that goes to a SCADA system. So we're able to see what that exhaust temperature is. If we had to put SCR on it, then that brings a whole new level of controls. And that's part of in our estimate is you have detailed controls that are measuring temperature. It's measuring NOx because it has to constantly change how much reagent you're injecting into the system to be able to account for changes in flow, temperature, and then ultimately NOx levels. So that ammonia injection, the reagent is being injected at different flow rates based on this this control system that is taking in all these inputs and deciding how much has to go in to make sure that we're still meeting a certain reduction.
And is that something that you are able to put on automation, or is that something that's required to have an operator on site take care of?
So the actual operating of the unit, the automation would be running that on the minute by minute. But all of that takes calibration. So your manpower goes up to take care of your manpower hours or your time to take care of all those instruments adds up. And then we have to have personnel on site because of all those truckloads of ammonia. We have to have personnel on site for safety while it's unloading and loading up the tank. So we would have to add personnel to take care of that SCR system.
Okay, and are these sites currently manned, or are they visited periodically?
To be honest, I don't. These sites would be manned during the day, and from like let's say 7 to 3, and then in the evening nobody's there, and they're run by our gas control system out of Colorado Springs, and so they operate those during the night when nobody's on site.
Thank you. Appreciate it.
Okay. Any other board questions? Any redirect?
No redirect. Thank you.
All right. Thank you very much for your testimony, Mr. Trent.
Thank you.
Do I understand that this is the end of your witnesses?
This is the end of our witnesses, and I may, if I might add, we are catching a flight this evening, so if we leave, we'll be popping back onto the hearing tomorrow morning to address any last minute logistical discussions.
All right.
So
Thank you very much.
that's fine.
All right. We hear next from the enterprise witnesses.
Thank you, Madam Hearing Officer and members of the board. My name is Allison Wood, and I'm with the law firm McGuire Woods. And with me is my colleague Kirsten, Kirsten Bahnson, Bahnson. And I did not have an opportunity to introduce her yesterday, so wanted to let you know who's sitting here with me.
Thank you.
We're going to follow the same format that others have followed, where our witnesses will do their direct and their rebuttal together, and then it'll be open for questions.
Thank you for that.
Members of the board, as an initial matter, it's important to remember that this rule is designed to improve visibility in Class 1 areas, national parks. In enacting the visibility provisions of the Clean Air Act, Congress did not require states to achieve maximum emission reductions to address visibility issues. Rather, Congress provided that states need only to show that reasonable progress is being made. This SIP is being prepared as part of the second planning period for the Regional Haze Program, and New Mexico is in very good shape. It is meeting the Uniform Rate of Progress, or URP, for all of its Class 1 areas except for the Salt Creek Wilderness area. But recent regulations in the Permian Basin will likely bring that part back within the Uniform Rate of Progress. This means that New Mexico is on track and meeting Congress's requirements for reasonable progress. 3 enterprise facilities would be subject to the SIP. The first is the Blanco C&D compressor station. I'd like to, as an aside, explain that Blanco C&D are different than Blanco A that EPNG has been discussing. The second facility is the Chaco gas plant, and the third is the South Carlsbad compressor station. Enterprise has been working with NMED during the entirety of the SIP development process, and Enterprise has been responsive to all of NMED's requests and appreciates NMED's engagement with them on this important issue. But overall, Enterprise believes that the SIP is flawed in several key respects. Today, you will hear from 2 witnesses on behalf of Enterprise. The first is Mr. William Tucker Jacobson, who is a senior manager, environmental for Enterprise. Mr. Jacobson has been very involved in Enterprise's engagement with NMED during the SIP development process. He's going to tell you about the 3 Enterprise facilities that would be subject to the SIP, what the SIP would require for these facilities, and we'll discuss NMED's 4-factor analysis of the facilities. He is also going to discuss the problems associated with installing SCR at the Enterprise facilities and the history of what happened with NMED with regard to the determination of whether SCR installation at these facilities would be cost effective. Second, you're going to hear from Mr. Jeremy Jewell, who is the Director of Quality for the Environmental Consulting Division at Trinity Consultants. Mr. Jewell is a subject matter expert in the area of regional haze, and he has provided consulting support to Enterprise during the development of the draft. Mr. Jewell will describe the sort of visibility analysis required by the Clean Air Act and how states and EPA have conducted visibility assessments to support their regional haze SIPs. He's also going to explain that a reasonable assessment of visibility conditions by reference to the URP establishes strong support for the finding that additional control requirements for the Enterprise facilities is unjustified, and that NMED unreasonably failed to consider this information. Mr. Jewell will also discuss the evidence in the record addressing the purported visibility impacts caused by emissions from the Enterprise facilities, and in particular, the Windrose assessment for each of those facilities. He is also going to place in context the emission reductions that would be achieved through control of the enterprise facilities if the SIP were finalized by comparing them to the NOx emission reductions achieved by New Mexico during the first planning period of the Regional Haze Program. Mr. Jewell will also discuss the authority that states have to select sources for evaluation, including state authority to focus on the visibility impairing pollutants of most significance in each planning period of the Clean Air Act's Regional Haze Program. And he's going to explain why NMED's decision to address NOx rather than sulfur dioxide, SO2 emissions, was inappropriate. Mr. Jewell is also going to address why NMED's assumption that NOx reductions from the enterprise facilities will result in meaningful visibility improvements is unreasonable. And he will describe the Q over D source screening process and the emissions and Q over D values for the enterprise facilities, explaining that if NMED had used a reasonable screening threshold, that NMED would likely have determined that the enterprise facilities were not appropriate candidates for regulation under the Regional Haze Program. Mr. Jewell will also address why the space constraints at the Blanco C and D compressor station render installation of SCR controls there technically infeasible. And he will address how states and EPA have considered and evaluated cost information pursuant to the Clean Air Act and EPA's Regional Haze Rule, and will explain how NMED has failed to consider relevant categories of cost data. We will also explain why the cost estimates prepared by NMED are unreliable and cannot reasonably be used to justify control requirements for the enterprise facilities. He will explain to the board that NMED has adopted a cost effectiveness threshold that is at odds with the thresholds adopted by other states, and that is unreasonably high, leading to the adoption of unnecessary emissions control requirements for the enterprise facilities. Finally, Mr. Jewell will provide an overview of the four-factor assessment process that is required by the Clean Air Act. The four-factor analysis prepared by Trinity Consultants on behalf of Enterprise, and will explain to the board Enterprise's view as to the appropriate control determinations based on a reasonable four-factor assessment for each of the enterprise facilities. In closing, because of NMED's flawed analysis, there is no way to know with a reasonable degree of certainty that the controls that would be required at the enterprise facilities under the SIP would have any impact on visibility in New Mexico's Class 1 areas. These controls cost millions of dollars, and these costs have a cascading effect. It is not just enterprise that will bear these costs. These costs will result in increased energy costs that will be passed along to consumers and will have a wide economic effect. Before society is required to bear these costs through increased expenses in goods and services due to rising energy costs, we should be sure that there will, in fact, be a visibility benefit from these controls. And as you will hear from Enterprise's witnesses, this is simply not the case. Because the SIP is so flawed, and because it is uncertain whether the controls being required at the enterprise facilities would result in any visibility benefits, Enterprise is participating in this hearing. Enterprise urges the board to disapprove the SIP and return it to NMED so that an appropriate analysis that examines whether the controls being required will actually result in visibility benefits exists, and so the other legal flaws in the SIP can be remedied. If the board is not inclined to return the SIP to NMED, then Enterprise would request that the board adopt the proposed changes to the regulatory language that would remove the enterprise facilities from the SIP. In the event, however, that the board is not inclined to do either of these things, then Enterprise would request that the board adopt Enterprise's alternative proposed changes to the regulatory language that would permit the enterprise facilities to comply with the SIP on a facility-wide basis. Enterprise thanks the board for its careful consideration of this important matter, and I would now like to call Mr. Jacobson to provide his testimony.
Mr. Jacobson, would you please spell your first and last name for the transcript?
Yes, it's William, William, Tucker, Tucker, Jacobson, Jacobson.
Do you swear or affirm to tell the truth?
I do.
Thank you.
Mr. Jacobson, could you please summarize for the board your education?
Yes, Madam Chair, members of the board, I have a Bachelor of Science degree in Environmental Management Systems from Louisiana State University.
And could you please summarize your work experience?
Yes, I am employed at Enterprise Products Company, which is an affiliate of Enterprise Field Services, LLC. I've been employed by Enterprise for over 12 years. My title is Senior Manager Environmental. As a Senior Manager in the Environmental Department, I specialize in environmental compliance matters and supervise a team that do the same. I've been involved in Enterprise's participation and development of the SIP since 2019. My involvement has included review of the materials developed by NMED, participating in the development of Enterprise's various information packages submitted to the NMED, coordinating with Enterprise employees as well as consultants and outside counsel, and participating in meetings and other communications with NMED staff.
Did you provide pre-filed testimony in this proceeding?
Yes.
Do you have any amendments, updates, or changes to make to that testimony?
No.
Madam Hearing Officer, Mr. Jacobson's pre-filed testimony is identified as Enterprise Exhibit 2 and was previously admitted as.
Yes.
Mr. Jacobson, I'd like for you to please summarize that pre-filed testimony for the board now. Would you please start by describing the Enterprise facilities subject to the proposed SIP?
Yes, we have 3 facilities that are impacted by the proposed SIP. First, our Blanco C and D compressor station, and as Allison mentioned, it's different than the Kinder Morgan Blanco A facility. Blanco, I'll refer to it as Blanco throughout my testimony, so I will not likely say Blanco C and D just to not get tangled up on words. So Blanco is a natural gas compressor station located approximately 2 miles northeast of Bloomfield in San Juan County, New Mexico. Facility compresses inlet natural gas for the purpose of Facility compresses inlet natural gas for the purpose of transportation to another facility via pipeline or to a major transportation pipeline. The units affected by the proposed SIP and companion rule are 3 natural gas-fired turbine units. Units T-C01, units T-C02, and unit T-01. The nearest Class 1 area is the Mesa Verde National Park, which is about 17 miles from Blanco. Second facility is the Chaco Gas Plant. The Chaco Gas Plant is a natural gas processing facility that receives field natural gas, processes the gas to remove impurities, then extracts natural gas liquids. Recovered natural gas liquids, also known as NGLs, are then treated and delivered to a pipeline for transport to downstream NGL fractionation facilities. The facility is located approximately 14 miles southwest of Bloomfield in San Juan County, New Mexico. The unit affected by the proposed SIP and companion rule is 1 reciprocating internal combustion engine, or RICE unit, and it's fired by natural gas. Like Blanco, the nearest Class 1 area is the Mesa Verde National Park, which is approximately 50 miles from Chaco. 49.8 to be more precise. Our third facility impacted by the proposed rule is the South Carlsbad Compressor Station. The South Carlsbad Compressor Station is a natural gas compressor station located 2.8 miles northwest of Loving in Eddy County, New Mexico. The facility compresses inlet natural gas for the purpose of transportation to another facility via pipeline. The units affected by the proposed SIP and companion rule are 2 natural gas fired combustion turbines, Units 1 and Units 2. The nearest Class 1 area is the Carlsbad Caverns National Park.
Thank you, Mr. Jacobson. What would the draft SIP require of each of the enterprise facilities?
For Blanco, the draft SIP and companion rule would require the 3 affected units to meet emission limits that are based on the installation of selected catalytic reduction, or SCR.
What would be required in Chaco?
For Chaco, the draft SIP and companion rule would require 1 reciprocating internal combustion engine to meet an emission limit of 0.5 grams per horsepower hour NOx that is based on a low emission combustion system, or LEC.
And what would be required at South Carlsbad?
At South Carlsbad, the draft SIP and companion rule would require the 2 units to meet emission limits that are based on installation of dry low NOx combustion, or DLN.
And can you DLN?
Yes. DLN, yes, sir.
Can you explain for the board how NMED arrived at these requirements for the enterprise facilities?
Yes, NMED conducted a 4-factor analysis as is required under the Regional Haze Program. NMED focused primarily on cost, which is the first factor, and said that this factor was predominant. Unfortunately, by focusing almost exclusively on cost, NMED did not take into adequate account the 3rd factor of that analysis, which requires states to consider the energy and non-air quality environmental impacts of compliance. Enterprise pointed out to NMED that there are disbenefits of using SCR that NMED did not take into account in their analysis. Examples of those are ammonia emissions, environmental and safety risk associated with handling ammonia, energy impacts. It's unclear whether sufficient electrical power at the facility is present to support SCR and its associated components and equipment. Impacts on engine performance. Enterprises required to meet certain commercial throughput requirements. It is not known if this issue will impact the ability of the enterprise facilities to meet commercial throughput requirements. This is also an energy impact that NMED is obligated to consider, but has not evaluated.
Do you agree with how NMED did the 4-factor analysis?
No. EPA has consistently made clear, including, for instance, in its 2019 Regional Haze Guidance document, that while states do have flexibility to decide how to characterize the 4 factors, the state's approach must be reasonable. At the very least, that required, as EPA has said, that states consider all of the 4 factors. Because NMED has not considered one of the factors, its benefits, it follows that the state has not completed the 4-factor analysis that the Clean Air Act and EPA regulations require.
Are there problems with installing SCR at the enterprise facilities?
Yes, there is not sufficient space at Blanco to install SCR.
And did Enterprise explain this to NMED?
Yes, Enterprise explained this issue to NMED and provided the department with information to demonstrate this problem. Initially, NMED agreed that because of the space constraints that SCR would be cost prohibitive at these facilities. In the course of its ongoing discussions with NMED since 2019, which occurred over a period of years, during the development of the draft SIP, Enterprise received an email from NMED dated December 20th, 2023. That email included 2 attachments of the Excel spreadsheets containing updated cost evaluations for Blanco and Chaco. In those spreadsheets, which were prepared by NMED, the department noted that in its 2019 4-factor assessments and its follow-up communications, Enterprise had explained that there was inadequate space for SCRs at each of the enterprise facilities. NMED stated in its spreadsheet that the aerial maps Enterprise had provided suggested that new buildings or substantial construction could be required to house an SCR. NMED further indicated that those actions would be costly, and NMED concluded that SCR would be cost prohibitive on that basis.
What happened when the draft SIP was released by NMED in August 2024?
In that draft SIP that was released in 2024, NMED reversed course and suddenly said that based on aerial images that were provided, there's space for the SCR if building modifications are made. But this conclusion had no actual analysis behind it. NMED just assumed that building modifications would cause a 10% increase in the cost of the project without doing any analysis of whether the building modifications were in fact realistic or appropriate. There are many considerations that would need to be given to make these types of building modifications and facility modifications that NMED completely ignored, such as the potential for underground obstructions not observable via aerial photography and imagery, the exhaust flow paths, pressures, rates, safety considerations for proximity of the SCR and other process equipment, additional electrical and other equipment that might be needed, how it might be routed. There's nothing in the record that shows what types of building modifications would need to be made to install SCR. What that would involve and what it would cost. Instead, the NMED just assumed it can be done and assumes it will cause a 10% increase in cost.
Did Enterprise offer an alternative to NMED that would assist Enterprise in being able to meet the requirements of the draft SIP?
Yes, the SIP is approved with the draft emission limitations for the Enterprise facilities. We would have to figure out how to install controls at these facilities. We explained to NMED that additional compliance flexibilities would help Enterprise to be able to meet these limits. Specifically, Enterprise requested that NMED allow for facility-wide averaging, but in the draft SIP, NMED did not address or even respond to this request, and the draft SIP continues to require the emission limits to be met at each unit. Facility-wide averaging that Enterprise requested would not have any effect on the overall stringency of the standards. Basically, the emission rate limits or the units at each facility are added together to provide a facility-wide rate. This added flexibility is really beneficial in situations like ours where application of the control equipment is not straightforward.
Is facility-wide averaging like Enterprise is requesting unusual?
No, this request by Enterprise for facility-wide averaging is not unusual. For example, EPA approved this type of approach for a facility in New Hampshire. The EPA itself, when it imposed a federal implementation plan, FIP, in Arizona, allowed a facility to use facility-wide averaging.
Thank you, Mr. Jacobson. Did you also provide pre-filed rebuttal testimony in this proceeding?
Yes.
And do you have any amendments, updates, or changes to make to that rebuttal testimony?
No.
Madam Hearing Officer, I'd just like to remind everyone that Mr. Jacobson's pre-filed rebuttal testimony is identified as Enterprise Exhibit 3. Mr. Jacobson?
Oh, I'm looking at it. It's 4.
It is 4. You are correct. No, yes, 4. I'm sorry. You're right. Thank you for correcting me. Mr. Jacobson, could you please summarize for the board the part of your rebuttal testimony that responds to the testimony of Mr. Robert Seidner, the Senior Air Quality Engineer and Manager for ERG Inc., who provided environmental consulting services to the NMED?
Mr. Sidner's testimony reinforces that states have flexibility in how they implement the regional haze program. His testimony also made clear that EPA's guidance on how states should implement the program, including the 2019 guidance document and 2021 memo, clarifying regional haze program requirements are not binding or legally enforceable requirements on EPA. Mr. Sidners also acknowledged in his testimony that SCR will result in additional ammonia emissions, and he concludes that in his opinion, the impact of ammonia emissions does not outweigh the benefits that will be achieved through reduced NOx emissions. But Mr. Sidner does not address the ammonia slip issue or the safety and waste release type issues Enterprise identified. These issues must be considered as part of the third factor, and NMED did not address them, even though Enterprise raised them in its comments.
Could you now please summarize the portion of your rebuttal testimony that responds to the testimony of Alexander Sanchez, the environmental analyst for the Control Strategy section in the Air Quality Bureau of NMED?
Yes, in his testimony, Mr. Sanchez acknowledges that NMED initially agreed with the conclusion that space constraints at the Enterprise facilities makes SCR infeasible. He then explains that the National Park Service submitted comments that said that they thought building construction could be done based on aerial photographs. NPS said in their comments that it was Enterprise's responsibility to show that doing this was cost prohibitive, including a need to justify this with existing documentation.
Did NMED ever ask Enterprise to provide additional documentation of the type that the National Park Service was saying was required?
No, and what Enterprise had provided to NMED was sufficient under the EPA guidelines. EPA's guidelines explain that technical infeasibility is a valid reason to exclude a source from the Regional Haze Program, and the guidelines say this can be accomplished with the showing that there are unresolvable technical difficulties with applying the control to the source. This is exactly what Enterprise did here. National Park Service appears to be saying that technical infeasibility can only be justified with something similar to engineering studies. This is not what has generally been done, and is not what the guidance requires. Finally, this was what was required. Enterprise did not have sufficient time to prepare that type of evidence.
Yesterday, Mr. Sidner testified that the draft SIP's estimates of emission reductions were being challenged by Enterprise and EPNG. Is Enterprise challenging NMED's estimates of the amount of emission reductions that would result from the SIP?
No.
Mr. Sidner also testified yesterday that it was Enterprise's fault that SCR is being required at Blanco because Enterprise had failed to provide cost estimates to show the cost of reconstructing the buildings at the facility to install SCR. How long did Enterprise have to provide additional evidence on the technical infeasibility of SCR installation at Blanco?
We only learned about NMED's change in position with regard to SCR at Blanco on August 24th, 2024, and the comments on the draft SIP were due less than a month later on September 20th, 2024. This is not enough time to conduct the engineering studies that NPS appears to want.
How long does it generally take to conduct these engineering studies?
Anywhere from 2 to 6 months, depending on it varies depending on scope.
Why was the comment period so short?
Mr. Sanchez testified that the department felt it had to act quickly because EPA could not impose a FIP on New Mexico in September 2024. But Mr. Sanchez's testimony seemed not to have considered that before EPA could do that. It would have to follow the Clean Air Act's requirements for notice and comment rulemaking and development of an appropriate record. This is a lengthy process. For example, when the EPA imposed regional haze FIP on Wyoming, that process took 1.5 years, with the FIP being proposed in July 2012 and the final FIP being issued in January 2014. Even if EPA had issued the proposed FIP in September, which it did not and has not, there would have been time for NMED to allow stakeholders to provide meaningful comments on the proposed SIP.
Mr. Sanchez testified yesterday that NMED provided 2 chances for Enterprise to provide information on the infeasibility of SCR at Blanco. Could Enterprise have provided the additional engineering studies on the revised draft SIP?
No, as Mr. Sanchez testified, the revised draft SIP was released to stakeholders on December 13th, 2024, and we only learned on December 2nd, 2024, during a scheduling conference that took place in this proceeding that a revised SIP was going to be released. Comments on the revised SIP had to be prepared over the holidays and were due on January 7th, 2025. That did not provide sufficient time to conduct the engineering studies. These types of moves by the NMED are mistakenly cast to give the appearance of a fair process with multiple input opportunities, when in reality, the NMED has only been given affected companies like us very short windows to respond to significant changes in position, despite the absence of any real urgency to do so.
Yesterday, Mr. Miller testified that NMED was skeptical of the claim in your testimony that allowing for facility-wide averaging would not result in fewer emission reductions or altered impacts on visibility conditions. Do you agree with Mr. Miller's skepticism?
No. Enterprise is asking for some flexibility and compliance with the SIP by being able to comply on a facility-wide basis rather than a unit-by-unit basis. Mr. Miller ignores, in my testimony, my statement that the flexibility that Enterprise is requesting would not affect the overall stringency of the SIP's requirements. This is true. Mr. Miller's point is that because it might be possible for a certain unit to operate more under a facility standard than they might be able to operate under a unit-by-unit standard, that might result in overall emissions being higher. But even if emissions were higher overall, which is entirely speculative, as Mr. Miller appeared to concede by saying that this was possible and would require a lot of examination, the emissions would nonetheless be within the limits of the draft SIP, which would mean that they meet the Regional Haze Program's requirements of reasonable progress. If the overall stringency of the draft SIP is met, and if the requirements of reasonable progress are met, there is no valid reason to deny Enterprise's request for facility-wide averaging.
Mr. Jacobson, do you have a recommendation for the board with regard to the draft SIP?
Yes, it would be best if the board would send the draft SIP back to NMED for further work to ensure that the draft SIP complies with the requirements of the Regional Haze Program and analyzes all four of the factors that the Clean Air Act requires and complies with EPA guidance. This approach would also allow Enterprise to provide the additional documentation regarding cost of SCR at Blanco. If the board decides to approve the SIP, then Enterprise would recommend that the board adopt its proposed changes to the regulatory text that are entered into evidence as Enterprise Exhibit 1 that remove the Enterprise facilities from the SIP. And if the board is not inclined to do that, then Enterprise recommends that the board adopt its alternative proposed regulatory changes also in Enterprise Exhibit 1 that would allow the Enterprise facilities to comply on a facility-wide basis.
Thank you, Mr. Jacobson.
Okay, we will turn now to questioning. Mr. V. Hill, do you have questions? No? Ms. O'Grady? All right.
Good afternoon, Mr. Jacobson. I just have one short line of questioning. I'd like to talk about the concerns with SCR raised in your testimony. You stated on page 7 of your direct testimony, and again brought this up this morning or this afternoon, that operating the SCR will also require power. It is unclear if existing electrical power is sufficient or if upgrading and adding electrical infrastructure would be required. Is that correct?
Yes.
Can you point to where in the record you provided information to NMED showing that Enterprise would need to install electrical infrastructure to meet the energy needs of SCR?
We did not submit any of that.
Can you point to where in the record you provided information showing that enterprise would need to upgrade electrical infrastructure to meet the energy needs of SCR?
I cannot.
You also stated on pages 7 through 8 of your direct testimony that operation of SCR would likely impact engine performance by creating additional working load on the engine, and it is not known, or excuse me, period. It is not known if this issue will impact the ability of the enterprise facilities to meet commercial throughput requirements. Is that correct?
That's correct.
And can you point to where in the record you provided information about the impacts on throughput requirements to NMED?
I cannot.
Okay, thanks. That's all I have. Thanks so much.
Thank you. Mr. Harris? No questions. You're Ms. Wood. Ms. Gutierrez? All right. And Ms. Catalano? No questions. All right. We'll turn to the board. Chair Sweet? Yes. Yes. I'm sorry.
No questions. No questions for me.
Mr. Jacobson, wasn't the point of the testimony that was just being read that NMED had not performed those analyses?
Yes.
So you weren't claiming that those issues were in fact going to be a problem, correct?
Correct.
Wasn't the point of that part of your testimony rather that you were unsure whether those would be problems?
That's correct. We have very limited amount of time to prepare these types of engineering analysis and estimates, being that we learned of SCR in September when the draft SIP was issued. So
that's all.
All right, thank you. Chair Sweeney indicated that she had no questions. Member Ely?
Yeah, I just need a little clarification. So SCR is being, or the emission limits associated with SCR is being, would be used at each of the 3 facilities. I thought you said DLN for South Carlsbad, which confused me.
yeah, sorry about that. The SCR is only being proposed at this in the draft, the current draft SIP at the Blanco C&D compressor station. For 3 turbines.
Okay. And not Chaco and not South Carlsbad.
That's correct.
Oh, okay.
There's other control technology proposed at those other 2 facilities.
Okay. I need to go back and look at my notes then. Okay. So it's just really the Blanco C&D that you're worried about, the SCR and the adequate space for the SCR.
Correct.
Okay. That's it. Thank you.
All right, thank you, Vice Chair Trujillo.
No questions for me.
Okay, Member Bitzer.
No question.
Member Honker.
No questions.
Member Garcia.
No questions. Thank you.
All right, anything further, Ms. Wood?
No, Madam Hearing Officer.
All right, doesn't sound as though there's any reason not to excuse Mr. Jacobson. Thank you very much.
Thank you
for your testimony.
Enterprise would now like to call Jeremy Jewell.
Mr. Jewell, if you would spell your first and last name, please.
Yes, Jeremy, Jeremy, Jewell, Jewell.
Do you swear or affirm to tell the truth?
I do.
Thank you.
Good afternoon, Mr. Jewell. Could you please summarize for the board your education?
Yes, I have a Bachelor of Science in Mechanical Engineering from the University of Arkansas.
And could you please summarize your work experience?
Yes, next month I will celebrate 25 years as a Clean Air Act regulatory consultant for Trinity Consultants.
And do you have any amendments, updates, or changes to make to that testimony? Oh, let's get a question. Did you provide pre-filed testimony in this proceeding, Mr. Joel?
I did.
And do you have any amendments, updates, or changes to make to that testimony?
Yes, I have two small edits to make. The first is on my direct testimony dated March 3rd, 2025 on page 5. I would like to clarify, there's a question and answer. The question begins with, based on the testimony you have provided, do you think it is consistent with regional haze requirements and similarly situated agency actions for NMED to decline to consider visibility when creating their regional haze SIP? At least in that answer, I should clarify that what I'm talking about is when NMED is evaluating control requirements, not the SIP writ large, if that makes sense. And secondly, on page 22 of my direct, there is an answer that begins with, and I won't read the whole thing, NMED screening threshold of 5.6 is not, that's the phrase it begins with. The very last statement in that answer, I would just strike the word or the state Idaho from the list. That's it.
Thank you, Mr. Joel. I'd like for you to please summarize your pre-filed testimony for the board now. Would you please start by describing how NMED assessed visibility in the draft SIP?
Yes, so, excuse me, I believe that is primarily in section 3 of my direct, and I'll just try to briefly summarize. First of all, NMED stated in the draft SIP, I believe I counted 17 times, that they did not directly consider the visibility benefits of potential control measures when making the control determinations. Further, I go on with a variety of different answers. One is with regard to how other states have considered visibility when making their control determinations, or in other aspects of the SIP, for example, when doing source screening. So yeah, different ways that the states have considered visibility. One is to determine which pollutants to review. Not all states reviewed both SO2 and NOx. Some states actually reviewed more pollutants than that. Some states used visibility assessments as a fifth factor when making control determinations. Some states used visibility assessments to prioritize which sources that would be evaluated. And some states used visibility modeling to directly predict the impact that proposed controls might have on visibility impairment in the Class 1 areas. I had a couple of examples. I won't go through them all, but for one example, Georgia is interesting because the EPA has proposed to approve the Georgia SIP. Georgia uniquely, well, maybe not uniquely, but interestingly quantified the difference between the effectiveness of NOx and SO2 in creating visibility impairment in the Class 1 areas that were at issue in Georgia, which are, of course, the different Class 1 areas that are at issue here. But it's interesting that it noted that the reduction of 1 ton of SO2 will have the equivalent benefit of reducing between 19 and 30.7 tons of NOx, depending on the Class 1 area. Thus, in their case, making SO2 much more important from a Class 1 visibility standpoint. I go on to point out a number of different models that various states used, 3 in particular. Some states, particularly in the northeast of the U.S., use the California PUF model, or CalPUF, that's CALPUFF. It was a model very popular in the first planning period, not as much in the second planning period, but it was used by some states. Others used a model called the Hybrid Single Particulate Lagrangian Integrated Trajectory Model. Sorry, Hybrid Single Particulate Lagrangian integrated trajectory model, high split for short. And then other states used a photochemical grid model known as CAMAX, or the Comprehensive Air Quality Model with extensions. Other states, whether they did modeling or not, have certainly evaluated the uniform rate of progress when developing their SIP control determinations. I would point out in the first planning period that all SIP control determinations were evaluated using modeling, particularly CalPUF in that one. I should have mentioned that a moment ago. I think that answers that question.
How did EPA evaluate and consider visibility during the first planning period?
So particularly, again, in all cases, because the first planning period was primarily about BART, best available retrofit technology, there was a statutory fifth factor for BART that required states or regulatory or regulated entities to do modeling to prove that the proposed control requirements would actually be effective at improving Class 1 area visibility impairment.
Thank you, Mr. Jewell. Could you please discuss NMED's basis for concluding that the SIP will result in visibility benefits?
Yeah, so that's primarily in Section 4 of my direct, excuse me. According to the draft SIP, again, NMED has simply assumed that the NOx emission reductions requested will translate to Class 1 area visibility benefits. They have not done any actual modeling or other assessments to demonstrate that those NOx emission reductions actually will result in Class 1 area visibility impairment improvements. All of the information in the record actually suggests the opposite conclusion. For example, the information about how ammonium sulfate, not ammonium nitrate, is the primary driver on the most impaired days at all the Class 1 areas in New Mexico. In addition to that, all the Class 1 areas being on track to meet their visibility goals without the additional emissions reductions. And that is the comparison to that uniform rate of progress, or the URP, which again, it's been explained, it's just a way to measure and assess the progress towards the national visibility goal, ultimately of achieving natural conditions with regard to visibility in Class 1 areas.
Could you please discuss the windrows assessments for the enterprise facilities?
Yeah, so that's primarily in Section 4 of my direct, excuse me. It is those windrows assessments that were submitted as a part of Enterprise's 4-factor analyses are currently the only information in the record from which we can glean any idea of what controls at the enterprise facilities might result in the nearest Class 1 areas. Just as a way of explanation, a windrows is a graphical representation that characterizes both the speed and direction of wind over some period of time at a particular location. To clarify, a windrows does not give us information about visibility. It just simply shows wind patterns so that we know that particle of emissions from a particular spot, which way it will initially travel. Just to summarize, first, the windroses for each of the 3 enterprise facilities, just to summarize together, show that the wind will blow in the direction of the nearest Class 1 area, respectively, between 1.4 and 2.4% of the time, depending on which facility we're talking about. And I would say without any further evidence, which we don't have any further evidence, these facts provide a basis for concluding that controls at the enterprise facilities will have minimal impacts in the Class 1 areas. And the record does not indicate that NMED has considered this information at all.
Could you please discuss how the emission reductions that would result from the proposed SIP compare to the emission reductions that have previously been found necessary to address regional haze?
Yes. So for a quick comparison, in May 12th, 2014, excuse me, in EPA's proposed rule to approve New Mexico's revised SIP in the first planning period, which was a replacement to EPA's FIP that had been established, there were three scenarios presented. One was NOx emission reductions of 17,500 tons per year. One scenario was 4,900 tons, and one was 12,989 tons of reduction. So the reductions being called for in this draft SIP for the three enterprise facilities are 866 tons for Blanco. Again, that's Blanco C and D. 118 tons for Chaco, and 136 tons rounded for South Carlsbad. So these emissions reductions, just by way of comparison, are 2 orders of magnitude less than the emission reductions called for in the first planning period SIP.
Could you please now discuss NMED's decision to pursue NOx emissions in the SIP?
Yeah, so, excuse me, yes. I'll start with this. So according to EPA guidance, states are empowered to conduct 4-factor assessments on the sources that emit the dominant visibility impairing pollutants. And according to the draft SIP, the dominant visibility impairing pollutant in the second planning period for the New Mexico and related Class 1 areas is ammonium sulfate. Despite this, NMED regulated NOx emissions, which is not a precursor to ammonium sulfate. One second. Yeah, and in terms of comparisons to some other, I just gave some numbers a moment ago that were in the hundreds of tons per year of NOx emissions reductions for the enterprise facilities being requested by the draft SIP. And I pointed out in my draft, you can read it there. But for example, just in way of comparison, Arizona's SIP calls for roughly 21,000 tons per year of NOx reductions. Somewhere between 34 and 39,000 tons per year of SO2 reductions. Ohio SIP calls for, again, 47,000 tons of SO2 reductions, 33,000 tons of NOx reductions. So there's just a large discrepancy, I guess, between the levels of reductions being required by others and what's being requested by NMED here.
Will the NOx emission reductions from the enterprise facilities meaningfully impact visibility?
Well, we don't know for sure because we don't have an analysis telling us, but everything in the record suggests to me that it would the impact from the controls being proposed at the enterprise facilities would be minimal at best at the Class 1 areas.
Can you discuss the Q over D values for the enterprise facilities?
Yes. So perhaps most informative would be a figure in my direct. The figure is entitled Ranked Q/D from SIP Table 6.1. I don't have a page number here. It would be roughly page 20, I think.
What table is it?
It is.
It's page 21.
21, thank you. Is this one? So it shows a graphical representation of the 134 facilities that were considered in the Q over D assessment by NMED. And it shows the Q over D numbers used by NMED for the 3 enterprise facilities, 28.3 for Chaco, 7.81 for Blanco C and D, and 5.91 for South Carlsbad. What I think is interesting about this figure is that the very first bullet, or the first dot on the figure, is 400 and some odd, the Q over D value. The next one looks to be about 50, and frankly, all the rest look like they're sort of in the muddled together. There's hardly any difference at all, relatively speaking, to the very largest Q over D values.
What should NME have done with regard to the enterprise facilities based on a Q over D analysis?
Pardon, just trying to find my place. To me, so this goes actually to several issues. First of all, the selected Q over D threshold value of 5.6 was said to be based in the SIP on EPA guidance, when in fact there is no EPA guidance. EPA guidance that suggests that 80% of visibility impairing pollutant emissions in the state should be screened in for the 4-factor analysis. In fact, there is no EPA guidance that says that. There was a draft guidance document. It was either in 2016 or 2017. EPA's guidance was finalized in 2019 and specifically rejected that 80% threshold, and instead used a statement, something to the effect of a reasonable number of sources. So that would be my first concern. The second one, in one of NMED's, and I don't know, we'll get to this, one of NMED witnesses' testimonies, they talk about Oregon's SIP also using that 80% threshold, but I think we'll get there in a moment. So the 5.6 Q over D threshold, in my mind, is quite tenuous at best. And frankly, I don't think Q over D in and of itself is an appropriate way to screen sources for regional haze 4-factor analyses.
What Q over D number did you recommend in your testimony that NMED should have used?
So I don't think I recommended one specifically. I noted that a Q over D threshold of 10 was common, that it had been recommended. I don't think I mentioned RAP, although that was testimony earlier today. Q over D of 10 was implied in EPA's guidance in the first planning period for the BART analyses. Q over D of 10 has been used by many other states in the second planning period as well. So it seems to me that that would be the starting point.
And what would have happened to the enterprise facilities if NMED had chosen a threshold of 10?
So Blanco and South Carlsbad would have screened out as having Q over D values of less than 10 based on the data that was used by NMED, which was 2016 emission data. Interestingly, Chaco would actually also screen out if you use more recent data from 2022 or 2023.
Can you please discuss the technical issues associated with installation of SCR at the Blanco facility?
Yeah, so Mr. Jacobson discussed this as well, so I'll be brief. I understand Enterprise received information from a vendor, Seco Peerless, in 2019 that stated that an area of approximately 40 feet by 20 feet is required for an SCR unit. And then based on that assessment and the size estimates for an SCR that were provided in that estimate, Enterprise determined that it was not possible to install SCR at Blanco. And then Enterprise also provided aerial photographs with those measurement overlays to demonstrate the limited space available for the installation of SCR at Blanco.
Are space constraints a valid basis for determining that SCR is infeasible?
Yeah, yes, I believe they are. So we have to again go back to the first planning period guidelines, because that's the only statements we have from EPA that I think speak to this issue. But those guidelines indicate that determining technical feasibility is the first step in characterizing control options. And those guidelines explain that technical infeasibility can be based on physical, chemical, and engineering principles. So a space constraint would be both a physical and an engineering principle.
Can you please discuss how EPA has considered the costs of controls in the SIP?
Yeah, excuse me. So in a variety of ways, EPA in past practice and their rules and the guidance allow for a variety of different cost metrics to be considered when making control decisions for regional haze purposes. So for example, total capital costs, annual operating and maintenance costs are very common. Cost per ton of emissions reduction, we've heard a lot about that. That's dollars per ton. Also incremental costs. We could also, and EPA has used this and other states have used this as well, develop a cost metric that's cost per unit of visibility improvement. So those would typically be either in units of dollars per deciview, which is a unit of visibility impairment, or dollars per inverse megameter, also a unit of visibility impairment.
And how would NMED's analysis have changed if it had used those different cost metrics that you were just talking about?
So we don't know for sure because we can't develop a dollar per deciview or a dollar per inverse megameter value in this case because we don't have any assessments of visibility of what the controls would mean in terms of visibility improvement in the Class 1 areas.
Can you please describe how NMED estimated costs for the enterprise facilities?
Yeah, so in short, NMED used the EPA's Control Cost Manual, which has been referred to as the CCM. It also, NMED refers to what it called, quote, other reliable sources of information. And in one case, they used the four-factor analysis information developed for a similar facility in New Mexico and applied it to one of the enterprise facilities.
Can you describe NMED's cost determinations for Blanco?
Yes, one second. Yes, so for Blanco, which is where SCR is being proposed in the draft SIP, NMED used EPA's SCR tool, which is a spreadsheet tool made available to supplement the control cost manual in order to calculate the cost that ultimately made it into the draft SIP for Blanco.
And can you describe how that retrofit factor works?
Oh yeah, I should have pointed that out. So within the control, or excuse me, within the SCR tool, NMED, as Mr. Jacobson testified to, used a 1.1 retrofit factor to account for what I'll call shoehorning in the retrofitted controls. Sorry, what was the question?
The retrofit factor and how it works and was applied.
Yeah, so we don't have a lot actually guidance about the retrofit factor, but what we do have is from the control cost manual developed by EPA. It says that a retrofit factor of 1 should be used for average retrofits. It doesn't actually define what it means there, but then it contrasts that with a range of 0.8 to 1.5. That's the range it gives in the control cost manual. So presumably up to 1.5 would be appropriate in some cases. And then lastly, I'll just point out that EPA's guidance in the control cost manual notes that, quote, the proper application of a retrofit factor is as much an art as it is a science, in that it requires a good deal of insight, experience, and intuition on the part of the analyst. My concern with the draft SIP with respect to the retrofit factor is I don't see anything in the record, any quantitative engineering analysis backing up the 1.1 value.
Can you describe NMED's cost determinations for the Chaco facility?
Yes, so Chaco is the example where NMED used a different facilities, in fact, the different companies' information to calculate what the cost of control would be at Chaco. So specifically, upon some investigation, you can figure out that what they used were the cost information for DCP's Linham Ranch gas plant. And then they applied that information as a surrogate to calculate the cost of controls at Enterprise's Chaco facility. There's a couple of issues with this. First of all, DCP's engines are 2,000 horsepower, whereas Chaco Unit 14, the unit at issue for Enterprise, is 3,400 horsepower, 70% larger than the DCP engines. Moreover, I find it interesting that NMED actually found that the controls, in this case LEC, was not cost effective for the DCP engines, but was in fact cost effective for the Enterprise engine.
Thank you, Mr. Jewell. Can you please describe NMED's approach to establishing a threshold for cost effectiveness?
Yes, so it's been described that NMED used a binning analysis, excuse me, where they, I'll explain quickly, they cataloged available controls, identifying the most effective controls available at potential CETVs, that's cost effectiveness threshold values, ranging from $1,000 per ton to $2,000 per ton. And then they bend the various, the graph that's created through that cataloging. And then they marked breakpoints at what they called obvious bend edges, there's a couple of issues here. First of all, I don't agree that the breakpoint that they used for bend, what they call breakpoint number 2, is actually the next obvious bend edge past breakpoint number 1. I think the bend edge would be where the slope of the line changes significantly, and it seems to me that that occurs next at $8,000 per ton, not $10,000 per ton. It seems to be more of an obvious breakpoint in the data as far as I'm concerned. Secondly, I will also just point out that, and we may get to this, but it's here, so I'll say it. The establishment of a bright line dollar per ton value as a control, or excuse me, as a cost effectiveness threshold value, as recognized by several other states, is blind to what's supposed to be a site-specific analysis for each of these units undergoing a 4-factor analysis. So they use the binning, but at a broader or at a higher level, I have some concern with even establishing a single number at all.
Can you discuss what the cost effectiveness determination was for Blanco?
For Blanco, there are 3 units being considered. TCO1, the cost effectiveness value calculated by NMED was $6,000 per ton. For TC02, it was $5,000 per ton. And for TD01, it was $4,000 per ton.
Did Trinity conduct a 4-factor assessment for the Enterprise facilities?
Yes, for all 3.
Could you please describe what Trinity's 4-factor assessment showed for each of the Enterprise facilities?
Yes, give me a moment. I'll go through all 3. So Trinity conducted an initial 4-factor assessment for Blanco. It was submitted in November of 2019. That initial submittal was supplemented on 5 different occasions that were specific to Blanco, and in 3 other submittals that covered more than one facility. The 4-factor assessment for Blanco, again, evaluated those 3 units I just named for their emissions of NOx. It evaluated a number of different control options, good combustion practices, fuel selection, DLN or dry low NOx combustion. It also evaluated water injection and steam injection, and lastly, SCR. Regarding SCR, Trinity explained in the four-factor analysis that, again, an on-site evaluation during which measurements were taken demonstrated that the amount of space needed for SCR rendered it impossible to install at Blanco. Ultimately, the conclusion of the four-factor analysis for Blanco was that none of the remaining options were economically feasible and therefore should be rejected as necessary for regional haze regional progress. For Chaco, again, the original four-factor analysis was submitted in November 2019. Follow-up submittals on 2 different occasions with respect to Chaco. The original analysis actually evaluated 8 units, but ultimately it was narrowed down to only Chaco Unit 14. And a number, again, of controls were considered: good combustion practices, fuel selection, dry load NOx, again, DLN, or in this specific case, a vendor-specific term was used, and I use it in my testimony, so I want to explain it. So low NOx. So it is DLN. It would be like calling Kleenex facial tissue. It's just sort of a brand of DLN. Also water and steam injection again, and SCR. So regarding good combustion practices and fuel selection for Chaco, Trinity determined that these practices were already in place, and so no further analysis was needed. Then for the remaining control technologies, Trinity conducted a literature review, determined which controls could be retrofitted to Chaco Unit 14, and determined that SCR and LEC required further evaluation. Similar to Blanco, the determination for SCR was that there was no space available, rendering it impossible to install. And then for LEC, Trinity determined in the four-factor analysis, I should say Trinity and Enterprise, that LEC was actually already being operated at Chaco Unit 14, and therefore nothing further was needed. And then lastly, for South Carlsbad Compressor Station, again, original submittal in November of 2019, evaluated a number of control options for units 1 and 2, good combustion practices, so low NOx, or again, we could just call that DLN, water and steam injection, and SCR. Again, good combustion practices, it was determined that these were already in place. We explained in the four-factor analysis that the particular type of unit being operated in South Carlsbad cannot support steam injection or water injection, and that those controls were therefore not technically feasible for South Carlsbad. Again, the space constraint exists at South Carlsbad for SCR the same as it does at Blanco and Chaco, excuse me. We conducted a cost effectiveness assessment for DLN or solo NOx and determined that it was economically infeasible at South Carlsbad.
Thank you, Mr. Jewell. Did you also provide pre-filed rebuttal testimony in this proceeding?
I did.
And do you have any amendments, updates, or changes to make to that rebuttal testimony?
No.
Mm-hmm. All right. Could you please discuss the portion of your rebuttal testimony that responds to Mr. Peters' testimony regarding the regional haze rules 65-year deadline?
Yes, so Mr. Peters states that the 1999 regional haze rule sets a 65-year deadline to restore protected areas to natural visibility conditions. He goes on to say that I'll point out that the Clean Air Act itself provides the ultimate binding standard, which is that states must develop SIP provisions, including, quote, such emission limitations, schedules of compliance, and other measures as may be necessary to make reasonable progress toward meeting the national goal, end quote. That's from 42 USC 7491B2. The national goal, the question was begged, what is that? The national goal is, quote, the prevention of any future and the remedying of any existing impairment of visibility in mandatory Class 1 federal areas, which impairment results from man-made air pollution. So achieving that goal by 2064 is actually a non-binding aspect of the regulations. It's used for, as I said earlier, for analytical purposes.
Could you also discuss Mr. Peters' testimony regarding NMED's responsibility to address reasonable progress?
Yes, his testimony appears to acknowledge the importance of visibility considerations, but his testimony does not address NMED's decision to exclude consideration of visibility when determining which sources would be evaluated, and more so, which sources would be required to install emissions controls under the SIP.
And could you address now the portion of Mr. Peters' testimony that discusses the goal of NMED in implementing the Clean Air Act's regional haze provisions with respect to existing units?
Yes. So Mr. Peters' testimony states that the goal of NMED was to quote, is to install control equipment on these existing units when the benefits to society of these pollution reductions outweigh the cost of these those control measures, end quote. And I would say this goal is not consistent with the goal of the Clean Air Act Regional Haze Program. The Regional Haze Program is not a technology forcing program like many other Clean Air Act programs are. It has a balanced approach that seeks to gain reasonable progress towards a goal that, when set, was more than 60 years into the future over, I believe, 6 different implementation planning periods.
Could you also discuss the portion of Mr. Peters' testimony that described visibility considerations?
Yeah, I would simply say again that NMED appears to concede that visibility is an important consideration when making determinations under the Regional Haze Program, what the testimony says to me.
And could you discuss the portion of Mr. Peters' testimony explaining the deciview standard for defining visibility impairment?
Yes, so Mr. Peters explains the deciview standard for defining visibility impairment. He explains that it's designed to capture changes in visibility that are perceptible to the human eye. And although the testimony suggests that perceptibility of visibility impairment and or improvements from potential or control requirements are relevant considerations, the SIP nor the testimony seems to take these issues into account when actually making control determinations.
Would you discuss Mr. Peters' testimony regarding which sources are targeted for analysis of achievable emission reductions?
Yeah, so the testimony states, again, quote, monitoring and modeling are used to determine which compounds with human sources cause the most visibility reduction so that those sources can be targeted for analysis of achievable reductions, end quote. And I would say this is true. However, again, NMED did not present any monitoring or modeling analysis or any other kind of information that it used to target sources for analysis of achievable reductions.
Turning now to Mr. Jones's testimony, would you please discuss the portion of his testimony that describes how NMED identifies the chemicals that cause or contribute to visibility impairment?
Yeah, so it starts by explaining that an assessment of visibility conditions in Class 1 areas is a part of the process for identifying the chemical species or pollutants that cause or contribute to visibility impairment. And then it goes on to establish that ammonium sulfate is the primary driver of visibility impairment at the New Mexico Class 1 areas of interest on the most impaired days. But then it goes on to what I would say conflate the effects of ammonium nitrate and ammonium sulfate. Another quote the combined ammonium sulfate and ammonium nitrate contribution to light extinction makes up approximately half of the total contribution to all sites. That's fine, but that does not provide a reasonable basis on which to assess whether NOx by itself is significant or appropriate for addressing the reasonable progress provisions of the Clean Air Act. Also, I would say that the role of ammonium nitrate and the size of the NOx emission reductions that would result from the second planning period SIP cannot be expected to have we simply don't have proof that the assumption made by NMED that these NOx emission reductions will result in Class 1 area visibility impairment improvement. We don't have proof that that's true.
And would you please discuss the portion of Mr. Jones's testimony that summarized the available visibility related data and information?
Yes, so he provides a summary of a variety of visibility related data and information. He recounts the nature and the purpose of the Improve IMPROVE Visibility Monitoring Network. He discusses how NMED, along with all the other states, calculate baseline, current, and natural visibility conditions for each Class 1 area, how they calculate the progress to date in each Class 1 area, and the uniform rate of progress, which we discussed. He also notes that all New Mexico improved monitor sites have showed improvement in visibility conditions from the baseline period to the interim period, and from the interim period to the current period, for both the most impaired days and the clearest days. But again, the testimony does not explain how NMED took this information into account when developing the control requirements of the SIP. The testimony also does not suggest that the consideration of the URP factored into NMED's decision to require controls in any way.
And would you please discuss the portion of Mr. Jones' testimony that discusses the 80% inclusion threshold that NMED relied on for its source screening threshold?
Yeah, so I started to refer to this earlier. So the Jones testimony states that the source screening threshold of 5.6 and the 80% inclusion threshold that NMED relied on to establish that threshold are supported not only by the draft EPA guidance that was never finalized, but also he refers to an Oregon SIP revision for the second planning period. But Mr. Jones's testimony does not demonstrate how the methods used in Oregon are reasonable for New Mexico. It does not mention that Oregon applied that threshold in a much different way than did New Mexico. So for example, Oregon used permitted emissions rather than actual emissions in its source selection process. Most, if not all, other state agencies for which EPA has approved SIPs used actual emissions, making Oregon an extreme anomaly in this case. Another example is Idaho, a SIP on which EPA has recently acted. March 24th, 2025, EPA proposed to approve Idaho's SIP. That SIP, that SIP screened, it used some unique approaches. For example, Idaho screened out a facility that emits NOx because ammonium nitrates were not the dominant visibility impairment pollutant at the nearest Class 1 area. Additionally, interestingly, Idaho used a program of trading or averaging of emissions across more than one facility. So the point of my rebuttal here is that Idaho and Oregon sort of form the spectrum of the types of SIPs that EPA has found approvable, even though they are quite different from each other.
Turning to Mr. Miller's testimony now, could you please discuss how Mr. Miller describes the department's consideration of visibility?
Yes, so he begins his testimony by stating the governing statutory standard, which is in establishing their long-term strategies for regional haze, States are required, after considering the 4 factors listed in the regulation, or excuse me, in the Act, to determine the emission reduction measures that are necessary to make reasonable progress toward meeting the national visibility goal, again, in the Act. Mr. Miller states later in his testimony that states determine the emission reduction measures that are necessary to make reasonable progress towards meeting the national visibility goal. Because NMED has based its decisions to address visibility in its regional haze SIP based on the non-binding guidance, that does not alter the underlying legal requirements applicable from the Act that was quoted by Mr. Miller that refers to the visibility goal. I hope that made sense.
What did Mr. Miller say about why the department did not perform photochemical grid modeling to support its visibility analysis?
Yeah, so in summary, it said that the department did not have resources to perform photochemical grid modeling, or PGM.
Has EPA ever performed a reasonable progress analysis for a state?
Yes, it has. Actually, in the first planning period, EPA stepped in Arkansas and said that BART wasn't enough, and it did a reasonable progress analysis in that case for one other unit, and it actually did photochemical grid modeling in that instance.
Finally, could you please discuss Mr. Miller's testimony that describes the way in which NMED calculated CETD?
Yeah, so this goes back to the binning analysis again, and I think I'll just make one more point, especially in the additional figure provided in Mr. Miller's testimony that was not in the SIP. It certainly appears to me that the bin 2 reductions look much more like the bin 3 and bin 4 reductions, which NMED excluded, than it does look like the bin 1 reductions. And so my question would be, well, my statement would be that the testimony does not discuss whether bin 1 reductions alone might have been sufficient for reaching reasonable progress.
Thank you, Mr. Jewell. In Mr. Jones's rebuttal testimony and in his testimony yesterday, he claims that you erred in several ways, including that you misquoted EPA's 2019 guidance, that you critically mischaracterized NMED's source selection approach with respect to NMED's focus on dominant pollutants, and that you incorrectly used the key term visibility impairment, conflating it with visibility extinction. Would you like to respond to these assertions?
I'm sorry, could you just repeat the question again?
Yeah, and it was compound, so let me break it apart. In Mr. Jones's rebuttal testimony and his testimony yesterday, he claims that you erred by misquoting EPA's 2019 guidance. Is that true?
No, actually, in what he was referring to in my testimony, I wasn't quoting the guidance at all. I was trying to summarize it.
He also claimed that you critically mischaracterize the source selection approach that NMED used to focus on dominant pollutants. Would you agree with that?
No, I wouldn't.
And he also says you incorrectly used the key term visibility impairment, conflating it with visibility extinction. Would you agree with that?
I recognize the terms and the statement, but the testimony actually didn't explain how I did that, and I don't recognize how I did.
Does Mr. Jones's rebuttal testimony that the inclusion of NOx in the source selection analysis was necessary contradict your arguments regarding NOx controls?
I would say no, because I've actually not argued that NOx should not be excluded in the source selection analysis. Jones claims that the inclusion of NOx in the source selection analysis was necessary because, quote, the combined amount of NOx and SO2 for all of New Mexico's major Title V facilities exceeded 50,000 tons per year, end quote. My testimony, on the other hand, is that without a demonstration, it's not appropriate to assume reductions in NOx emissions will result in visibility impairment, and certainly not at the same rate as SO2 reductions in the Class 1 areas at issue. NMED's own analysis, albeit very limited, implies that this is not true. NMED identifies ammonia sulfate as the primary driver of light extinction at all the New Mexico Class 1 areas of interest on the most impaired days. This despite the fact that NOx emissions are actually more than 3 times larger than SO2 emissions. Therefore, SO2 must be more effective at generating visibility impairment than NOx.
Mr. Jewell, I'm just going to ask you a clarifying question on your answer just then. You said it is not appropriate to assume reductions in NOx emissions will result in visibility impairment. Did you mean visibility improvement?
I did. Thank you.
Mr. Jones's.
I'm sorry, Ms. Wood. I thought you were wrapping up because you said finally a little bit ago.
Oh,
we really do need a short break.
Of course.
All right. Are you close to finished?
We probably have another maybe 15, 20 minutes.
Oh. Okay. Okay. Let's just take a 10-minute break then.
Okay.
Okay. This is Felicia Orth, the hearing officer. I'm just checking at the end of a very short break here at the end of the day, if there's anyone on the platform present to offer public comment. Please raise your virtual hand or say something in the chat. Pam? Anybody? No. Okay. Thank you. We will then do our best to get through the very end of the technical case before we break today. So everybody, thank you for hanging in there. Ms. Wood and Mr. Jewell, please.
Mr. Jewell, Mr. Jones's rebuttal testimony presents a case study example for the Mesa Verde National Park Class 1 area to demonstrate the importance of addressing NOx. Is this a good example?
I would say no, for the simple fact that it buries the lead. There's nothing presented in the case study about ammonium sulfate and SO2 emissions, despite the fact that NMED has recognized ammonium sulfate as the primary driver of light extinction at all the Class 1 areas at issue.
Mr. Jones's rebuttal testimony says that, quote, some operators claim that NOx emissions are inconsequential for regional haze purposes, close quote. Did you make that claim?
No, I have not made that claim. My testimony is that we do not have evidence to tell us the significance of NOx emissions for the purposes of Class 1 areas in New Mexico.
Mr. Jones's rebuttal testimony discusses NMED's analyses for the Salt Creek Wilderness area and claims that your testimony, quote, incorrectly states NMED did not use visibility impacts when developing the revised proposed SIP, close quote, and that it also, quote, egregiously mischaracterizes NMED's robust demonstration. And another quote is that it falsely suggests that NMED is not considering visibility. And then it implies that NMED is not proposing any additional control measures or emission reductions in the area of influence of Salt Creek Wilderness area, and quote, twists facts. Would you like to respond to this?
Yes, I would. I would say that none of this accurately reflects my testimony. In my testimony, I attempted to briefly summarize NMED's robust determination, that's a term of art, for the Salt Creek Wilderness area. As explained in the draft SIP, NMED was required to complete this robust determination because Salt Creek is unique among the Class 1 areas evaluated by the department. It is the only one that's projected to be above the Uniform Rate of Progress glide path in 2028. And then to take these claims one at a time, my testimony did not say that NMED did not use visibility impacts when developing the revised proposed SIP. Rather, it said NMED stated that it did not consider the visibility benefits of potential control measures when making control determinations. This is nearly an exact quote of the statement made by NMED 17 times in its draft SIP. That exact quote is, NMED did not consider visibility impacts when making reasonable progress control determinations. Moreover, Mr. Jones misquotes my testimony. I did not say that NMED's robust demonstration does not require additional controls for Salt Creek Wilderness area. I said, rather, the draft SIP also contains NMED's robust determination that additional controls are not needed to address visibility in Salt Creek. By additional, I was referring to controls beyond those determined to be required through the 4-factor analysis process completed by the department. In that way, I used the word in the same way that NMED did. In their quote, while these additional facilities/sources were not considered to be necessary for reasonable progress, and the same way that EPA has used it.
With regard to NMED's analyses for the Salt Creek Wilderness area, do you recall what Mr. Jones said yesterday was the issue at that area?
Yes, I believe I recalled that he testified that the issue at Salt Creek is a large cumulative problem of ammonium nitrate that comes from oil and gas sources in the Permian Basin.
And do you recall how NMED representatives testified yesterday in response to questions from me about the impact of NMED's ozone precursor rule on this cumulative problem in the Permian Basin?
Yes, they testified that emission reductions from the ozone precursor rule, which they referred to as Part 50, were taken into account in the draft SIP only to the extent that stakeholders provided information on how they were being regulated under that Part 50 rule.
Is this an appropriate way to account for emissions reductions that will result from the ozone precursor rule?
It seems to me that it's not. The ozone precursor rule, I've looked at it a little. It was finalized in May of 2021, well before the NMED released the draft regional haze SIP. In a fact sheet issued by the department at that time, NMED stated that it anticipated that the rule would result in a reduction of NOx emissions of 23,148 tons per year. NMED in that fact sheet further stated that the Part 50 rule would create, quote, create clearer visibility for our skies. These anticipated emission reductions exceed the emission reductions expected by the draft SIP, regional haze SIP. As a result, it seems to me that the department should have taken these emission reductions into account when developing the SIP, because including these reductions in the modeling and analysis used to develop the SIP might have shown that no further controls were needed to address reasonable progress for the second planning period.
Mr. Jones's rebuttal testimony claims that you said, quote, NMED used an improperly low Q/D threshold of 5.6. Is this correct?
I don't believe I said that. My testimony is that the Q/D threshold of 5.6 was unreasonably based on an obsolete goal of capturing 80% of the total NOx and SO2 emissions from all Title V facilities in the state. Again, this guidance from EPA was never finalized. EPA did not adopt that 80% threshold in the guidance it did finalize.
Mr. Jones's rebuttal testimony claims a statement you made about the BART guidelines recommending a Q over D threshold of 10 is inaccurate, and he further claims that the quote BART guidelines do not recommend or include a Q over D threshold of 10. In fact, the final guidelines do not mention Q over D at all, close quote. What is your response to this?
So I agree that Q over D is not explicitly mentioned in the BART guidelines, but the concept of Q over D and the threshold of 10 is clearly implied in the BART guidelines. Here's a brief quote from those guidelines. Based on our analyses, this is EPA speaking, we believe that a state that has established 0.5 decibels as a contribution threshold could reasonably exempt from the BART review process sources that emit less than 500 tons per year of NOx or SO2. That would be a Q over D of 10. As long as these sources are located more than 50 kilometers from any class 1 area, and sources that emit less than 1,000 tons per year of NOx or SO2, or combined NOx and SO2 that are located more than 100 kilometers from any class 1 area. So I misspoke earlier. So 500 over 50, 1,000 over 100 from that quote, that is a Q over D of 10. So it's clearly implied in the BART guidelines.
Mr. Jones's rebuttal testimony claims that your assertion about Q over D thresholds of greater than 5.6 that were adopted by other states is, quote, not supported by a closer examination of other state SIPs, close quote, and he provides several examples. Would you like to respond?
Yes, interestingly, the first 2 examples that he gives are actually listed in my 8 examples that I give in my testimony. Those would be Wyoming, Wisconsin, Arizona, South Dakota, North Dakota, Hawaii, Washington, and Colorado. I gave those as examples of states that used a Q over D of 10 or greater. And then to deal with a couple of specific examples that he mentions. So South Dakota's source selection process is really not comparable at all because it consisted of a great many steps, not simply a Q over D analysis. It started with a Q over D analysis, and it started with a threshold of 10. Noting that that threshold is what is being used by most RAP states. But at that threshold, South Dakota only screened in 1 source. So then it considered a Q over D of threshold of 2 in order to quote that an large number of sources would be identified. And 1 additional source was screened in at a Q over D threshold of 2. So now South Dakota evaluated 2 total sources. They then supplemented their Q over D analysis with a weighted emissions potential, or WEP, also called an area of influence, or AOI analysis, that uses what I mentioned before, the model called high split. Still, even after this 3rd effort that South Dakota employed, only 2 South Dakota sources were selected for 4-factor analysis. It's also noteworthy that South Dakota SIP, as drafted, requires no controls on either of those 2 sources.
I'm sorry, Mr. Joel. Sir. Okay, so we can't extend that at all. Okay, thank you very much. Ms. Wood? I didn't want to interrupt his answer, but some of us, including our court reporter, actually need to pack up.
Okay, that's fine.
To get out.
Would you like for him just to finish this answer to this question and then we can go?
Oh, I thought he was done. I'm sorry.
I was going to address 3 other states that were mentioned in the testimony.
Can address those 3 states tomorrow morning, or we can address them now.
So
up to you.
I think, yeah.
Let's address them tomorrow morning.
Thank you. Very sorry. We have to come back in the morning. It will be short. So thank you all very much. See you tomorrow.